Mormon Standard Time. I'm still 2 minutes early. I can't actually blame Mormon Standard Time today because I can blame KFAR. He's here early, and BB early. It's your guys' fault, or it's really just my fault for, overestimating how soon I could be ready to get on here. So sorry about that. I hope you all had a wonderful long weekend. And for those of you who aren't in the US, I hope you had a wonderful long weekend away from me. Um, so, yeah, we are, as usual, here for the Karen Reed trial. All Karen Reed, all the time. We're on day 18, and yeah. So, Kova, good to see you. I I understand. It's a lot to watch. It's a commitment. It's a commitment. Um, and Neil, you know it. Except, like I said, it's KFAR time today. It's his fault. But I hope that Scotland is treating you well today. And let's keep going. Vince, good to see you as well. And Kevin, that was a good thought, but nope, I was just slow today. Just slow. And I certainly wouldn't be 30 minutes into my monologue only 5 minutes late. It's um that's not how I work. That's not how I work. And see, Brandon, it's you and KFAR and BB. It's you. It's you, not me, it's you. Um and let's see. Uh, exactly. That's after spending all day yesterday with my very Mormon family, I feel it's my duty. Um, JT Davis, good to see you. And let's see, Pat's Cats, hello. 3 cents, hello. And Neil, once again, not engaged in this trial. I hope the post office trial has been exciting this week. I haven't paid any attention whatsoever to that. Just your brief updates. So yeah, scroll through Luna Nights. I have a feeling we're going to get started with extreme craziness because we are still on the cross-examination of Brian Higgins. So yeah. And let's see, I believe I am caught up on chat. So, just give a few more minutes of my 30-minute monologue, if I can talk. So I continue to be amazed. Well, scratch that. I'll get to that. But so I know I said I've been generally avoiding media, so that I'm not influenced. But I couldn't help myself last night, and I did watch Yellow Cottage Tales interviewing attorney Kevin Mahoney from Boston, who, he's a very experienced criminal defense attorney, and he's I won't say he's anti Karen Reed. He just sees the case the way it's going, and he agrees with me that Jackson and Yannetti could be facing very serious consequences for their conduct, for their, at the very least, tacit approval of witness tampering, witness harassment, and their in-court behavior has been very problematic. But he brought up an interesting point, which I've noticed. I haven't brought it up because I don't know that due to information overload, I think my brain just didn't fully process it. But he brought up a really good point, Mahoney, that Jackson, as abrasive as he is, as conspiratorial as he is, that's part of his brilliance, is he's able to take very mundane things and make them seem conspiratorial. You know, the big example Mahoney used was all the times he asked the party goers. So when Trooper Proctor was interviewing you at the Albert home, he wasn't taking notes, was he? As if that's some abnormal, conspiratorial, suspicious thing, when the reality is most troopers aren't taking notes in that situation unless there's something they really do need to write down, because, you know, why take notes if that's going to have to be handed over to the defense? Trooper Proctor's brain doesn't have to be handed over to the defense. He's going to have to testify, be cross-examined by the defense, but he doesn't have to give his brain to the defense. He probably does have to give his notes to the defense. So it's actually very normal behavior, but the jury doesn't know that. And so Jackson, even though it's nothing, Jackson, oh, so you didn't do this, you know? Oh, you tied your shoes yesterday? Interesting. And it's, I would hope that when we finally hear from Trooper Proctor, DA Lawley asks him, so you didn't take notes in these meetings, did you? No. Is it your normal practice to take notes in these types of meetings? No. So you wouldn't consider it suspicious in any investigation not taking notes? No. And hopefully he does that with Trooper Proctor, and, you know, it helps clean some stuff up. But, and that's it. The judge has admonished him over and over, including in front of the jury. Most of the time in front of the jury, it's Mr. Jackson. We've discussed that at bench, but, you know, it's just, and that's it. I've also said that it's not the defense I'd do, because unless you have a clear culprit that you actually do believe there's evidence for a third-party culprit defense, number one, it's a scumbag move to try to ruin someone else's life. But number two, I don't think it's the most effective defense. It's, you know, going back to Attorney Mahoney, I liked his suggestion that, you know, first thing he'd do is he would have put Karen to a forensic psychiatrist to discuss the I hit him, and then get on the stand and be like, well, yeah, she wasn't saying that to mean consciousness of guilt. It was the extreme shock causes people to talk nonsense in the heat of the moment. And, you know, that might actually be better than, oh, so firefighter McLaughlin, you went hot tubbing in Maine, didn't you? to try and counter the I did it, which, if you can counter, fine, but explaining it away with a forensic psychiatrist might be the best option. And Pat's Cats, I did not eat bologna, I ate bratwurst. So, different sausage. And how many times has Turtle Boy been absolutely right in all of his analysis? I mean, not at all, but, per sources. If he's on the Commonwealth's witness list, they can call him. Turtle Boy's sources are in the Karen Reed camp. Prosecutor Lawley isn't telling Turtle Boy anything. And I know you know that, Darcy. I know you know that. But I'm just... Yeah. And the thing is, JT Davis, circumstantial evidence is often the best evidence. It's a far too common TV trope of, oh, you don't have any real evidence, it's just circumstantial, and you can build an entire case and get a conviction on circumstantial evidence. It's often circumstantial is better than eyewitness because circumstantial evidence doesn't have a faulty memory. So, but moving on back to the point I was originally going to make, I'm still amazed, still getting same nonsense comments that, oh, you're the world's worst lawyer. You're a biased hack. You don't know anything. Got a few on the last video. You should stick to finance. You're clearly not cut out for the law. And it's like, the Utah Supreme Court would beg to differ. They've given me express permission to practice law in all state courts in the state of Utah. The federal court, once I pay the $30 annual fee again, I've got permission to practice in the federal district court in Utah. Hypothetically, when all the civil cases start flying in the Karen Reed case, hypothetically, I could pro hoc vice to represent the O'Keefes in the wrongful death case. I wouldn't because I don't know that it would be expressly unethical, but it would be unethical to me. I think I have a conflict having covered this case on YouTube. So, whether the bar agrees or not, to me, it's unethical. Therefore, I wouldn't touch it. And, it's just, I don't get it when I keep saying the same thing. I keep saying nothing's been proved yet. My vote at this point, if I were a juror, is not guilty because nothing has been proven. But let's wait until both sides have had their say, both sides have done their closing arguments, and the jury is out to deliberate to make our decisions. Because the only evidence that matters is the evidence presented in court. And so all these grand proclamations from Turtle Boy, who, from Brian Higgins is going to flip Turtle Boy, are meaningless. And so let's wait until the end. But somehow that makes me a biased hack. And the funny thing is, I have a feeling that the Free Karen Reed crowd is going to be chanting that same thing in a couple weeks. Because once the Commonwealth has presented all their evidence and rested their case in chief, a lot of people are going to be like, oh, yeah, she's guilty. But the Free Karen Reed crowd, and rightly so, is going to say, wait until the defense has presented its case in chief. And it's funny to me because that's the usual order of operations. Bad thing about spring is you never know if you need a jacket. But that's the normal order of operations in a trial. Is the prosecution finishes and the defense gets up. Well, frankly, they say it in opening arguments usually. Instead of Karen Reed was framed, their opening arguments will be, keep an open mind until you hear from both sides. The Commonwealth might present what you think is a compelling case, but just wait until you hear what we have to say. And they always say that. Yet in this trial, it's before the Commonwealth has even finished, before they've even started presenting their case. It's, oh, there's so much reasonable doubt that the judge should dismiss right now. It's ridiculous. If you don't see Karen Reed as innocent, you're biased and ridiculous and da da da. And it's normally it's the defense preaching, wait till the trial is over to make your decision. We're in bizarro world. But once again, for the smooth brain morons that keep saying the same thing, I'll say it again. Let's wait until the very end and then make up our minds. And you guys might, you might be surprised. I might at the very end say, my gut is still that Karen Reed did it. But Prosecutor Lawley hasn't proved his case, so I would vote not guilty. That's a very real possibility. Very real possibility. But, I might even say, yeah, I think he's proved it to clear and convincing or preponderance, but not reasonable doubt. But, yeah, it's just ridiculous to have your mind made up already before the case has started. So, and Brandon, how can circumstantial evidence meet beyond reasonable doubt? Well, the thing about circumstantial evidence is, finding the defendant's DNA under the fingernails. That's circumstantial. It's pretty compelling evidence, though. It's, oh, so the victim was probably fighting back and got a good scratch of the victim or of the defendant. That's circumstantial. DNA is highly technical, but it's generally circumstantial. That just, you put a trial is a puzzle. You put all the pieces together, and there could just be an overwhelming number of circumstantial pieces to that puzzle that you put it all together, and it puts together a reasonably clear picture. And the thing is, reasonable doubt doesn't mean all doubt. Using the puzzle analogy, let's say let's say the puzzle you're putting together is, what band am I wearing today? Sublime. Let's say you're putting together a puzzle of the Sublime Sun logo. Even if there are one or two pieces missing from that puzzle, you're still going to know to a reasonable certainty, frankly, that it's the Sublime logo based on 99% completeness. It's, so long as there's pieces for every element, you're going to see the complete picture, whether there's one or two pieces missing. And when I say one or two pieces missing, I don't mean, oh, well, they're for drunk driving, they're missing the part where the defendant was driving. Yeah, she was drunk, but that the prosecution hasn't shown she was driving. That's not a piece missing. That's half the puzzle missing. So it's just, circumstantial evidence can build a very compelling picture. So that being said, that's only a 21-minute and 45-second monologue, JT Davis. So let's jump to the trial. Like I said, we are day 18. We are still in the cross-examination of Brian Higgins, ATF agent Brian Higgins. I believe David Yannetti is taking over for Alan Jackson today. Jackson is back in LA. So David Yannetti taking over mid-cross of Brian Higgins. And Brandon, you're terrible. And then I actually don't know who the next witness is after Brian Higgins. It looks like there's a considerable break from court after Brian Higgins. We've got the blue title screen for a quite extended period of time, and it looked like court was still going live when I was getting set up. So that's considerably later than a half day. But yeah, so let's jump into it and see how Yannetti treats Higgins. Oh yeah, and no idea at all. Just I understand he's back in LA. Forgot we left off on the big bombshell with Brian Higgins on Friday that, and you're aware that it's illegal. It's a federal crime. It's a federal crime for you to have, extracted the text conversations from your phone to provide to law enforcement. And it's not. And I'm not under investigation. Was their big gotcha. And then there was also, and you destroyed your phone after the preservation order had been denied. So those were the big gotchas at the end. And BB and Scott Johnson, good to know. All I knew was there was the blue title screen as I was scrolling back through the timeline. So that didn't give me any context. So good to know. Thank you. So now we are definitely hitting play.
Jim, counsel.
So can I see a sidebar?
Of course, sidebar. Why do I try so hard to scroll to the exact moment only to know they're going to go straight to sidebar? But the thing is, Vince, I don't actually agree because
Versus Karen Reed. Can I have counsel identify themselves?
Because he's providing information to law enforcement. You know, he's a law enforcement agent using law enforcement resources to provide information to law enforcement. Even though that's as a witness in a non-federal case, it's still law enforcement purposes. It's not for personal gain. As Attorney Mahoney pointed out, once again, going back to yesterday's video, it's there was a better CFR, can't remember what it was, but basically it's illegal to use federal resources for, you know, unauthorized purposes or whatever. I can't remember. I don't care. But that still wouldn't have counted. It still wouldn't have applied, but it would have been more applicable. It's just Jackson wanted to say, oh, so you used it for personal gain. Personal gain. Even though, what's the personal gain in providing information off of your phone to law enforcement? It's the argument is ridiculous one way or another, but choosing the other statute is slightly less ridiculous. It's just Jackson wants to inflame with ridiculous questions. So,
For the record.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Morning, Ms. McLaughlin.
Good morning, Your Honor. Elizabeth Little.
Good morning, Ms. Little.
Good morning, Your Honor. David Giannetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, jurors. Before
You are unmuted.
I just want to mention that Attorney Jackson is not here today. Please don't consider that in any way. Certainly don't hold it against Ms. Reed for him not being there. Just don't consider it at all in your deliberations.
I didn't hear. Well, I did Miss Little give her appearance before Yannetti? Because I missed. I only heard Yannetti for Karen Reed.
So I do have to ask you those three questions. Are you all able to follow my instructions and refrain from discussing this case with anyone? Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on?
Yes.
Everyone said thank you very much. All right, let's bring Mr. Higgins
Oh,
in,
wait.
please. And Mr. Yannetti, you'll be
jury.
taking over?
I will, Your Honor.
Okay.
Well, all right. Well, nope. Little is there today, and buckle up for Yannetti. Ugh. I guess. No.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case having answered the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good morning.
Proceed, Your Honor.
Yes.
Sir, you provided to investigators what you claim were the complete text exchanges between yourself and Karen Reed and yourself and John O'Keefe, correct?
What I provided was I let them know that it was a complete exchange between myself and the defendant. And I said that I may have had other text strings at other times with Mr. O'Keefe.
I'm going to proceed to ask you a series of questions which call for a yes or no answer. Can we agree that you'll answer yes or no
No.
to those questions?
No.
If I can answer yes or no to the best of my ability, I will.
All right, I'm going to keep the question very simple, sir. Okay?
I would say no. Once again, I don't have to answer the way you want me to answer. I have to answer the truth.
You did not provide to investigators any other text messages between you
And once again, his phone was not subpoenaed. His phone was not subject to a warrant. He provided the text strings voluntarily. So him providing information voluntarily that he was not legally obligated to do, the defense is spinning as, it's suspicious. It's suspicious that, you didn't provide your entire phone, even though you didn't have to. It's suspicious. Karen Reed fought to keep her phone from being searched. She fought the search warrant for her phone. She wouldn't hand over the passcode when her phone was seized. But these people who are not criminal defendants, it's suspicious that they didn't give the defense free access to their entire phone. That's what's suspicious. That's what's suspicious.
anyone else.
That's correct.
In September of 2022, you were served with a preservation order for your phone, were you not?
Yes.
After September of 2022, you never received anything in writing that canceled or lifted that preservation order, correct?
That's correct.
After September of 2022, you made the decision to dispose of your phone without consulting anybody about the decision to throw out your phone, correct?
Yes.
Before you threw the phone away, you did a factory reset of it, did you not?
No, I did not.
Well, you previously testified that you testified in another proceeding on June 1st, correct, of 2023?
Yes.
Prior to that June 1st testimony, you met with some people and gave a statement on May 5th of 2023, did you not?
I did meet with them. I don't know if that was the date.
Okay. It was prior to June, correct?
Yes.
All right. May 5th doesn't sound wildly inaccurate, does it?
No.
And when you met with those people on or about May 5th, we'll say, or whatever date it was prior to June 1st of 2023, you told them that you did a factory reset of your phone ending in 5421. Did you not?
I don't recall that. No, I don't recall making that statement.
You don't recall what you said about the factory reset during that interview, we'll call it, in May of 2023, correct?
That's correct.
May I approach, Your Honor?
Yes.
And once again, he never received written confirmation. Well, he very well could have just been phoned by Lolly saying, yeah, it was denied, or Trooper Proctor, or whoever. It doesn't have to be written. Might have been, once again, I haven't seen the preservation order. It might have had an expiration. Like, literally, the preservation order might have said, you are ordered to preserve this evidence, the phone. This order is in effect for 30 days. If it is not, granted permanence, or if, it expires after 30 days if you don't receive further notice. And so it could be, once again, I don't know. This is just hypothetical. It could be he didn't receive a written notification that it had been denied, but he just, this order expired. It had a 30-day expiration or whatever. But once again, he could have received a phone call. He could have, non-written. He could have met with Lolly in person, and Lolly said, yeah, go ahead, get rid of it. I don't know. But it's not suspicious if he knew there was no preservation order, if he knew it had been denied. No matter how he found out, it's not suspicious that he got rid of it. Hopefully, Lolly brings that up on redirect. So you found out that it was denied on this date? Yes. By this method? Yes. So you didn't get rid of your phone while there was a pending preservation order? No. Not suspicious.
Directing your attention to the first highlighted line there, sir.
Why don't you give him a second?
If you read that silently to yourself and look up at me when you're done.
It's a long time for one line.
My approach.
Yes.
Having read that document, sir, just
I think that's actually why he didn't just read the one line. Certainly looked like he was reading at least a paragraph so that he had the full context. He might not be able to give the full context to the jury, but if you read more, refresh more, you can give a better answer than, the gotcha. Oh, you just read the one line I wanted you to.
does that refresh your memory about telling those people in May of 2023 that you did do a factory reset of your phone?
That's not accurate. I did not tell them that. And I also didn't tell them that I saved texts with my father.
All right, so your testimony is that they got it wrong, correct?
My testimony is I didn't make those statements.
Your testimony is
My testimony isn't that they got it wrong. My testimony is that you are feeding me bullshit. I don't know what this is from. I don't know that that's the actual transcript. All I know is you have something that's wrong, is what I would say.
that they got it wrong, yes or no?
Objection.
Sustained.
Well, in any case, you took the SIM card out of your
Argumentative.
phone, correct?
No, what I testified to was that it's,
Did you take the SIM card out of your phone, yes or no?
Fuck
I
you.
don't know.
Did you testify that that's what you do when you get rid of phones, sir?
What I said was that might have been the extent of it if I was to have done that.
It's pretty normal to take the SIM card out of your phone when you get a new phone. I mean, of course, when I get a new phone, it's generally I take the SIM card and the new one, but I still take it out of the old phone. Why keep a SIM card in an old phone? It's not suspicious. It's not one bit suspicious. Why?
And you either cut up the SIM card or ripped it up, correct?
I believe what I testified to was
I'm
I
not
would have.
asking you what
Fuck
you testified
you.
to. I'm asking you today, did you either cut?
Fuck you, fuck you, fuck you. He does not have to answer yes, no. He's answering your question. You don't like the way he's answering your question, but he's answering your question, so don't interrupt him, jackass.
Cut up the SIM card or rip it up?
Cut it up or broke it.
And you will agree with me that cutting up or breaking the SIM card destroys the SIM card, does it not?
The card itself, yes.
That would have been the purpose in terms of cutting it up or ripping it up, to destroy it, correct?
Well, so nobody else could use the phone.
Well, that was my next question. But,
In another phone.
But the purpose of cutting up or ripping up with the SIM card is to destroy the SIM card, is it not?
Yes.
And you wanted to make sure that somebody couldn't put that SIM card in their phone and potentially access your data, correct?
No, that wouldn't be the reason why.
Okay. Well,
You don't need the SIM card in your phone to access the data on the phone. That's not how it works. I mean, as I've said, you can store very, very, very limited information on your SIM card, to my understanding. Like, you can save a few contacts on it. The SIM card isn't where your texts are stored. It's not where your photos are stored. That's on the phone. That's on the phone. You're taking the SIM card out doesn't make it so people can't access the data on your phone. Once again, these jackasses are taking absolute nonsense and trying to spin it as suspicious. They're taking their inability to understand technology and making it suspicious. The Lolly, frankly, needs to object or clean it up on cross. It's, you know, it's just ridiculous.
We already talked about the fact that you testified under oath on June 1st of 2023, correct?
Yes,
And you were under oath when you were testifying on June 1st of 2023, correct?
yes,
You swore to tell the truth.
yes,
You raised your right hand.
that's correct.
And June of 2023, June 1st of 2023 was about a year ago, correct?
Yes,
It was
No, Kevin. Much as I dislike Yannetti, I dislike Jackson more.
about a year closer to your throwing your phone away, correct?
yes,
And in that testimony that you gave in June 1st of 2023, did you say the following, quote, I made sure that somebody couldn't put it in their phone?
yes, I did say that.
Because them putting it in their phone wouldn't give them data. What it would do is it would make it so they could make calls and text using that SIM card, assuming it's not deactivated, and basically give a bullshit record. Create bullshit data saying, oh, look, you were texting all this gobbledygook after you changed your number. It's like, well, someone must have taken my old SIM card and put it in a different phone. And Pat's Cats, I think basically that's what Yannetti is counting on from the jury. So the difference between a SIM card and an SD card is a SIM card is what you put in your phone to basically connect it to service. It's what your telephone number is attached to, your Wi-Fi or your wireless signal. And once again, I'm a lawyer, not a tech expert, so this is my understanding. I might not be getting it exactly right, but it basically, it's the unique chip that makes your phone unique to the cell company. An SD card, on the other hand, is a memory card. It's like your USB thumb drive or a floppy disk or something, where, except it's, you know, the different shape. It's the little itty bitty square with the, well, rectangle with the cut corner. Looks kind of similar to a SIM card, but it's memory. And so, like, on my phone, I have a micro SD card in it that has my music on it. And I have moved that from phone to phone as well, just, you know, because it's where I have my music. But you'll have the slightly bigger SD cards usually that go in your digital cameras. They, you know, so yeah. And Brandon, the tech expert, your SIM card is what your carrier uses to assign service to your device. Basically, it's the decryption code. So there you go. That's kind of what I was trying to explain. Brandon, the tech expert, said it better. And the only thing a SIM card stores is data pertinent to your account, including contacts and your phone number, but no data. So a hardware dongle, it's yeah. So, and I don't know that it's even an option on my phone anymore. And Kevin, haha, dongle. But on old phones, when I'd add a contact, it would ask me save to phone or SIM card. And it didn't really matter to me which, because, but I think that was back with flip phones. On this, it's basically save to phone or save to Google. And it's like, well, most of the time I save it to Google just because that's where my email contacts are. And it's portable. It makes it automatic when I get a new phone to transfer. So, but let's keep going.
In fact, by either cutting up or ripping up your SIM card, you also knew that that SIM card couldn't be put back in your phone either, correct?
Yeah, I believe that would be correct.
And you'll agree with me that you took that destroyed SIM card and put it in a trash bag, did you not?
I believe it went in a trash bag, yes.
Well, you used a passive voice. It went in a trash bag. Did it fly out of your hand?
iPhones don't count, Brandon. They're barely technology because I don't understand them.
Unexpectedly into a trash bag, sir?
No, sir. It
And
would
that's objection argumentative. Fuck you.
have been disposed of with the phone.
No, I understand. But are you reluctant to say that you put it in a trash bag, sir?
Objection.
Can you answer that? Are you reluctant to say that?
No, Your Honor, I put it in a trash bag. Oh, with my
And
trash.
then you also took your phone, now without the SIM card, and you put that in the trash bag too, did you not?
Yes, sir.
Then
And
you drove to
that's it, Kfar. That's it. He's taking completely mundane things that he was legally allowed to do, not suspicious in the slightest, and twisting it as, oh, conspiracy. You did something ridiculous. You did something, how dare you? And Edwin, that's, hopefully you're right. Hopefully there's someone on the jury that understands SIM cards. He can't explain it now. I say they can't explain it now. But because they can't deliberate yet. But at deliberation, if someone's like, so about that SIM card, does anyone know anything? And someone's like, well, funny you ask, I'm a cellular technician and da-da-da. They can explain it. Now, let's say I'm put on a jury. They ask me, so why was that objection sustained? Even a month down the road at deliberation, I couldn't explain. Well, you see, that was hearsay because that's a legal determination, and I can't, it would be highly inappropriate for me to explain the law to the jury, even as a juror. It would just be way inappropriate. I'd know, but I couldn't tell them. But still, that's one of the reasons why lawyers are generally not put on juries. Another reason, frankly, from the prosecution side is we all know in a criminal trial, the standard of proof is reasonable doubt. Let's say for the normal juror, reasonable doubt is right here. For lawyers, it's higher in general, I think. And so, because lawyers being, somewhat argumentative and analytical and looking at cases are going to look at it like, so about that, I'm not convinced. And so, even though the standard is reasonable doubt, for lawyers as jurors, it might as well be all doubt, beyond all doubt, which is not the standard. So, yeah. And that's it. Jurors aren't stupid. Jurors are not corrupt. Jurors tend to take their job, even if they're unwilling to be there, don't want to be there. They take it seriously. They take the judge's admonishments seriously, to not research the case, to listen to, I mean, you do get the occasional juror nullification, but in general, jurors take it very seriously, and that's kind of the magic of the American justice system, is the jury. It's an adversarial system, and both sides get their say, and the jury, it might end up groupthink in the end, but to me, jurors don't always get it right. Well, scratch that. Jurors don't always get it factually right. Like O.J. Simpson. I'm 100% sure he killed Nicole Brown and Ron Goldman. And the jury got that one wrong. But generally, if they come to a different decision than what reality is, it's generally not malfeasance. It's generally not the jury is stupid. It's generally, well, we analyzed all the evidence, we discussed all the evidence, and we're just not convinced. Going back to the puzzle, we have the outline of the Sublime Sun logo. It very well could be the Sublime Sun logo, but it also might be the creepy sun from Teletubbies, and so we think you're on the right track, but we're unconvinced. So, and that's very possible. But in that case, what's her name? Was the prosecutor Marcia Clark? Should have struck some of those jurors. It's assuming she could, of course, because you can't strike them for race, but at the same time, if they are going to be biased, you can strike them for bias. And yeah. So, but let's keep going.
Military base, and you threw both the destroyed SIM card and the phone into a dumpster, did you not?
Well, I was cutting through the base, and I believe how I
Did you
testified
drive to
was
a military base, sir?
I was cutting through a base.
Fuck
Yes.
Did you drive to it?
Yes, sir.
And then you put both the destroyed SIM card and the phone itself which were in a trash bag, into a dumpster on that military base, did you not?
I believe that's what I did, yes.
And as you were driving away, you knew that that destroyed SIM card and the phone would be gone forever, correct?
Yes, I threw it away.
And before you drove away, you did not transfer anything from your old phone to the new phone, correct?
That's correct.
You lost all of your photos on that phone, did you not?
Whatever photos I had on there, I did, yes.
You lost all your videos on that phone, did you not?
To the extent if I had any.
You lost all of your other text messages besides the ones that you had with Karen Reed and John O'Keefe, correct?
That's correct.
Is anyone here sentimental about their old text messages? Once again, when I get a new phone, I think when I transfer to this phone, because I went through the official transfer process, I don't know if it was the Google stuff or if it was the Motorola. Like, I think I used a USB plugged into both this phone and my old phone, although it might have just been Wi-Fi and, put in a passcode. So I think text messages did transfer to this phone. Like photos, it's just the Google Drive. That's what they're on. But when I've upgraded from my old phone to my old phone, they didn't transfer. And Edwin, you're probably a serial killer. That's why you do that, right? I mean, I don't think it, but I'm sure Jackson and Yannetti would find that highly suspicious. Highly, highly suspicious. And that's like I said, I don't know how many. It might have just been the 30 days, but when I got this phone, I know I didn't have to transfer anything manually because it basically cloned my old phone. But that's because I used the automatic process. And as I've said, I don't throw out old electronics, but I also don't exchange them. I just keep them because I kind of don't trust others with my data. So I've got a stack of old laptops and phones that don't get any use, but they're also, relatively secure with me. I know where they are. And should we call you Mint Jelly, Edwin? I mean, I know we usually go with the South Park jokes, but Simpsons did it first. So call me Mint Jelly because I'm on the lam. God, Grandpa Simpson's a great character. So good. And that's it. Like I said, I get the relatively cheap Motorola's off of Amazon because I'm an Android person. I don't like Apple in general. The old school iPods were good. Still use an old school iPod when I mow the lawn. But I like Samsung. They're just more expensive than Motorola. And like I said, Motorola has their system that if you get a new Motorola phone, it'll automatically transfer everything from one Motorola to the next. And, it was real easy. Of course, as I've said, I have my music on the SD card and just pop that into the SD slot and my music's transferred. So, yeah. Yeah.
You did have text messages on that old phone with Kevin Albert.
He's a friend, most likely.
You also had text messages on your phone with Nicole Albert.
Most
Which-
likely, yes.
Is not suspicious. It's not suspicious. He's spinning it as suspicious, but it's not suspicious. If it was suspicious, the prosecution would have subpoenaed it. They would have had a warrant before it was thrown out. The prosecution didn't ask for it. It's not suspicious.
And you had text messages on your phone with Brian Albert.
Yes.
It was important to you that no one see those text exchanges that you had with those three members of the Albert family.
Objection.
I'll let him have it.
No, sir, that's not true.
You took no steps to preserve those text messages, did you?
That's correct.
You did not ask your friend Matt Kelch, the agent, to help you extract those text messages, did you?
That's correct.
And when you went to that machine, you did not extract them yourself, did you?
He walked me through it. I did do the extraction.
You did not extract the three strands of text messages with Nicole Albert, Kevin Albert, and Brian Albert to preserve from that machine, did you not?
No, I did not extract those.
So the only place you knew they existed was on your old phone, correct?
Yes, that's correct.
The same phone that you put into a dumpster on a military base with a SIM card removed from the phone and destroyed, correct?
Well, I did throw the SIM card and the phone on the military base.
Right, and the SIM card was destroyed. You've already testified to
I
that.
said to the extent of if I did that, I would have done that.
And we're talking about the actual phone that would have had your text messages, again, with Brian, Nicole, and Kevin Albert, correct?
Yes, because the motion was denied.
Well, you've already testified, sir, earlier that you never received anything in writing that either canceled or lifted the initial preservation order, correct?
That is correct.
Yet he knew it was denied. It's almost like writing isn't the only form of communication.
You knew when you were throwing that phone and the destroyed SIM card in the dumpster that from that day forward, no one would ever be able to access the content of what you and Brian Albert had discussed by text messages on your old phone, correct?
Anybody.
I have nothing further.
Mr. Lally?
Thank you, Your Honor.
I mean, once again, I don't think the defense made any legitimate points about the phone on cross. But they took a lot of nothing and tried to frame it as suspicious. So hopefully Lolly's able to take that and push back on direct. So you never received written, notice that it was denied. No. Were you ever notified that it was denied? Yes. And how is that? I was called. I was, my lawyer was informed. Whatever. It self-destructed after 30 days. There are the butt dials. Drunk people butt dial. Yeah. So, he's sitting at the table because he just finished cross. So, yeah. Lolly's about to get started on redirect.
Morning, sir.
Good morning, sir.
If I could take you back just for a moment to January 29th, early in the morning, you're pulling away from the Albert home, correct?
Yes.
You had Plow down in front of your Jeep Wrangler, is that correct?
Initially, it was still on the ground. Yes.
About how long distance again was that on the ground before you pulled that up?
Maybe a foot.
And with relation to the curb, specifically in front of the area with the flagpole and fire hydrant, how close to the curb were you when you were pulling away from the Albert house?
believe I looked both ways. There was no vehicles coming in either direction. I pulled out into traffic, and because that's a one-lane road, if there's no other vehicles, I'd be more to the center of that road.
Now, maybe a silly question, but with reference to the
And one lane, not one way. Residential streets are often wide enough for 1.5 cars. That's actually a intentional design to slow down traffic on residential streets. So
front of your Jeep Wrangler, that didn't have any red plastic pieces or anything like that on front of it, correct?
At what time? At what point?
At any time?
No.
So no taillights on the front of his Jeep. So you wouldn't have embedded taillight on the Jeep. In fact, I'm pretty sure every single state, it's illegal for a civilian car to have a red lens on the front of their car. They're restricted to the rear of the car, or, the rear side, basically, because you can have the slight wraparound on taillights. But you can't have a red reflector or a red light on the front side of your car. Illegal. You can have amber, you can have white. Generally, and once again, that's for civilians. Police can have red on the front of their car because, police lights. But, yeah, so no red glass, no red plastic produced by the snowplow. So Brian Higgins hitting John O'Keefe with the snowplow from the front wouldn't deposit red plastic on John O'Keefe.
And that's the same Jeep Wrangler that you then drove to the Canton Police Station immediately after?
Directly from there, yes.
And then you drove that same Jeep Wrangler back to your home in West Roxbury?
Yes.
And then you drove that same Jeep Wrangler back to Fairview Road later on that morning?
Yes.
And then you drove that same Jeep Wrangler from Fairview Road to the Canton Police Station again later that morning, correct?
Yes.
Now, the text communications between yourself and Ms. Reed, again, who initiated those?
The defendant did.
And that was on January 12th, 2022, correct?
About 8:23 in the evening, I believe.
And one thing I've noticed about Brian Higgins is he really avoids calling her Miss Reed or Karen. It's the defendant.
Now, with reference to that, what she claimed happened in Aruba, that was something that she mentioned to you via text, correct?
The incident itself, I believe, was through text, but I believe the actual location was when she had stopped by my place in West Roxbury.
So that's to my point. So, sir, with regard to the incident itself, she referenced that both via text and in person to you as well.
Yes, that's correct.
And the kiss that she planted on you in the garage at Mr. O'Keefe's house, that was again something that she mentioned both in text and verbally in person. Is that correct?
Yes, that's correct.
Now, as far as the ghosting that you were asked questions about last Friday, there were some text messages between you and the defendant on January 19th, correct?
What was the date? I'm sorry.
January 19th.
19th?
Yes.
Yes.
And do you recall if there were any text messages between you going either way, between yourself and the defendant between January 19th and January 23rd?
Kevin, I would have thought that was impossible. I would have thought that was impossible. I mean, of course, the relationship drama in Fleetwood Mac led to Rumors, which, amazing album. This relationship drama, unfortunately, did not lead to Rumors. Although maybe the band at the Waterfall that night has, recorded an amazing album that is pending release. Maybe they got that secondhand relationship drama to feed into an amazing album. And frankly, it's your fault, Kevin, that I'm chasing this squirrel right now. I want you to know that. But so the album that I judge all other albums on is Rubber Soul by the Beatles. It's not the best album. It's an amazing album. I don't put it as the best album. I do have it as my favorite Beatles album. The reason I use it as the comparison, as the baseline, is because, frankly, it was my introduction to music. When I was, we'll say, 9 years old, my dad brought home the cassette to Rubber Soul. And for the next several months, that was our soundtrack in the family car. Until a few months later, he brought home the cassette for Abbey Road. Then we alternated. And I mean, he had all of these on vinyl, pretty much all the Beatles albums, at least the US Beatles albums, are out there on vinyl. In addition to Zeppelin, Floyd, The Doors, Rolling Stones, we've got pretty much everything you need. But because Rubber Soul has had such an impact on me, it's what I compare all music to ever since. That was relationship drama. That was Paul McCartney navigating either his very recent breakup or his pending breakup with Jane Asher. And that went into so many of the songs on Rubber Soul. I'm Looking Through You. Wait, I believe. For one of my favorite albums, you'd think I could think of all the songs off the top of my head, but putting myself on the spot. But so many songs on that album were about Jane Asher and the relationship troubles. And I absolutely agree with you there, Edwin. The Peter Green era was the best era of Fleetwood Mac. But lots of the great Led Zeppelin songs were about that. 10 Years Gone, Robert Plant wrote that about a woman that dumped him 10 years before. And basically she had given him an ultimatum. It's me or it's music. He chose music. And he wrote 10 Years Gone basically as a what if. The song Thank You, Jimmy Page got in a fight with his wife, and he wrote a love song to her. Frankly, Eric Clapton's best songs were all about George Harrison's wife. And George Harrison, some of his best songs were about the same woman. Of course, he was happily married to her at the time. So it's just, while Rumors is the ultimate breakup album, there's just so many great ones. But enough of that. We've caught the squirrel. Let's keep going.
I think there were, not 100%.
Madam Mayor Pro?
Yes.
I'm going to show you what's been.
I think, Grey Duck, the key distinction there is modern digital recording. Like I think early CDs, not so much. There were compressions and clips, and it didn't work as well. The media player Neil Young tried to introduce, frankly, is probably the best, but it's also inaccessible. But there is a magic, there is a soul to vinyl. And there is a certain magic to recording on an old 4-track. It took skill. Even an 8-track console, it took skill. And so there is a magic to it. Modern recording, I mean, my opinion is that Cher ruined music in 1998, because before her song Believe, auto-tune was a dirty secret that no one dared speak aloud. She made it into a god-awful art form. I absolutely hate the auto-tune wobble. But it suddenly became okay for talentless people to use auto-tune to have music careers. And it really does take away, like, there's magic in that, little gravel, that little rasp in the voice, the waver. Whereas you take the auto-tune and you just put a flat line basically right at the note, and it's technically perfect, but it doesn't sound as good because it doesn't sound as human. So, yeah.
Marked as Exhibit 104A. Direct your attention back there, specifically the back page. If you could just let me know whether or not there are any text messages between yourself and the defendant, Ms. Reed, between January 19th and January 23rd.
I grew up with vinyl because my dad has it.
Yes, looks like the 19th and the 23rd, both text messages.
But in between those dates, and what I'm asking about is January 20th, January 21st, January 22nd. There's no text messages on any of those dates, correct?
I don't see any.
And then as far as between January 23rd and January 28th, January 28th is when you texted her while you were both within the waterfall, correct?
On the 28th, yes.
So between the 23rd and the 28th, so on January 24th, January 25th, January 26th, January 27th, you didn't send any text messages to her, you didn't receive any from her, correct?
I don't believe so, no.
And then beyond that one text message that you testified to on the 28th, the next text message you received from the defendant was in regard to John being dead on the 29th, correct?
Yes, that's correct.
You're asking questions about these text messages and whether or not you discussed them with various people. Did you discuss those text messages with anyone?
Not to my knowledge, no.
Why not, sir?
To be honest with you, I mean,
They're embarrassing.
On a personal level, I kind of keep things to myself. I was a little embarrassed.
Hey, they're embarrassing. He didn't want the world to discover his pathetic game. And I mean, I'm not going to criticize him on that because, as I've said, I have no game. But he also, flirting with his friend's girlfriend. That's embarrassing. You don't want that coming out. It's not suspicious. It's not suspicious not volunteering your entire phone. Because, yeah. And I don't know Dr. Hook. Shore music. I mentioned, I still use the old school iPod mowing the lawn. To me, it gets meditative and tends to be on the louder side of rock mowing the lawn, though.
Wasn't really proud of him. Kind of maybe didn't show me in a good light with respects that I was John's friend.
And so with regard to that text on January 28th that you had sent her in the waterfall, she didn't respond as she was in the waterfall with her boyfriend, Mr. O'Keefe, correct?
That's correct.
Now, if the defendant did not have a boyfriend, wasn't dating Mr. O'Keefe, would you have been interested in pursuing anything further with the defendant?
I can't say. I don't know.
What, if any, reservations would you have based on the conversation that you had?
Just everything was so
I can end that one very quickly, Kevin. Can't stand them. Done.
out of left field. I just found it hard to believe.
With reference to going to the Camden Police Station after Fairview Road and moving the vehicles around, which is
I just associate Captain Beefheart with Frank Zappa since they collaborated.
closer to the Camden Police Station? Your home in West Roxbury or the home on Fairview Road?
The home on Fairview Road would be.
And with the impending weather, why was it that you went to the Camden Police Station to move the vehicles around on that occasion?
Because as I stated before, if I didn't do it then, I would have had to come back in the morning. And I knew the weather was going to be getting worse. I knew that I had a long day. I had been in New York. I had been out the night before in New York, and I just thought it was best to get them moved at that point.
Now, you were asked some questions on Friday about a phone call or something in a call log from about 2 o'clock or 2:22 in the morning of January 29th. Do you recall that?
I recall the questions, yes.
And you have an iPhone, or you had an iPhone, is that correct?
Yes.
Now, when you make a call on an iPhone, as you sort of place that call, you hit the button, there's sort of a timer that comes up and it starts counting off seconds as the call is being connected, correct?
I believe so.
Okay.
I'll allow it.
And so seconds are ticking off while the call is being connected, correct?
I believe so, yes.
And if a call is connected, then it starts ringing, and unless someone picks up immediately, there are further seconds that are ticking off on an iPhone while that call is ringing through, correct?
I believe so.
The objection sustained is to the phone.
Leading.
You were asked some questions about a call or a call back between yourself and Brian Albert around that time frame. Do you recall that?
Yes.
And you were trying to explain sort of what your answers were in that prior proceeding in reference to, correct?
Yes.
What, if anything else, did you want to explain to the jury in regard to that? Okay.
In that form, I'll sustain.
Calls for narrative. It's vague.
You were asked some specific points as far as your testimony in the prior proceeding, correct?
Yes.
What, if anything else, would you say in reference to that in the prior proceeding? Okay.
Sustained is to the phone.
Vague.
Did you ever speak with Brian Albert at 2:22 in the morning on January 29th?
No, I did not.
Do you recall making a call or receiving a call from Brian Albert around that time?
No, I do not.
You were asked some questions on Friday regarding key card access within the Camden Police Station, correct?
Yes.
Now, as far as that door that you utilized, you would testify on Friday that you would sort of park down towards the back and then come into the Sallyport area, is that correct?
So I believe I was referring to one of the two Sallyport doors.
And that was sort of your cut through in order to get to your office.
Yes.
Now, with reference to that particular area, as far as going in and out from the parking lot of the Sallyport, does the key card, you have to swipe the key card in order to go in and to go out?
So sometimes if you're close to the door, maybe having a conversation with somebody, it could activate the key card itself. But physically, if I'm going into the door, I would take it out and I would swipe it. I would hold it to the card reader. Some are more sensitive than others, is what I'm trying to say.
And similar to when you're going in, when you're going out, does that require sort of swiping or using the key card in order to go outside?
So there are some doors that you need to swipe out of, and I believe the booking room and the Sallyport itself are doors such as those.
May I approach?
Yes.
And, some, they're not, they're only locked from the outside. So you only need the key card to access. Whereas, you know, you it just has the push bar on the inside where you push it open. Whereas from the outside, it doesn't have the latch mechanism. You just have to swipe the key card. Some, if you don't swipe out, they won't let you swipe in because it says, no, this person's already in the building. They didn't swipe out, therefore they are in. Therefore, this person swiping isn't them. Like, and it's not just secure buildings. My mom worked in an office building. Her parking key card, so that you couldn't, you know, swipe in, go park, walk out, hand the card to the next person, have them swipe in. You had to swipe in and then swipe out. Otherwise, it wouldn't let you swipe in again. How do I know that? Because one time my mom had foot surgery, so I was driving her to work and picking her up. And the guy at the parking booth, the attendant, he let us in once. He raised the gate without me swiping. So going out, it wouldn't let me out. He had to. So it's not just police stations. It's not just secure buildings. It's, you know, sometimes you have to swipe both ways.
I'll show you a document of place on for now. If you could just take a look at that when you finish. You recognize that, sir?
Yes,
That's the same document that was essentially the same document that was placed before you on Friday.
yes,
And that's a 167-page document encapsulating different key swipes within Canton Police Station on January 29, 2022, correct?
yes,
And from those 167 pages, at least on that first page, does there appear to be about 27 entries there?
yes,
And so,
Once again, it was the defense that put this 167 pages in front of him. Why did they put 167 pages in front of him? To make him look suspicious to the jury. 167 times 27 per page, on average, we'll say. That's a whole lot of swipes. He might have what, 20? He might have less than one of those 167 pages attributed to him. But they slap that 167 pages down in front of him, the defense, and the jury sees that and they're like, holy shit, that's a lot of swipes. He must have been busy. Busy, busy, busy. Ow. Oh. At least it was about the new girlfriend. The Karen Reed vibes. Or wait, sorry. I misread that. I thought a wedding barbecue. So never mind. Just the same. I'm glad it was about a new girlfriend and not a new wife. Was the point I was going to make, but I misread that. But ow. Karen Reed vibes. That. Oh. And yeah, jumbled chronologically, just like the defense does everything. If they can, they've jumbled the key swipes. They've jumbled the text messages. Because they're timey-wimey, wibbly-wobbly. The defense tries to jump back and forth temporally to confuse the jury. Lolly is trying to go in a linear manner, which I get it. That's not for everyone. I appreciate it. It's easier to follow. I assume it's easier for the jury to follow as well.
So from 27 entries over a course of 167 pages, that'd be somewhere north of 4,500 entries within those 167 pages. Does that sound right?
Well, I went to public high school, but I'll take the word for it.
Would it surprise you that there are 18 entries within those 4,500?
So not what would surprise him. Ask the question differently, Mr. Howard.
You know that there are 18 entries that contain your name within those records.
Objection. Formal question.
So when I said 20 or even one page, 27, I was being generous to the defense. Of those 4,500 entries, you account for 18 of them. So you really weren't a busy beaver that day.
No, I'll allow that.
Are you asking me if in the 167 pages, there's only 18 entries with me?
Yes.
I did not know that, no.
Would that surprise you as far as your, well, let me rephrase that. Now, with respect to your,
Except they have, kind of. They're doing clumps in chronological order. And you know, starting with the rescue from the first responders, they did that in chronological order. The McAlberts, they did that group in chronological order. And so that's it. They're doing it by theme, but each theme is chronological. So, you know, each act is chronological. So,
travels around Canton Police Station on that particular day, would you quarrel with 18 entries as far as where you went and what you did in Canton PD that day?
No, in and out, nope.
Now, sir, with respect to your phone, you were provided notification in regard to a preservation order in regard to your phone sometime in September of 2022, correct?
I received a subpoena on September 30th, 2022.
And that was in regard to a hearing in which counsel for the defendant was seeking your physical phone as evidence, correct?
Yes.
And is it your understanding, or were you informed after that date, sometime in early October of 2022, that that motion had been denied?
So I believe it was October 21st of that year, I was made aware that that was denied on actually October 5th.
Are you aware of a 30-day period by which a defendant has to file some sort of notice of appeal of a motion? Objection.
I'll allow that.
I know typically there's appeal periods. In this particular sense, I wasn't familiar with the preservation order itself. What a preservation order was with respects to, that was kind of all new to me. Usually in an investigation that I'm conducting, it's a search warrant, I take the phone. I don't ask people to preserve it through a court order, if that makes sense.
And so when was it that you disposed of your phone?
and that's it. He's used to the prosecution side, the investigator side, not the defense side. That makes sense.
It was about 2 months after that,
And why was it that you disposed of the phone?
because it was beaten, it was broken up, and I had already had a new phone, and this only explanation is I threw it away. That's it.
Now, beyond sort of this case, what, if anything else, was going on with reference to your personal phone that led you to want to get rid of it?
So in July of 2022, I had a target of an investigation I was working who alleged that he called me on my personal cell phone. And when I questioned him as to the fact how he obtained my personal telephone number, he told me that his girlfriend had obtained it off of open source internet, which I later confirmed that that number was out there.
What, if any, concerns did that raise for you, sir?
So basically, that explains why he didn't just get a new phone and transfer the SIM card. Like I mentioned, that's what I usually do. He got a new SIM card because he wanted a new phone number so that this crazy person couldn't contact him. I think I've mentioned before, you know, during my internship with the U.S. Attorney's Office here in Salt Lake City. So they had just opened the new federal courthouse in Salt Lake. I'm talking, it had been days that the new courthouse was open. But day one, there was a shooting in the courthouse. A Tongan Crip defendant attacked a witness testifying against him, and the court security shot and killed the defendant. It's on YouTube. It's, you know, you can look it up. I was going to do a video when the defendant lunged at the Vegas judge a couple months ago and say, yeah, he got off easy. It could have gone like it did here in the Salt Lake Federal Courthouse. But literally day one. And so they held office-wide meetings and trainings for everyone at the U.S. Attorney's Office. So interns went too. And part of that was logistics of the new courthouse. You know, the first people to have hearings there, because most of the assistant U.S. attorneys had not yet had a hearing at the new courthouse. So it was, yeah, these are the issues we saw. I think I mentioned last week, you know, one of the issues was the witness rooms weren't properly soundproofed. They could hear testimony. That was a problem. Another problem was the architect didn't take into account that, you know, traditionally the prosecution sits at the left side of the courtroom and the defense at the right. Of course, that's assuming the courtroom is big enough. You know, in the Karen Reed case, it's a tiny one, so it's prosecution in front, defense in back. But the problem was the door to bring in custody defendants into the courtroom wasn't always on the right side. Sometimes it was on the left, and the U.S. attorneys are like, we need to train the court staff that when they bring the defendants in, they don't walk them behind us. If we're in a courtroom where the door is on the left, they have to walk them in front of us for security. Or we just need to say convention be damned and claim the prosecution table as the one opposite the secure door. But because they were talking about security, and especially courthouse security, they were all, you know, on a heightened alertness due to the shooting. They held trainings on how to basically get yourself off the internet. They're like, if you have social media, here's how to make your Facebook a ghost profile so that your friends can see you, but you're blank to everyone else. You don't show up. You have to find your friends. They can't find you. This is how you force the white pages, the telephone book, to unlist you. You know, they held a training for everyone at the U.S. Attorney's Office, but specifically the assistant U.S. attorneys, saying, you want to disappear. You do not want the crazies you're prosecuting to be able to find you. Now, Brian Higgins is not an assistant U.S. attorney, obviously. I mean, in the U.S. Attorney's Office, we constantly had FBI agents in and out all day long because they're federal law enforcement. I was in the white collar division, so we had IRS special agents, armed special agents, because, IRS armed special agents, they are law enforcement, constantly in and out in the white collar division. In the violent crime division, I'm sure they had ATF agents all the time, in and out. And I'm sure the FBI holds that same training. I'm sure the ATF holds that same training. I'm sure federal judges receive that same training. And not just federal judges, state judges, state prosecutors, everyone. Because you're dealing with crazies. You're dealing with violent criminals. And you don't want your face out there. You don't want your contact information out there. So for Brian Higgins to change his phone number is not suspicious. His phone number getting out is what's suspicious. The target of his investigation being able to find his private personal phone number online is what's suspicious. Once that's out, him changing his phone number is entirely reasonable, and I'm sure the ATF, if they didn't advise him, they would have. And that's it, Sinclair Reed. Nephew in Special Forces, he wants to be a ghost. He wants to be a ghost. He needs to be a ghost. His operation could depend on him being a ghost. It just makes sense. It's good practices. I mean, it's good practices for all of us to take our online security seriously. But there are certain jobs where it's life and death. It really is. I mean, we've seen crazies show up at judges' houses and execute the entire family because the judge took their kids away. It's happened. I think it was a New York judge like 5 years ago. It was definitely that area, New York, Boston, Connecticut, New Jersey. It happens. Of course, family law to me is the most dangerous. Like, I'm on the record, I don't like guns. If I practiced family law because I'm kind of slow escaping, I probably would have a handgun at my desk just because that's dangerous. So, yeah.
Well, I had a lot of concerns. And so July of 22 is when I probably started thinking about, you know what, I got to get rid of the telephone number itself.
And a lot of the work that you were doing, at least at that time, was undercover work. Is that correct?
Before this case right here, yes.
Now, as far as the SIM card that you're talking about, do you have any specific memory of doing anything with that SIM card?
No, and that's how I testified in that other hearing, that to the extent of what I would have done is I would have cut it up or broke it. And the concern would be that to my understanding, that's not holding any photos, that's not holding videos, that's not holding my contacts, it's holding phone information itself.
As far as
And that's a pretty good explanation. It's holding phone information, like the functions of the phone, not the functions of the mini computer in your hand. So, well, and even sovereign citizens, there was that sovereign citizen at the Spokane courthouse like 10 years ago that he attacked it. He drove right up to the front doors and was killed, and there's video of all the smoke grenades going off, and so sovereign citizens have done it in the courthouse. Violence, I mean, not, yeah.
Photos or videos or what, if anything like that, did you even have on?
I didn't have much in the sense that I'm divorced. I don't have kids. I didn't have the typical memories that somebody would have had on their phone that they wanted to preserve. They were more like the text messages with the defendant, where it would be a drink glass at a bar, food, something along those lines. I had more of a connection to my work phone and more of a value to my work phone than I did my personal phone.
Now, as far as that military base down the Cape, how often, let me ask you this, when you lived at the residence in Barnstable County, what would you do with your trash down there?
Well, if I was going through and I had trash or some recycling, and I was either getting gas on the base or hitting the duty free, I would occasionally toss a bag of trash in one of the dumpsters there.
And being a military veteran, he has access to the base, maybe not full access anymore, but he has access to the base. He has access to the duty-free stores, the commissary, the base exchange, the, taxless gas.
Or if I forgot, I would throw it out when I got back to my other property. And at the time, at one point, I was living in Canton, and I had the house there, and then I sold it, and then I had the in-law I was renting, so I had other options to throw things away.
Do you have trash pickup at your residence in Barnstable?
No.
So if you were to throw away anything, any sort of trash,
So no trash pickup at his cabin, his house down the Cape. I mentioned, my family had the cabin up above Deer Valley, sold because there was no water. Still a dirt road when we sold, and now it's $30 million mansions all the way up that road. But no trash pickup. You take it in, you take it out, and it was a hour drive, little less. Once again, dirt road. It's less now, but to downtown Park City is 35 minutes. So, yeah, but you don't want stinking trash in your car the whole drive. If you have access to a dumpster where it's not illegal for you to dump, you get rid of it so that you're not driving with trash. Makes sense.
it would have to be either at the base or at one of your other homes.
It would be somewhere else.
And so with reference to the phone and the SIM card, if you even did you drive specifically to the base to throw your phone away, or were you throwing it away with other trash?
It was just with other trash.
You were shown some call logs or some toll records or something to that effect last Friday with respect to calls that you had made or received around January 29th, 2022. Is that correct?
Yes.
And was that anything that you had specifically preserved and given to the troopers, or that was something that someone was able to obtain even without your phone or without your SIM card, correct?
That's correct.
May I approach this to retrieve now?
Yes.
1 moment, Charlie.
Yes.
And those are illegal in lots of places in the West since wildfire. Idaho, some areas obviously get enough rain. It's weird to me that Boise gets only like 2/3 of the rain Salt Lake does, and we don't get much.
Sir, going back to January 29th, pulling away from the residence on Fairview Road, you didn't see anything on the side of the road, is that correct?
Absolutely not, no.
And what is it that you would have done had you seen anything, or had you seen Mr. O'Keefe on the side of the road on January 29th?
I've spent my whole life between being a firefighter, working in the profession that I work now, being a tactical medic. If I had saw John O'Keefe on the side of the road, I would have done something.
Karen's agitated. Oh. Lolly struck a nerve. Struck a nerve. Ooh. And Vince, that's why Chicago is clearly superior to New York City, because New York City, they just use the street. No need for dumpsters.
To make a difference.
No further questions.
Yes. Chairs, feel free to stand up and stretch.
We were promised that Brian Higgins would flip. Turtle Boy told us. Turtle Boy told us. If you can't believe Turtle Boy, who can you believe? Who can you? And yeah, you know, he thought she was hot. If he thinks I'm hot, why won't he flip? Why won't he help me get away with murder? That's what you do for hot people. Kevin, that's just gross. People are gross. I've driven off with stuff on the car before, but that wasn't intentional. And that's how I lost a whole bunch of CDs once. Although that was my friend that put my CDs on top of the car. So, yeah, that was annoying. But, oh, looks like we're getting a recross. Recross.
Sir, you testified that.
And once again, the scope gets narrower and narrower each time. On direct, the scope is extremely broad. Basically, it's all relevant, admissible evidence. On cross, it's generally anything on the topics of direct. Although sometimes they say, yeah, on cross, you can do other things as well, because that way you don't have to call them as your own witness. You know, just in the name of efficiency, sometimes the scope rule is relaxed depending on local rules. And when I say the scope might be limited on cross to what was covered on direct, impeachment is allowed on cross because that's kind of where you do it. So even if the subject matter of the impeachment wasn't brought up on direct, you can still do it on cross. That, you know, scope doesn't matter. A few other things, but redirect, you're limited to cleaning up cross. So scope is very limited. Recross, limited even further just to what was done on redirect. So yeah, pretty much.
A prime motivator of you to get rid of your phone was a July 22nd call from a target of an investigation that you were working on?
I never said it was a prime motivator.
Was it a prime motivator?
No, what I testified to was that the phone number was what I was concerned about primarily.
Right.
Didn't have anything to do with the phone.
The phone was because it was old and falling apart. You upgrade phones. The motivation for changing the phone number was the call of the subject of his investigation. Two separate things. Upgrading his phone, changing his number. Two separate things. He did them at the same time, but they're two separate things. Different motivations for each of those.
You did not change your phone number on July 22nd, correct?
July of 2022? Is that what you mean?
The date that you received a call, supposedly, from a target of an investigation you were working on was July 22nd.
Fuck you. Supposedly. Fuck you.
Of which year?
So it was, I believe it was July 25th to 2022.
July
I was so
25th.
concerned that I reported it to my supervisor.
Right, but you did not change your phone number after that for quite a while, correct?
I believe it was September.
So for those months, you kept the same phone number and kept the same phone, correct?
I did.
And September happened to be the month that you received the preservation order from this court, correct?
September of 22, yes.
Right. Now, with regard to the text exchanges that you had with Karen Reed, you testified that you were embarrassed about them.
Well, I wasn't proud of them.
I think your word was embarrassed, correct?
I can agree to that. That's fair.
Well, you already testified to that, right?
I believe that might have
5
been
minutes ago.
a word I used, yes.
And you also explained that you would keep things like that to yourself, correct?
That could be something, yes.
However, you would also agree with me that while they were going on, you told your boss about that text exchange, correct?
Well, I told her about the kiss.
Do you deny telling your boss about the texting that you were doing with Karen Reed?
I don't know if I specifically recall that, no.
But you don't deny it, sir, correct?
It's possible that I told her about that. I'm not going to deny it.
All right. And in any case, those texts.
That's because he's trying to make everything suspicious. And I mean, it's just like my Oma. I can have an argument with her where everything I say is, I agree with you, and she'll still argue. But here it's, yeah, I think that's what I said. But isn't this what you said and how you said it? Make it sound suspicious. It's trying to make it sound suspicious.
Exchanges were preserved. You preserved those before disposing of your phone, correct?
Correct.
And with regard
didn't
to the
have
other
to.
text exchanges that you did not preserve with the Alberts, including Brian Albert, are you familiar with the term consciousness of guilt, Mr. Higgins?
Fuck you.
The objection sustained.
Come everyone.
Yes.
That there's, first of all, that's beyond the scope. It's argumentative. It's calls for a legal conclusion. It's, you have no evidence that Brian Higgins did anything. You didn't evince anything that would have him having a consciousness of guilt. That question is wildly inappropriate. This is one of those where the judge, frankly, once she sustains the objection in this bench conference, should instruct the jury to disregard that last question because it is wildly inappropriate. And once again, he was not under no obligation to provide the text messages that he did.
Just one more
He
thing.
did
With
that
regard to
voluntarily.
The date that you changed phone numbers on your phone, you would agree with me that was September 29th of 2022?
When I actually changed the phone number?
That's what I just asked.
Yeah, yes, I also got a new phone, yes.
Okay. September 29th of 2022, you changed your phone number and got a new phone. And then September 30th, the next day, you were served with the preservation order, correct?
I got the preservation order on the 30th, that's correct.
Not the 30th.
All right, Mr. Higgins, you are all set, sir.
Thank you, Your Honor. Thank you.
And he didn't get rid of the phone until after the preservation
Mr. Riley, who's your
order
next
was
witness?
gone.
Sure.
It's more a matter of me slouching, Kevin. It's a matter of me slouching. So, as I said, it looks like we're getting the kids, which we won't fast forward until we hear from the judge. But we're getting the kids, I'm told. Therefore, we won't be shown the next witness. Which is good, as I've said.
Chris, we're going to take a 10-minute recess.
You are unmuted.
Oh,
All rise to the court, please.
well,
Follow me.
we'll wait until the jury's gone. She might instruct the court. I don't specifically know. BB says no. And frankly, that's true. It takes a long time for transcripts to come out. So we certainly won't before the end of the trial.
All right, so Mr. Lally, your next witness is a juvenile?
Yes, Your Honor.
All right, so there's a specific media order that there'll be no transmission of this testimony. Well, and by agreement of the parties, the child witness will be sitting in the courtroom, in the witness stand when the jury comes back in. And that's by agreement, Ms. Giannetti?
Yes, Your Honor.
Okay, all right, so 10 o'clock or so, we'll come back out?
Court, all rise. So you're just gonna end.
See, I disagree. I'm fully in favor of completely keeping the kids out of it. The kids shouldn't have any media attention at all. I mean, I don't think spectators should be kicked out of the court necessarily. But frankly, we don't have a right necessarily to broadcast of any kind from the courtroom. So, you know, I don't know if it's the niece and nephew testifying. Well, niece or nephew, I should say. They won't testify concurrently. Or if it's some other minor. I don't know. You know, is it Maya? Is it the McCabe's daughter, minor daughter? Is it the other friends? You know, the friend who went to try and fix the garage door and picked up the niece that morning. Or is it his daughter? I don't know. They just said minor. Either way, any minor should not be broadcast in any way, I don't think. And that's it. The children have rights. And often you heard the judge say, by agreement of the parties, the child will testify in court from the witness stand. Often what they'll do is, now that they have the technology for it, they'll have the minor testifying from a different location on video, the screen played in the courtroom, just in the courtroom, and the child sees the lawyer and the judge. It's a conversation. Because, and this is especially in exploitation of children cases, it keeps the child from having to look at their abuser. And that's good. That's a good one. That's a good one. And that, to me, once again, the Ronnie O'Neill case, wild. You know, it's a court by court decision, case by case, and it could be that his adopted parents, the police officer that adopted him, they agreed, yeah, his voice can be heard. It literally could be as simple as that. The guardian said yes. it could be, Florida's sunshine law is strong enough that they had to, because Florida is weird that way. But I don't know. And the kids, they're old enough that they're not only competent witnesses, but they're good witnesses. They're teens. You can have a 6-year-old testify. If they're the best eyewitness, you can have them testify. There is a lower limit, but the niece and nephew are considerably older than the lower limit. We won't have the transcripts, but a summary is online because media was in the courtroom taking notes by hand. And that's, the niece was a witness when Karen arrived, when she left, making the phone call to Jen McCabe, to Carrie Roberts. But they're also witnesses to the relationship, to Aruba, to, they, just like Paul and Darren O'Keefe, the brother and sister-in-law, they're witnesses about John and Karen together. So not just about that night, that morning. But this is, of course, a flaw in my plan. I've mentioned, my goal is to base my ultimate verdict on the in-court testimony. But I have to do that without a few witnesses. How key those witnesses are remains to be seen. But, so I actually might have to consume other media and look for a unbiased, factual summary. Obviously, I won't look at Turtle Boys or DUI guys or whatever. I want to see an unbiased summary. And if the transcripts are released, it will be months, and by then there will be plenty of other things to read. And let's see. Vince says, Larry Foreman's tweets are so silly today. That's the DUI guy. I'm not on Twitter, so I haven't seen them, but he's unfortunately been pretty silly in this whole trial, is my opinion. So, yeah, but that's it. I think children's rights are more important than my curiosity. BB said it extremely well. And the thing is, Pat, as I've said from the start, I do have a bias. I dislike Karen Read for the terror campaign. Even if she hasn't participated in it, she's sanctioned it by associating with Turtle Boy. And that's biased me. But not as to her guilt, just to her character. It plays no role whatsoever in my analysis about her guilt. So, yes, I'm biased. And I absolutely think she funded it. I absolutely think there's a reason Turtle Boy has gone from sleeping on a couch in his wife's basement, you know, his estranged wife, to driving a brand new Lexus. I think there's a reason that happened. You know, we've heard from Yellow Cottage Tales talking about, yeah, I was contacted by Turtle Boy last year saying Alan Jackson wants to talk to you, trying to recruit media, trying to recruit bloggers to put out their side of the story, their version of the story. And, you know, and frankly, I think being able to admit that, it, you know, puts you ahead of the game, Pat's Cats. Saying, yeah, I'm biased against her, but it doesn't, you know, I'm keeping an open mind about the evidence. If I'm convinced the other way, I'm convinced the other way. If I'm unconvinced of her guilt, I'm unconvinced about her guilt. I can't say that for the Free Karen Reed side. For them, every witness has been a lying criminal and just firmed up their belief, almost like they're watching a completely different trial than the rest of us. And it's like, tell me again who's biased? Those who proclaim from the rooftop from the start, she is factually innocent. This must be dismissed. The prosecution has barely started their case, but there's so much reasonable doubt that it must be dismissed. And it's like, tell me who's biased. Tell me who's biased. They'd have anybody that would hire me has a fool for a client. Well, anyone that would hire me wouldn't themselves have a client. So, frankly, your statement doesn't make any sense. If you're trying to say anyone who would hire me would be a fool of a client, because I'm saying what defense attorneys always say, wait until all the evidence is presented, then deliberate, then make up your mind. Because I keep saying that this case is wild in that morons keep saying when the case has just barely started, you know, one witness in, we must make up our minds right now. As I've said, defense attorneys are usually the ones preaching, don't make up your mind when the prosecution rests. Wait until you hear from us. But we have so many people saying, don't even wait until the prosecution has presented their evidence. She's clearly not guilty. We haven't seen the evidence ourselves, but she's clearly not guilty because the carefully curated evidence that we've been presented through Turtle Boy. So absolutely no reason to take it as reliable whatsoever. But that tells me she's innocent. It doesn't matter what the witnesses say. It doesn't matter what the prosecution has. It's what I have before the start of the trial. That's what matters. I'm missing something there. What I'm missing is all the evidence. And I mean, this is the first time I'm seeing you here. All the other people in the chat who have been here from the start can tell you, I've preached from the start. Let's wait until all the evidence comes in. Then let's make up our mind. Because what matters? What Turtle Boy has said or what the jury hears? What the jury hears is what the verdict is going to be based on. I mean, I was guaranteed that Brian Higgins was going to flip. He didn't. I was guaranteed that Colin Albert was a murderous, hardened thug. He was a goofy kid that, plays football, and I don't know that he's the sharpest tool in the shed. But that's the thing, Darren. That's exactly the point I'm making. The jury isn't making their decision based on Turtle Boy. They're not making their decision based on what Turtle Boy has said. They're making their decision based on what's presented in court. The Free Karen Reed crowd, on the other hand, has made up their decision before the trial even started based on what Turtle Boy has told them. So I didn't bring Turtle Boy into this. But he is a factor in the people saying Karen Reed is factually innocent. So as to the public discussion, as to the the so-called evidence that's out in public that hasn't been presented in court, it is him. Whereas he doesn't matter, assuming the jury hasn't been tainted. But only the evidence presented in court actually matters. Only the evidence that's been presented in court matters. And the thing is, you get to personally weigh how credible you think the witnesses are, just like the jury does, just like I do. And the thing is, witnesses don't have perfect memories. They're not machines. They're not SD cards, since we discussed those earlier. They aren't paying attention to the same thing all night. They were drunk. They perceive things a little different. So them being off by 5 or 10 minutes compared to others tells me they didn't rehearse. They didn't form the story and stick to it. They're testifying from their memory, faulty as it may be. And yeah, it's, we're what? Are we beginning week 4? Week 5 of a 8-week trial? There's a lot of evidence to be presented by both sides. So and Vince, that's a very good point. Although I could pro hoc into Illinois probably, but you'd have to pay me a lot of money to do that because, there's expenses to practice out of your jurisdiction. I mean, we've talked about, Karen Reed may have paid between the 3 attorneys $1 million for this trial just in legal fees. There's also hotel fees she's been paying. Jackson isn't paying his living expenses there in the Boston area out of his legal fees. It's an expense being paid by Karen Reed. And even though Yannetti is a Boston local, he's probably staying in the same hotel as Jackson Little as well. Because especially with a long, high-profile trial, you don't want to be commuting. Like a trial downtown Salt Lake, great. That's an easy drive. Trial in Park City, that's a 25-minute drive. I'm not risking the canyon for a long trial. I'd get a hotel room and the client would pay for it. Because there's one way up to Park City. I mean, technically there are a couple, but one you drive up the canyon, the others you drive around the mountains. And the I have friends, they've done week-long trials in Provo. They're based out of Salt Lake. Provo's a 40-minute drive. They stay in a hotel. The entire team stays in a hotel for the entire trial just to take that concern off the board. So, Karen's been paying for that. And we've discussed that as well, Darren. I keep saying, to me, it's Shakespearean. In Hamlet, there's the play within a play. This has been a trial within a trial. Although I realized last week that it was actually Lolly doing the Chewbacca defense, in effect. Because I kept saying, if I were defending Karen Reed, everyone else has heard me say this before, Darren, but I'm doing this for you. So I keep saying, if I were defending Karen Reed, I would be using the some Puerto Rican guy defense. Both that and the Chewbacca defense from South Park. So the some Puerto Rican guy defense, basically what I'd do is I'd say, well, yeah, of course John was hit by a car. It was some Puerto Rican guy. I don't know who did it. I wish you'd go find him. And to me, that's a lot easier to show to the jury than creating some grand conspiracy. Because, frankly, to me, it's hard to believe that a Boston cop is so dumb that his cover-up of a murder is to dump the body on his own front lawn. That's so colossally stupid to me that I just can't fathom it. Whereas the some Puerto Rican guy defense, well, yeah, someone hit him. Go find him. I wish you would. It just wasn't me. Is easy to sell. It's easy to sell. So that works. But instead, they're doing the conspiracy. Conspiracy. Can't forget the conspiracy jazz hands. So what Lolly has done is he's done the preemptive Chewbacca defense. It doesn't make sense. Although, as I've said, the Chewbacca defense doesn't make sense because Wookiees don't live on Endor. Ewoks do. The only Wookiee on Endor went for that specific mission. Because Wookiees are from Kashyyyk. But, I kept saying, it was Hamlet, play within a play, trial within a trial. He did the sub-trial first. So to me, Lolly spent the first couple weeks basically trying to disprove the conspiracy, to show it was none of the people that the defense is blaming. So they spent weeks showing it was not Jen McCabe as the mastermind. It was not Colin Albert. He wasn't there. It was not Brian Albert. It was not Chris Albert. He wasn't there. Carrie Roberts didn't even really know these people. So they spent the first couple weeks on the Chewbacca defense saying, this isn't it. The conspiracy is nonsense. And now, starting with Jen McCabe, and then Carrie Roberts, and Brian Higgins, the kids, he's finally into his actual case in chief. So he's finished with the let's disprove the conspiracy, although, you know, some of the witnesses going forward might still be part of that, but the focus has shifted. Now it's let's prove her guilt, as opposed to showing it wasn't all these other people. So is it, once again though, is that the way I would have done it? Not necessarily. Not necessarily. Because he might have lost the jury. That's a risk from the prosecution. He might have lost the jury. They, you know, they might have got bored. Why would you do it on recross though? If you know the defense's strategy, bring it on direct. And it wouldn't be recross anyway, because it would be direct or redirect. But I get what you're saying. But if you know what the defense is going to do, you bite the bullet first. You don't want the defense to be the ones to introduce something. You want to introduce it and show that it's not bad. You want to introduce it and show there's nothing nefarious. And sure, there's going to be things to clean up on redirect. But once again, I've said from the start, I liked the way that the prosecutors did the Darrell Brooks trial. There, they had the lead investigator start, very first witness for the prosecution. He laid out the case. He gave us a roadmap. He gave us the big picture story. Really good. Then we had all the individual witnesses. And then at the very end, the prosecution recalled the lead investigator to clean up loose ends. And I really liked the way they did that. Now here, once again, all this media, all this chatter, we've heard how Trooper Proctor, Trooper Proctor, Trooper Proctor. I don't know how good a witness he will or won't be. It's very possible that the prosecution wants to bury him in the middle. Get his information out there, but don't have him the first thing in the jury's memory. Don't have him the last in the jury's memory. Put him in the middle. That might be their strategy. I don't know. But once again, it's a risk, the order he went. But I also think he was building a foundation by trying to disprove the conspiracy first. He was building a foundation so that he can then build his case on a solid foundation. Because you don't build a house first and then put the foundation up once the house is washed away. And so I shouldn't say it. I'll just stick with yes, box for it. And that's it. That's exactly what I've been saying. Let's hear from the medical examiners. Let's hear from the automotive detective, the motor pool detective, just like we did in the Darrell Brooks trial. Let's hear them testify about what they did on the car. Let's hear from the medical examiner. Let's hear from the state crime lab. Let's hear from the lead investigator. Let's hear from the defense witnesses. Let's hear from their experts. Let's hear from the defense, competing medical examiner. And then let's make up our minds. Because that's the way the jury has to do it. So, and Luna Nights, once again, that's what I've been saying the entire time. As of right now, she has not been proven guilty of anything. I'm getting closer. I'm seeing the possibility of a motive, but I still haven't been shown she's the one that hit him. And she's innocent until proven guilty, as are all criminal defendants. Just because I don't like her doesn't mean I'm not presuming innocence. My gut instinct says she did it. Or at least says that she hit him. I don't know that it was intentional or not, but my gut says she hit him. But my gut is, not what I base my verdict on. And as I've said from the start, frankly, I have no skin in the game. I have no skin in the game. This is day 18. I've missed 2 days, so this is my 16th day streaming, and I've said all of this so many times. I don't like her. I don't like her. I judge people based on the company they keep. She keeps company with Turtle Boy, and I judge her for that. But at this point, that's all I'm judging her for. That's all I'm judging her for. And, as far as her guilt or innocence, I'm only going to judge on the evidence. And the thing is, I could be getting 100 times the views if I had no integrity and I said, oh yeah, free Karen Reed, free Karen Reed. But I'd rather call it the way I see it and get the views I get than, pander to the bigger crowd. I'm hoping by the end of the trial, all of the lawyers covering the case basically converge. Whether that's innocent or guilty, I don't know. But I would hope that once all of the evidence is presented, the lawyers pretty much meet in the middle and say, yeah, this is what the evidence has shown. I would hope. I don't know that that'll happen. Some I don't have much confidence in, frankly, and that's it. It's just my gut. If I'm wrong, I'm wrong. If I'm wrong, I'm wrong. And like I said, he is not in evidence. But that's why I keep bringing him up, is to make that exact point. that he's not in evidence. And so I keep bringing him up for that exact reason, to say that what he says is not evidence. What he says is not evidence. So it does not factor one iota into my ultimate verdict. Only the evidence in court matters. Only the evidence in court. Whereas, as I've said multiple times while you've been here, the free Karen Reed crowd who are shouting it from the rooftops have taken what Turtle Boy says as evidence. They have taken it as the truth of the case. And their minds are made up off of that. But let's go with what's presented in court. And with that said, let's fast forward, because I don't feel like debating all day. So we'll go right there. And I didn't mention you by name, but I did talk about you at the beginning of the stream. Are you a Utah State Bar examiner? Because if not, your opinion doesn't matter. You know, the Utah Supreme Court says I get to practice law. Where are you admitted to the bar? Which state are you admitted to the bar? Inquiring minds would like to know. Apparently, I didn't scroll quite far enough.
Step one.
May stand and face the clerk.
Raise your right hand. You solemnly swear the understanding of the court and jury the case out here to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you. Sit this down.
All right, Mr. Lally, whenever you're ready.
Thank you. Good afternoon, sir.
Hi.
Could you please state your name and spell your last name for the jury?
My name is Justin Rice, R-I-C-E. Is that what you asked me to spell?
And sir, that mic.
Okay. No idea who Justin Rice is, so this is completely new to me. Completely new to me. And I should also say, Darren Smith, I've intentionally avoided media coverage. I've intentionally avoided reading the pretrial rulings because I want my first impression, to the greatest extent possible, to be what's presented in court. So I know that Turtle Boy and others, I just use him as the mouthpiece of the Free Karen Reed movement, but I know that people are shouting things from the rooftop, but I'm intentionally avoiding hearing it so that I'm not influenced in any way, because I only want to go off of what's presented in court, how it's presented in court, how credible I find them, etc. So
In front of you, however you want to position that, it's flexible. So
Too far away. Is that better?
that's perfect. Thank you. And what do you do for work, sir?
I'm an emergency medicine physician.
And how long have you been doing that?
I finished my residency in 2008, so I've been attending since 2008.
And where is it that you work now?
My current employer is South Shore Health.
And how long have you been working for South Shore Health?
I started there in October of this past year, 2023.
And where did you work prior to that?
Before that, I had been full-time at Good Samaritan Hospital in Brockton.
And how long was it that you worked at Good Samaritan?
Let's see, I started at Good Samaritan in 2010.
Now, sir, if I could, I'd like to just talk a little bit about your educational background. Where did you go to school as far as your undergrad is concerned?
I went to undergraduate at the College of William and Mary in Williamsburg, Virginia.
And what, if any, degrees did you graduate from there?
All right. So we have a doctor. I don't know. Well, I think he said emergency medicine. So he was probably John's treating physician at Good Samaritan, not the medical examiner yet. But I agree, finally. And, oops, Gray Duck, nay. As far as button-down collars, they're for children. I use collar stays. So, yeah.
Obtained a bachelor's of science in chemistry.
And following your graduation from there, where did you go to school after that?
So after that, I attended University of Virginia for medical school.
My cousin's husband did as well. He's practices here in Utah, though, but he did his med school, University of Virginia. He's from Virginia, though, so.
You asked me, I'm sorry.
And following your graduation from medical school, where did you go after that?
Then I did an emergency medicine residency in Philadelphia at University of Pennsylvania.
And what is a residency?
So residency is there's several years of training that's where doctors will specialize. For me, in emergency medicine, some people choose to be surgeons, pediatricians. That's when more of the specialization, if you will, happens in medicine, medical training.
And how long was your residency?
It was 4 years.
And following your residency, where did you go from there?
So I, in 2008, finished residency. I worked for 2 years in Manassas, Virginia at Prince William Hospital for 2 years.
And are you board certified?
I am by American Board of Emergency Medicine, yes.
And what is it that you're board certified?
Specifically emergency medicine.
And when you use that term as far as board certification is concerned, what goes into that? What does that entail?
So when I obtained board certification, it was a two-step process where there was a written exam administered at one of the testing centers. And after you pass that.
Hey, she probably thinks he's hot, based on her type. He's hot and he's a doctor. No blue collar anymore. She's hit the big time.
Then there's an in-person oral exam, I guess is what they're called. And that's where you've given like didactic or individual cases. Assuming you pass that, then you're board certified.
And your board certification is up to date currently?
Yes.
Now, with reference to the time that you worked at Good Samaritan, as far as the emergency department is concerned, can you describe to the jury sort of what does the emergency department at Good Samaritan look like as far as staff, bedding, sort of layout, like describe that to the jury?
Sure. So at the time and currently, there's 36 treatment rooms in the main ER.
So at the moment, he's essentially qualifying him as an expert witness, but he's also a fact witness. So he's kind of dipping a toe into both worlds as a fact witness and expert.
A lot of hallway stretchers as well. There's also an express care kind of area, but for the purposes of this conversation, 36 beds in the main ER. Staffing wise, there'd be anywhere between 4 to 5 and 12 nurses. And for the purposes of this discussion, it would have been 2 docs on and probably one either nurse practitioner or physician assistant at that in the morning.
And as far as the morning I'm going to turn your attention to is the morning of January 29th, 2022. Were you working at Good Samaritan on that day?
If that's the morning of this incident, then yes. Yeah.
And is there a particular shift or what kind of hours would you be working around that time at Good Samaritan?
I'm pretty sure I started my shift at 6 a.m. that day. There was a 6 a.m. to 2 p.m. It was either 2 or 3 to, excuse me. It was either 6 to 2 or 6 to 3 p.m., but the shift would have started at 6 a.m. as I recall.
What? You were a resident and it wasn't a 36-hour shift? Oh. In my day.
And on that date at Good Samaritan, do you recall becoming involved with a treatment of a patient by the name of John O'Keefe?
Yes.
And, Your Honor, may I approach the witness?
Yes.
And obviously, there are exemptions to HIPAA, so he's able to testify about his treatment of John O'Keefe.
I'm showing you a document. If you could just take a look at that and look up.
You want me to look through each page or just acknowledge that?
Just as far as, do you recognize what that document is?
Yes, of course.
And what do you recognize that to be?
So it looks like is a transcription or a copy of the medical chart that I would have produced or dictated. And on the front page is also a, it's called like a code sheet, which the nurses would have put together and I would have signed off on, detailing what resuscitative efforts, as in the specific details and timing of the resuscitative efforts that were performed on Mr. O'Keefe's behalf.
Thank you. Your Honor, with the court's permission, may the witness hold on to that during the course of the testimony?
Yes.
And Your Honor, what I proceed to introduce in a minute is the next.
And once again, generally witnesses can't hold on to reports and stuff. He's basically an expert witness, qualified as an expert. He can testify from his report.
Next exhibit would be a redacted copy of those same records.
Is there any objection?
Your Honor, we can just review those.
Okay.
What issues do they have with the report? Like, it's a business record. You know, I believe they called it a code sheet. Basically, it's the report made in the ordinary course of business. So not hearsay or exempt from hearsay. Can't remember. There are some things that you'd otherwise think are hearsay that the rules of evidence say, yeah, these aren't hearsay. But there are other things that the rules say, well, yeah, these are hearsay, but they're exempt from the hearsay rules. And I can't remember, you know, records kept in the ordinary course of business, if they're not hearsay or hearsay exemptions. Should look that up. I should fast forward and then look it up.
Here you go, doctor. This is you.
Thanks.
That's my identification.
Okay, thank you. And Mr. Lally, I'll let.
And that's possible, but if it's kept, if it's, you know, produced in the ordinary course of business, and it's a summary of his records, that's possible. So it can get complicated. I don't actually know how a code sheet is produced. I just assume it's produced in the ordinary course of business. As I mentioned, you know, my cousin's husband is the doctor in the family. He's not an ER physician. He's family practice with a fellowship in obstetrics. He does a lot of paperwork, you know. he finishes his shift and then he does a couple hours of paperwork and he does it himself. So
You hold on to what's been marked SS for identification.
Thank you. Now, Dr. Rice, with regard to Mr. O'Keefe, about what time did he come into your facility at Good Samaritan?
Would you like me to look at the chart here? Let's see.
If you can't remember things and you need to reference the chart, you can do that, Doctor.
Okay, thanks. So it looks like, based on the code sheet, first line starting at 0647, so I'll say 6:47 a.m.
And as far as his,
So, to clarify, now that I have it pulled up on my phone, so hearsay, as we've said many times, the following definitions apply under this article. And this is federal rules of evidence I'm looking at, not Massachusetts, but they're going to be the same. But statement, declarant, or A and B, hearsay. Hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, and a party offers in evidence to prove the truth of the matter asserted in the statement. So, the law school answer, hearsay is an out-of-court statement offered for the truth of the matter asserted. So, statements that are not hearsay, this is Rule of Evidence 801D. A statement that meets the following conditions is not hearsay. A declarant witnesses prior statement if the declarant testifies and is subject to cross-examination about the prior statement, and the statement A is inconsistent with the declarant's testimony that was given under penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. So, when on cross-examination, Unetti keeps saying, so you said this in a prior hearing under oath, subject to, well, he wasn't subject to cross-examination in a grand jury. That's not hearsay. It's not an exemption. It's just not hearsay. Or if it's consistent with the declarant's testimony and is offered to rebut an express or implied charge. So basically to rehabilitate with a prior consistent statement. And yeah, there are a few others. But I'm bored with the federal rules of evidence. We don't really care about hearsay. Let's keep going.
presentation, Mr. O'Keefe's presentation, when he came into the emergency department, how would you describe his presentation upon his arrival?
So he would have been, he was unresponsive and intubated, as in with a breathing tube into his airway via his mouth.
And as he came into the emergency department, what, if anything, was fixed in regard to CPR or other resuscitative efforts?
So he would have had CPR in progress. And also someone would have been ventilating his lungs via the endotracheal tube.
Now, there's mention within that record as far as a cardiac arrest. Is that correct?
I don't know. I'm sorry. I don't understand what you're asking me.
So let me just ask you, familiar with the term cardiac arrest?
Yes.
Can you describe to the jury, based on your training and experience, what your understanding of that term is?
Sure. So as in he arrived with in cardiac arrest, which by definition means that his heart was not autonomously or independently pumping blood, or in his case, without electrical activity as well of the heart.
And are you familiar with another term called perfusion?
Yes.
And can you explain what perfusion is and how that relates to the condition of cardiac arrest?
Sure. So, for example, you and I right now, because our heart is autonomously, pumping blood, the heart is the pump and responsible for pushing blood throughout your body, therefore perfusing your body. In a scenario like this, where a patient is in cardiac arrest or asystole, or as in not having any electrical activity in his heart or mechanical activity of his heart, the perfusion that is happening is by CPR, as in the chest being pushed upon, indirectly is, you call it maybe indirectly pumping or moving blood flow. So there is perfusion, but in a significantly limited compared to someone not in cardiac arrest.
So, to summarize, perfusion is the distribution of blood through your cardiovascular system, if you were to put it in one sentence. So, and testifying and teaching are, you know, separate entities, separate animals. I won't judge anyone based on their their style testifying. He could be a great teacher.
And as far as that perfusion process is concerned, what, if any, relation does that have to the organs within the body?
Well, so, you know, if your perfusion is limited, then your organs are not getting the normal amount of blood flow and therefore oxygen and all the other, you know, nutrients that your blood's providing. So your organs will begin the process of failure.
You use the term in there as far as asystole. Could you explain to the jury what you understand that term to mean?
Sure. So asystole would be when you put the electrical leads on a patient's heart. The complete absence of intrinsic electrical activity from the heart would be asystole. So as in not having any observable or detectable electrical activity would be asystole.
Now, as far as these conditions, as far as cardiac arrest and asystole, what, if any, concerns does that raise from a diagnostic perspective in relation to Mr. O'Keefe?
I guess your question with respect to from a diagnostic perspective, I don't know exactly what you're asking me there.
Let me rephrase that. So with regard to those conditions that are observed and noted within the medical chart for Mr. O'Keefe that you have before you, how would that relate to his condition or sort of how he's presenting and what, if anything, you're doing treatment-wise?
Well, so even with good CPR, the perfusion of the brain, for example, and this is what I think about frequently during resuscitative efforts like this, as in, I couldn't tell you an exact time, but there's a certain, without perfusion of the brain for a certain amount of time, you're limited with respect to, well, the concern is that the patient.
And that's actually a good point, Pat's Cats. Explaining something to a jury, you're trying to make it so that the average person can understand. If he's teaching in med school, you know, I'm assuming emergency medicine isn't a first semester course. Med students are going to have that base knowledge that he's not dumbing it down. And so I think that's part of what translates as nervousness, translates as fumbling for answers, is how do I explain this to a 6-year-old? This very complicated concept. You know,
even if you resuscitate their body, that there's potentially going to be brain death or anoxia or lack of oxygen to the brain and a poor outcome with respect to neurological outcome.
Now, as far as the resuscitative efforts are concerned, is there any sort of standard sort of resuscitative protocols that would be undergone?
And even there, anoxia, you know, I get that, the absence of oxygen. The jury might not. They might not.
On with someone who presents as Mr. O'Keefe did?
Yes.
And can you explain what those are?
So,
Oh yeah.
you know, in broad terms, there's ACLS, which is Advanced Cardiac Life Support. That's an algorithm that through medical training, you know, I've learned and is frequently, the algorithm can be adjusted. There's also a TLS for trauma patients. So there's an algorithm there with respect to resuscitation or guidelines, I guess, with respect to resuscitation.
And within those sort of guidelines or protocols, are you familiar with a medication called epinephrine?
Yes.
And how would epinephrine play into sort of the treatment or the diagnosis of Mr. O'Keefe?
It's the Motley Crue drug. Kickstart my heart.
So, in the time that I've been practicing, epinephrine is probably the only medication or drug that has persistently been in the ACLS pathway. It's adrenaline. So the idea is loosely that you're attempting to affect upon the heart itself more squeeze, as in more pressure, and also to increase the potential, or if there is electrical activity, to increase the amplitude of that electrical function at the cellular level.
Kickstart my heart.
Now, in addition to the cardiac arrest and the asystole, as far as Mr. O'Keefe was concerned, what, if any, presentation did he have related to hypothermia?
So I know his initial temperature was low. I'd have to look, but I can see here that the nursing wrote in their notes that his
Did it, shall we say, increase his blood pressure slightly? Just a little bit? Just a wee bit? My sister-in-law's mother is allergic to peanuts, and she frequently stays here when she visits from Pennsylvania. As I've mentioned, my brother lives next door, so spare bed here. And we're close to the mother-in-law anyway. But we're kind of careful with peanuts when she's here because, we never want to see that EpiPen.
is I see T equals 80.1 R. So I interpret.
And for those of you who do have allergies and EpiPens, if you ever use your EpiPen, get your ass to the emergency room. The EpiPen is to keep you alive, not to cure.
That to be his temperature was 80.1 degrees by rectal temperature.
Damn paperwork.
And if you could explain to the jury sort of your understanding as far as hypothermia, what
Did he say 82.1 rectal? I was busy making a joke. 82-ish rectal temperature. I'm sure the medical examiner will be able to tell us the rate of cooling.
what is it and how does that present itself?
So, as it pertains to this case, there's a few ways to get hypothermic. If I at 12:20 were to have a cardiac arrest right now and stop perfusing, my current temperature will.
I thought of that joke, Vince. I thought of calling you out, but I refrained and let you do it yourself.
My current temperature, I'm guessing, is 98.6, right? The normal temperature. Without perfusion, the body will lose, or excuse me, the core temperature will decrease over time.
And yeah,
The specifics of that I couldn't, or beyond my knowledge and training, but does that answer your question?
Yes. And so as far as hypothermia is concerned, is there a certain sort of baseline or what is sort of the typical temperature under which someone would be
95?
declared sort of hypothermic or treated?
I don't know if I could give you a definition of medically what a quote diagnosis of hypothermia. I couldn't tell you a number.
I mean, technically, I believe below 98.6 is technically hypothermia. Of course, individual bodies vary, and the rectal temperature isn't necessarily 98.6. I can't remember if that's the oral temperature, the forehead temperature, ear temperature. You take a armpit temperature, it's going to be different. So the 98.6 figure thrown out is for a certain location. I just can't remember the exact. But I believe rectal actually is slightly higher, but that's a long time since I heard that, so I could be talking out my ass. I hope Brandon is still here for that pun. But technically, anything below is hypothermic. But from the 98.6, I think there's serious concern under 95, as I think that's the number that has stuck out to me in the past. Once again, it's been a very long time. I'm a lawyer, not a doctor. So there is that. That's good advice. Red probes go in the butt, not in the mouth. Red probes are probulators.
I can tell you that 80 qualifies as hypothermia, but I couldn't tell you a number under which that definition applies.
But the temperature that Mr. O'Keefe presented with certainly fits within those parameters. Is that correct?
Yes, 80 degrees is very cold.
And as far as resuscitative efforts as they pertain to the core body temperature or the low core body temperature of Mr. O'Keefe, what, if anything, was done with relation to treatment of that?
Sure. So as the nursing note mentions, there's a bear hugger was applied. So that's a blanket that has warmed air being pumped through it. So that's a way of externally warming someone. He also, having reviewed the chart earlier, I don't see it right in front of you. Actually, I take that back. He had warm IV fluids running. So IV fluids not at room temperature, as in a warm or an oven of sorts, would have been given to him via intravenous or central.
And I assume that warm IV is just saline, possibly warmed plasma, but that's frankly the fastest way to warm up the core temperature, is try and circulate warmth as opposed to compress warmth onto you with like a warming blanket or a heater. Warming you up from the inside would be the fastest way, if possible.
Venous access.
And as far as the body temperature is concerned, what if any relationship does the body temperature have and the warming process have as to a declaration of deceased in relation to Mr. O'Keefe?
Well, so there's a goal in resuscitative medicine to attempt to rewarm a body. Loosely, the idea being that the heart, among other organs, will function better or function at all in a warmer environment. That's one goal of resuscitation. With him, as I recall, despite resuscitative efforts for approximately half an hour, there was not a significant warming of his core temperature.
And so, sir, with reference to Mr. O'Keefe,
So that's saying we've repeated multiple times throughout the trial, you're not dead until you're warm and dead. If you can't get warmed, you're probably dead.
at some point, was he pronounced deceased by yourself?
Yes.
And do you see any indication within the chart as to what time that was?
Sure. I'll just need this
And
moment here.
well, like I'm gonna say an hour after my amputation, I started bleeding, and I just felt my blood pressure plummet, and yeah, that was unpleasant. Can't say I felt cold. I just lost energy immediately.
According to my note, it looks like the time of death was, death declaration was 7:50 in the morning.
Is that 50 or 15?
50.
Now, as far as
So 3-ish hours
observations
after
that
he's
you made, as far
found.
as a systole and the cardiac arrest, did that persist throughout the course of your treatment?
2.5.
O'Keefe?
Yes.
Now, may I approach the witness?
Yes.
Let me just see that document. attention to what's the fourth page in, bottom of it says 2 of 4, and I direct your attention to the top of that page, so you see that, sir?
Yes.
And as far as this is sort of a listing of observations or, well, let me ask you, can you describe what is listed at the top of that page there?
Sure. So this would have been the physical exam documentation of my note. So, with respect to the head, it says, excuse me, the first word is other, which I believe is a function of the computer system. As in, I typed in there is a right superior orbital ridge region, approximately 7 millimeter laceration, and then with surrounding soft tissue swelling / contusion.
So if I could just stop
So right superior orbital above the eye.
you there, as far as what you're talking about with the right superior orbital ridge region, could you explain to the jury
Eyebrow.
or demonstrate the jury?
Sure. So the orbital ridge is the bone above your eye that you can, like where your eyebrow is or, would normally be.
And as far as the other sort of things that you noted over the course of your physical exam or review of Mr. O'Keefe, what, if anything else, of note did you observe?
Well, according to my note, the only other kind of observations other than would be that he had breath sounds present bilaterally. I observed that he was pulseless. His abdominal exam was atraumatic on my chart, and then extremity exam or musculoskeletal exam, I wrote that he had superficial abrasions on the right forearm.
And from a medical perspective,
Breath sounds bilaterally. How are you getting breath sounds? He's not breathing. Is that breath sounds caused by the mechanical ventilation? And so the mechanical ventilation is filling both lungs? That just sounds weird to me, but
when you use that term abrasion, so can you explain to the jury what you understand the term abrasions to mean?
Yeah, I use it as a medical synonym for scratches, if you will.
And under neuro or neurological, there's a listing as far as a GC3, is that correct?
Yes.
And can you explain what that is and what that means?
So GC is what I charted.
dog scratches, superficial abrasions. Dog bites, to me, would be punctures. But once again, I'm not a medical examiner, so and that's what I assumed, Grey Duck. But once again, my doctorate is law, not medicine. So
What I intended to write there was GCS, which is a Glasgow Coma Scale, which is a scoring system to identify someone's level of consciousness or unresponsiveness.
And as far as the 3, where does the scale start? Where does it go to, and where does the 3 fit in?
So there's 3 components: verbal function, motor function, and eye or ocular function. And someone who's completely unresponsive, as in no motor, no verbal, and no eye movement or function, completely unresponsive, the lowest you can get on the scale is 3.
Thank you, sir. May I approach this retreat?
Yes.
Now, later on over the course of that same morning, did you have occasion to become involved in the...
And I'd heard of the Glasgow Coma Scale. I couldn't remember the scoring.
treatment of another patient by the name of Karen Reed?
Yes.
And may I approach the witness again, Your Honor?
Yes.
I'm showing you another document, just ask you to look at that. To the extent you can recognize it and look up whenever you finish.
They might, Pat's cats. They might. And once again, Karen Reed was his patient. HIPAA applies, but there are exceptions to HIPAA. Just like there's exceptions to hearsay, there are things that are not hearsay that normally you'd think are. There are also exemptions to HIPAA. Testifying in a criminal trial, there are a lot of exceptions from HIPAA. I highly doubt Karen Reed has waived HIPAA, but the state is able to breach that doctor-patient confidentiality under certain circumstances. So, and of course here, maybe she did waive, and, you know, he's on the defense witness list. I don't know. But she might have waived to, you know, go with, well, yeah, even if I did it, I was clearly not in my right mind. So, you know, going back to our discussion at the beginning of Attorney Mahoney's observations, that, you know, he said, yeah, if I were representing Karen Reed, first thing I would have done, send her to a, you know, clinical psychologist and have them testify. Well, yeah, she was out of her mind with grief and worry and stress. She could have said anything. She could have, you know, said E.T. did it, because she wasn't thinking straight. So when she says, I did it, that was her hysteria. And so it's possible that despite the third-party culprit defense instead of some Puerto Rican guy, it's possible that they're still going with, well, she didn't do it, the McAlberts did it. But even if she, you know, and she never said, I did it. She never said, I did it. But even if she did, she was clearly out of her mind. Look, her treating physician from that morning even testified. She was sectioned, for God's sake. How can you take a word she said that morning as the truth? How can you take any of that literally? So, and that's it. Whereas attorney-client privilege has very, 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 very few. Like, I did watch the Mess Hole live stream over the weekend as well, with Boomer and Corrosive and that Heisenberg person I'd never heard of, and Turtle Boy's latest victim, Lindsay, alleged victim, I should say. I believe her, but I still should say alleged victim. But that Heisenberg person, I had concerns about a lot of what he was saying. Like, I agreed with some of the stuff, like, let's wait for all the evidence to come out. But the whole, when he was saying, I'd want to call Karen Reed to the stand and have her answer one question for me, and that, you know, did you tell anyone you hit him? And that way, if she told her attorneys, you know, she has to tell the truth and say, yeah, I told my attorneys I killed him. And it's like, there were so many problems with that bit. So many problems. First off, the prosecution can't call Karen Reed to the stand. But even, let's say Karen Reed does take the stand in her defense. The defense calls her. On cross-examination, have you told anyone that you did this? Have you told your lawyers the truth? Objection, attorney-client privilege, boom, done. You cannot ask about attorney-client communications, period. Whatsoever. And damn it, I forgot to mark myself as safe from Kate's boob attacks yesterday. Forgot to mark myself safe from Kate's boobs. So, but yeah, they're literally, the attorneys can break attorney-client privilege to defend themselves and to prevent future crimes. Attorney-client privilege can be breached if the attorney is colluding, if they're committing crimes, they're part of the conspiracy. So, as I've said, Jackson and Yannetti, maybe even Little, I don't know, but in my mind, they should be worried, because if they've been communicating with Turtle Boy directly, those communications aren't privileged, and they can be used against Jackson and Yannetti to bring them in to conspiracy charges on the witness tampering. They're not safe. If Karen Reed and Turtle Boy, their communications are obviously not attorney-client privileged, and if Karen Reed texts Turtle Boy, Alan Jackson said you should do a rolling rally past the McAlberts, that might get you pretty damn close to, as the state, being able to breach that attorney-client privilege. Not as to her guilt in this trial, mind you. As to her guilt in this trial, as to evidence in this trial, that's still sacrosanct. You cannot breach it. At least not based on that. There are dumb things they could do to accidentally waive privilege, but this isn't it. But as far as communications about the harassment campaign, that could cause it. And that's it. The attorney-client privilege is the client's privilege, not the attorney's. But the attorney can blunder their way into accidentally breaching that attorney-client privilege. But as I said, really the only two ways I can voluntarily do it myself, where the client has no say in if I breach that, their waiver is meaningless, is if they tell me they're about to commit a crime and I turn them in, or to defend myself against like a malpractice claim. If they make accusations against me, I can defend myself. Other than that, nope. It's, attorneys have gone to jail for contempt for refusing to waive privilege, which is fucked up because, you're going to jail me for following my ethical rules that the Supreme Court, the state Supreme Court, holds me to. But you, a lower judge, are going to put me in jail for that. That's not right. That's not right. So.
In general, sir, do you recognize what that is?
Yes.
Or what do you recognize it?
The first part I recognized would have been the medical record or medical note with respect to Miss Reed, who was also a patient that morning.
Thank you. Your Honor, the Commonwealth seeks to introduce in the minutes the next exhibit, a redacted copy of those records.
Regarding no objection, subjects to the redactions. This is exhibit 106.
Now, sir, if you know about what time was it that Ms. Reed came into the emergency department at Good Samaritan that morning?
And actually, before we go too far afield, you know, since we've been talking about HIPAA and attorney-client privilege and stuff, frankly, none of these are constitutional concepts. All of them are statutory or derived from the common law. So attorney-client privilege is a legal concept, not a constitutional concept. It's, you know, it's, I don't actually know if it's created by the courts as, you know, because the courts regulate attorneys. They're, you know, the state Supreme Court regulates attorneys. Therefore, they get to tell us what our ethics are. I don't always agree with them. I think they should go further a lot of times, but that's me. But like HIPAA, doctor-patient privilege, basically, is statutory. It's a federal statute. Priest-penitent privilege is generally statutory. In some states, it's common law. There's one or two others I'm not thinking of off the top of my head, but that's actually one of the benefits. There are certain areas of law where you don't necessarily need an attorney to represent you, such as tax law. You can have a CPA or an enrolled agent represent you in U.S. tax court. In fact, they might do a better job because they're bigger experts at tax. They do the numbers. Whereas one of the advantages of using an attorney is there is no CPA privilege. There is attorney-client privilege. So it's funny like that.
I mean, I can tell you from this chart, it looks like that her, at least the first posted vital signs were from 7:51 in the morning.
And in reference to Ms. Reed, what is it that she came into Good Samaritan in regard to? Why is she there?
I'd have to review Daisy's note. So
Well, let me ask you this, sir. Was it in reference to section 12?
Okay, yeah, I saw that a couple weeks ago, Vince. It was in Judge Stevens' court, and of the YouTube judges that get a lot of airtime, Judge Stevens is not my favorite by any means. But that was brilliant. That was brilliant. And by brilliant, I mean the prosecutor on cross-exam, knowing that attorney-client privilege had been waived. So he admitted to you that he did this crime. Yeah. That's pretty damn good evidence. That's why you don't waive attorney-client privilege. Ever. Yeah, Kova. The attorney was in the hospital with pneumonia. He had the oxygen cannula. He was in obvious pain. And he still brought the smack down. And absolutely vote Debbie Davis if you live in St. Joe County. Otherwise, don't, because then it would be voter fraud.
you recall?
Yes.
And with regard to section 12,
It's, I think it's on Law Talk with Mike. Pat's Cats. I think it's Law Talk with Mike. I'm sure someone will be able to find it, and if not, give you the link, give you the title, and it's like 2 weeks ago. So, but it's brilliant.
patients to come in regard to that. What kind of involvement do you have, or who, if anyone, do you work with in regard to those types of patients?
Sure. So section 12, I would define as involuntary detention of a person, usually for a mental health concern, whether that's self-harm or harm to others, or if someone who's, afflicted with schizophrenia or psychosis, members of the public can bring someone to or the police or members of the public can bring someone to the hospital on a section 12, which again, involuntarily detains them for evaluation.
And in addition to yourself, is there other staff? You mentioned that there were physician's assistants or nurses that were working. How much involvement would you typically have with someone who comes in on that kind of prognosis?
I would say, to answer your question, my involvement is variable and dependent a lot of times on what that nurse practitioner or physician assistant feels like they need or want my involvement to be.
And what kind of involvement would you have as far as when someone comes in with that kind of issue? What is sort of the typical protocol or policies that your Good Samaritan would undergo with reference to that patient? What are you doing with reference to the patient when they arrive?
I'm sorry, I don't really understand what the question is.
No, understood. Let me rephrase that. So with regard to a patient coming in on a section 12, what happens with that person once they present in the ER?
So whether they're evaluated by me or a nurse practitioner or physician assistant, if that person feels like, based on their evaluation, that they need a mental health consult or evaluation, then they would have that initiated, as well as what we do for a lot of patients, or all patients' vital signs, and sometimes blood work as well.
And when it comes to that sort of blood work, or say, as far as what's being done with someone who comes in with that kind of report, what is sort of being tested and what is being looked at as far as the blood work is concerned?
Well, there's a few reasons to get blood work, but in general, part of the evaluation is, with respect to the medical presentation, to make sure there's no medical emergencies present, in addition to whatever the mental health concern may be. There's also blood work drawn with respect to disposition, as far as some people, for example, it would be inappropriate to have a mental health evaluation if, for example, I were intoxicated on alcohol and my alcohol level were elevated, because I think the idea is that you're not getting, a true representation maybe of what's going on.
So am I correct in that someone presents and then there's sort of you medically clear that person as far as any sort of injuries or anything like that first?
I wouldn't say first necessarily. I think a lot of times these processes happen in parallel.
So in parallel, you have the medical clearance and then sort of a psychological clearance as well?
Sometimes, yes.
And then sort of involved in both of those, there would be blood drawn and reference to section 12, as far as a typical one would be looking for sort of alcohol and drugs of abuse, things of that nature.
I mean, I'm hesitant to answer yes because of the word typical, because I wouldn't say there's really a typical present.
And that's the thing, Kevin. The fact that Michael Mee hasn't even withdrawn, he's the counsel of record on the appeal. He hasn't submitted the appeal. He didn't file an appeal, but he's still the counsel of record on the case. He hasn't withdrawn, as far as I've seen. And yet they're appealing on ineffective assistance of counsel. It doesn't work that way. It's wild. It's absolutely wild. And he's still technically on the civil case. It's wild. And I got distracted. Real life, had to send a text. I got distracted. So I'm a little lost, but it could be BAC. So we'll click play and see.
Presentation with respect to mental health presentations in the ER.
And from your memory and or your review of the chart, was that done as far as the blood work done with regard to Ms. Reed on this date?
Are you asking me if blood work was drawn?
Yes.
I believe so. I have to double check. So yes, it looks like there was blood work drawn.
And among the things that were tested within the facility.
All right. So blood work drawn. If they tested her BAC, now once again, there are defenses. Let's just say her BAC comes back high at 8 in the morning. I say, well, yeah, but I drank a bottle of whiskey after I got back to Johnny's place at midnight. I wasn't driving drunk. I got drunk after I drove. Of course, then she's on the record as driving drunk to Jen McCabe's house at 5 in the morning. But that's just a DUI, not DUI manslaughter. She's not even charged for that DUI. So, to me, once again, I'm a juror. I haven't seen the indictment. The charges I know of are second-degree murder, DUI manslaughter, and basically DUI leaving the scene, something like that. I don't know if there are lesser includeds. I want regular manslaughter as a lesser included at the very least, because to me, frankly, the hardest part, if they don't prove second degree murder, the hardest part for the DUI manslaughter might be the DUI part, the intoxication. Because at the end of the day, the jury might say, well, yeah, we believe she hit him, but we don't believe she was intoxicated, therefore not guilty. Whereas if you have the regular bog standard manslaughter, the unintentional killing of another, of a human being, and you don't have to prove intoxication. And that's the thing, though. That's the thing. Second degree murder is the top level, the top charge. She's charged with DUI manslaughter. So DUI manslaughter, by its definition, includes vehicular. But I don't know specifically, because once again, I haven't read the indictment. I don't know that vehicular manslaughter or is a lesser included. I hope it is. I hope vehicular manslaughter is a lesser included in the DUI manslaughter charge. I hope that bog standard manslaughter is a lesser included to the second degree murder charge. Normally, I would expect that to be the case. And then, if she's found guilty of the higher charge, they merge and the manslaughter is consumed by the second degree murder. So, not necessarily. It could be, but it might not be. But as I've said, I don't agree with the DUI manslaughter. To me, I think DUI manslaughter should just be second degree murder, because to me, if you're driving drunk and kill someone, the driving drunk to me is different. So DUI, second degree murder, does not matter whether she's drunk or not. But they have to prove intent. They have to prove that she intended to kill him or acted with reckless disregard for human life. So the DUI manslaughter, they have to prove the DUI, but they don't have to prove intent, just that she killed him and was drunk and driving and doing so. So, and that's very true. Had she, you know, to quote Leonard French, lawful masses once again, and I realize it's not his quote, but I attribute it to him because he's the one I hear it from. But, you know, it's better to eat the crow when it's young and tender, because surely if you don't, you'll eat it when it's old and tough. Had she right out the gate said, oh my God, I hit him, it was unintentional, it's terrible, but it was an accident, she might still be on probation, but she might already be out of jail, especially since her plea deal might have been to regular manslaughter, not DUI manslaughter. She might be done already. So that's, of course, assuming she did it. Hasn't been proved yet. And that's my argument, Pat's Cats. To me, the DUI is intent and it should be second-degree murder. The DUI manslaughter should not exist because to me, it is depraved indifference. Reckless disregard for human life. It is, to me, second-degree murder. But legally, it's not. And I think that's wrong. I think that's wrong. If I came to power, that's a law I would change. If you kill someone while driving drunk, it should be second-degree murder. Or first degree if you know, intended to go out and kill someone and got drunk and, you know, so. But yeah, get an Uber or don't go out. Walk. Get a DD. Just don't drive intoxicated. And that's it. You know, Brian Higgins, he was clearly drunk driving home. That's a scumbag move. He should know better, especially ATF. He should know better. I mean, but once again, maybe that was Boston sober. I don't know. But just don't do it. Period.
Within Good Samaritan was an alcohol screen, is that correct?
Yes.
And what is the result of that alcohol screen that's contained within those records?
Do I answer or no?
Yes.
So it looks like 93.93. I'd have to maybe look deeper in the chart to tell you the units of that measurement. I don't want to guess. So to answer your question, 93.
May I approach just briefly on?
Yes.
I just.
So defense doesn't want the BAC.
I'm directing your attention to the top portion of that.
Sure.
Do you see the units that 93 contains in that record, sir?
So yes, it looks like it's milligrams per deciliter.
Thank you, sir. May I approach this to retrieve now?
Yes.
Yep.
Thank you, sir. I have no further questions to this witness, Your Honor.
All right, Ms. Little?
Good afternoon.
Hi.
You testified that you treated Ms. Reed when she arrived at the hospital on January 29th, correct?
I don't know if I testified that I treated her, but I was involved in her care, yes.
You actually wrote the reports regarding her care, correct?
That is not correct.
Would it refresh your recollection to take a look at the report?
The report, I believe we're talking about the note, the emergency room note was written by a nurse practitioner.
Oh, once again, there are major exceptions to HIPAA, and prosecution is one of them. And you know, she was treated that morning, so her medical records for that morning are relevant. So that's how they're getting the evidence or the medical records into evidence for the prosecution.
Commissioner,
Would it refresh your recollection to take a look at some additional reports from January 29th?
sounds like you want to show me some reports, so sure.
He's like, if you want to show me, sure.
May I approach?
Yes.
Yep, okay.
Is your recollection refreshed? Do you recall treating Ms. Reed on January 29th?
I do not.
Do you recall writing a report that has your name, Justin Rice, on it from January 29th?
No, it depends what you define report as. It's best to answer your, well, do I recall writing this note? No. Is that what your question was?
So is it your testimony that do you recall treating Ms. Reed at all?
No, I don't.
Do you recall actually ordering her blood in this case?
No,
Do you recall sending it out to the labs at all?
no,
As you sit here today, you don't know who collected the blood?
that's correct.
You don't know who?
And that also is a part of HIPAA, but HIPAA is also the privacy. It's, you know, it prevents the healthcare providers from unauthorized disclosure, but it also is about, you know, it's the health information privacy or portability and something act. Can't remember exactly. It's not usually relevant to me. And CJ5, good to see you. I hope everything is well down under. But yeah, it deals with portability, you know, old providers, how they're supposed to provide it to new health providers, and what they're allowed to disclose and how they have to disclose it, when they have to disclose it, what they're not allowed to disclose. It's just you know, it's so much. It's a very comprehensive law that, you know, they could teach an entire law school class on HIPAA, or medical school class even.
Package the blood,
That would also be a fair assessment, yes?
and you don't know who submitted that to the lab.
Correct.
And it wasn't you, correct?
I can confidently say that I did not collect blood work.
As the attending, his name is going to be on it, but it was probably a nurse that drew the blood.
Yeah, I did not do that.
Okay. You testified that you treated Mr. O'Keefe upon arrival on January 29th, correct?
Yes.
Did a firefighter ever approach you on the morning of January 29th and tell you that he had information suggesting that the victim had been struck by a vehicle?
Objection.
Do you remember that?
I do not.
So if a firefighter indicated that he informed you that he had information suggesting that Mr. O'Keefe had been in some sort of vehicular accident, that's something that you would have included in your report, correct?
I don't know if that's a fair assumption.
But as you sit here today, you have no recollection whatsoever of anyone telling you that the victim had appeared to be in some sort of car accident, correct?
Well, I think, I don't have it in front of me, but I think my note that I prepared for Mr. O'Keefe states that per EMS.
Dr. Rice, you have no record. Apologies.
So I don't think he finished his answer.
So I think that what I was trying to say, right, was that on my note, it says per EMS report. So one of the medics, as in one of the folks on the ambulance.
So I finally found the Law Talk with Mike video about the guy that stupidly waived attorney-client privilege and questioned his attorney. It's the video from a month ago. It's alive, and it's titled, "I was not yelling, I'm simply speaking up." And it's the second case in that video, second hearing. Basically, move forward until you see Judge Stevens, and that's the one. Obviously, wait until we're done here. Open it in a different window and pause it. It's wild. So I'm not yelling, I'm speaking up. Law Talk with Mike live a month ago. So that's the one we were discussing a few minutes ago.
Who brought Mr. O'Keefe in. Again, I'm not right in front of my note, but as I recall, it said something to the effect of per EMS report, the patient may have been struck by a vehicle.
Can I show you a copy of that report?
Please.
That's it. They're the air traffic controller, even, herding chickens, herding toddlers.
Yes.
You can take a look at that.
All right, so,
I'll ask a question. Is your recollection
course.
fresh?
yes.
Is there anywhere on that report that says that the patient came in and there was a statement by EMS that the victim appeared to have been struck by a vehicle?
Just give me a moment to read through the. So no, there's not.
In fact, there's no mention of a vehicle whatsoever, correct?
That's correct.
Oh, that's definitive proof that it wasn't a
Dr.
vehicle.
Rice, did you observe Mr. O'Keefe's injuries when he arrived at the hospital that morning?
I mean, did they mention a dog attack? What did the EMTs mention to Dr. Rice, a dog attack? Did they mention looked like he'd been in a boxing match with Colin Albert? Did they mention it looked like a gang initiation beat in? Did they mention it looked like he'd fallen from space because the alien's tractor beam wasn't strong enough? Did they mention it looked like he'd been hit by a snowplow? Did they mention it looked like he tripped over the curb? If the only options are the suggestions that the firefighters made about what it looked like, it's pretty limited. It's not really relevant. And every Law Talk with Mike episode is the one with the thruple, Kevin. Come on.
I guess you'd have to define what observed injuries means.
Well, during the course of your treatment, did you inspect him for injuries?
So, yes,
You testified that you observed certain abrasions and scratches on his right arm, correct?
yes,
Aside from his injuries to his right arm, and I believe you described sort of a laceration above his eye,
Mhm.
John O'Keefe did not have a single other injury on his body from the neck down, correct?
I don't know if that's fair to say.
Well, you didn't report a single injury to his shoulders, correct?
Correct,
You did not report a single injury to his chest, correct?
correct,
You did not report a single injury to his torso, correct?
correct,
You did not report a single injury to his back, correct?
correct,
You also did not report a single injury to his ribs, correct?
correct.
It's almost like he's not the medical examiner. He's the ER physician. His job was rescue. His job, well, I mean, eventually it might have become treating the wound to get above his eye, treating the scratch marks, looking for injuries on his torso or legs. But his job, his attention was the cardiac arrest, the lack of cardiovascular function. You know, we've talked before. When you hear hoof prints, you look for horses, not zebras. Unless you're in the Serengeti, then zebras might be a reasonable speculation. I mean, of course, my house, the reasonable speculation is probably the Monty Python coconuts, because there's not a lot of horses in my neighborhood either. But horses are, well, I guess there is the zoo. A zebra could escape and go by my house. But as an ER physician, you're not a medical examiner. You're paying attention to the cardiac arrest. Everything else is secondary. If that. Tertiary. If you don't restore cardiac function, you declare him dead and move on. You don't say, oh, but you know, let me fix that fractured femur just in case. I know I didn't restore cardiac function, but let's hurry and, you know, put a cast on that femur. That makes sense. That makes sense. Whereas the medical examiner, well, by the time he reaches the medical examiner, you're assuming there is no cardiac function and there will be no cardiac function. So the medical examiner says, let's have a little look-see-poo, see what else there is. Let's take a look inside and see how you tick, or how you ticked. It's almost like they're different functions. ER physician and medical examiner. And I'm sure we have swallows here, but I don't actually know. We have a lot of starlings. Messy fuckers. Oh, they make a mess. A lot of finches. Squirrels. Jays. Robins. Hawks. Falcons. Sure, there's eagles, but they're not nesting in the city usually. Mountains, though. I mean, there's all kinds of birds. You know, the Great Salt Lake is kind of the pit stop for migratory birds. And so, you know, pelicans and just everything, everything. One of my friends on Facebook is always going out birding at the Great Salt Lake and posting pictures. And actually, my high school biology teacher, he retired as soon as he was eligible. He was, you know, like 55 probably. And he spent the last 20 years as a wildlife bird photographer. And he'll go out to the wetlands and use a telephoto lens that, you know, you'd be able to flip a coin on Mars and know if it's heads or tails. And so he goes out and sits in the bed of his truck with that telephoto lens taking pictures of birds, and they're spectacular. So, but I don't know which specific birds or specific swallows are here. And Vince, you are still terrible. So, all right. Barn swallows in Utah. And there is in Liberty Park, there is the Tracy Aviary, which is frankly a very good aviary. And back in the day when I was very young, first 4 years of my life, we lived a couple blocks away and we were poor. And at that time, the aviary was free. So we'd walk up and see the birds. And I loved that snowy owl when I was a kid and the golden eagle. And the flamingo flew off to the Great Salt Lake. So there's a lone flamingo out there called Pink Floyd.
To his hips, right?
Correct.
You observed no injury to his knees, correct?
I reported no injuries to his knees, correct?
No injuries to his shins, correct?
Correct.
No injuries to his ankles, right?
Correct.
And no injuries to his feet.
I'm told Wyoming isn't real either, yet I have seen birds in Wyoming. I haven't. I've seen birds in Wyoming. In fact, I've seen Baldy. So we were driving along the highway into Jackson Hole. We hadn't reached Hoback yet. We were on 89, probably 3 or 4 miles before Hoback Junction. For those of you familiar with the Jackson Hole area, it's one of the areas where the river widens out and is shallow and has lots of sandbanks and, or, you know, sandbars and stuff. And we were driving in to Jackson from our campsite for dinner to go to a restaurant. And I saw a bald eagle get a giant fish out of the river, swoop down, catch the fish in its talons and fly off with it. And just as we're driving on the highway, and that was impressive. That was impressive. And that's it. I've seen birds in Wyoming. Conspiracy. Double conspiracy.
Correct.
From the neck down, he did not have a single broken bone, right?
I don't know if that's a fair assessment or statement.
You certainly didn't notate in your report that he had any broken bones from the neck down, correct?
No, I did not. I'd happy to explain that, but to answer your question, no, I did not.
You did not report a single fracture from the neck down, correct?
I did not report a single fracture, correct?
He wasn't looking for them. He was focused on
So,
his
injuries
ticker.
that you testified to today were that he had sort of a laceration above his eyelid, correct?
The injuries that I testified to today, correct, yes.
And the scratches on his right arm.
On the right forearm, yes.
No further questions. Okay, Mr. Lally?
Dr. Rice, with reference to fractures or broken bones, can you explain sort of why that may not have been noted or why that wasn't included within the chart?
Sure, yeah, I'd like to. So with a patient like Mr. O'Keefe who came in, the focus of myself and the team of physician assistant, nurse practitioner, and nurses, whoever was helping in a case like this, the focus is in core resuscitative medicine
It's once again, the defense strategy is, you know, we've talked about it before, not specifically them, but in general, you know, if the facts are on your side, you harp on the facts. If the law is on your side, you harp on the law. If the facts and law are not on your side, you pound the table and get loud. And that's basically what this is. They're taking nothing but trying to make it sound suspicious. So you didn't note any of these. It's like, I wasn't looking for those. I was trying to save his life, not treat an owie. It's real easy to clean up on redirect, as we're seeing now. My focus was not on owies. I wasn't trying to kiss his boo-boo better. I was trying to start his heart. When I failed, whether or not he had owies was irrelevant, because he'd be buried with those. I mean, unless they're trying to retrieve something from it, there's no reason. And even then, retrieval would probably be the medical examiner anyway. So still no reason for the ER to x-ray a dead body. So, yeah.
securing an airway, making sure he has a breathing tube in, making sure that the CPR is being applied, the right pressure to the right place, making sure that the core resuscitative elements of medicine are happening, unless, as in the mind can only focus on so much. So I think in cases like this, because the attention is on resuscitation of someone's heartbeat, their life, there's less focus on injuries or observations that don't coincide with the resuscitation effort, or not pertinent to that resuscitative effort. If that answers if that answers your question.
So in that vein, it's not like you're doing X-rays or a full skeletal survey or something like that.
No, we're not doing a full skeletal survey. No.
Because you're more concerned with the fact that his body core temperature is 80, his heart isn't pumping blood, and he's pulsing, correct?
Correct, unless there was an extremity injury that would be pertinent to his resuscitation. If he had had a traumatic amputation, as in removal of a leg, for example, that would be pertinent to a resuscitation, but an otherwise intact extremity.
As I can testify, if you're bleeding out from a recent amputation, that's going to have implications as to your circulatory system. I mean, if you note, a compound fracture, you're still going to perform a primary survey, but it's going to be more visual and touchy-feely than X-rays. And so if you notice, hey, that leg is on backwards, that might have him bleeding internally. And I better get rid of all those leeches then. Apparently that's not state of the art anymore. Except where it is, because, you reimplant a digit till the venous flow returns, you use a leech.
That is not necessarily within the realm of resuscitation.
Can I approach the witness?
Yes.
I'm going to direct your attention on document case discharge and clinical impression. If you could just read from that, look up when you finish. Read to yourself.
I'm sorry, what would you like me to read out loud?
So as far as the chart is concerned, as far as your clinical impression of Mr. O'Keefe, can you read sort of what you...
Sure, right. So I wrote clinical impression, cardiac arrest, head trauma, exposure to environmental cold.
And approach this to retrieval.
Yes.
No further questions.
Anything further, Ms. Little?
No further questions.
All right, thank you, Dr. You are also.
So clinical impressions, head trauma, exposure to environmental cold. That'll kill you. That'll kill you. And that's true. If, you know, getting rid of gangrenous tissue, getting rid of bad stuff, you use maggots, and ew, that's gross. But it's still good medicine, you know, assuming the maggots are from a known source, a clean source. If they're not carrying an infection, if they're sterile maggots, they're gonna eat the dead flesh, you know, keep it debrided and healthy, and they're going to prevent infection. And like I said, you know, you reimplant a finger, put a leech on it every now and then to make sure it doesn't blow up like a balloon. And yeah, there is that. So, ew. Ew. I mean, like, I get that there might be medicinal properties to bee venom, but still, ew.
Thanks.
Rather than when it's 10 minutes of one, jurors, can we do an abbreviated lunch today so we can get as much of the testimony in as possible? So it's 10 minutes of one. Why don't we come back here at 1:30? And can we go until 4:30 today? We'll seem to say yes. If that changes, just let Officer Delano or Officer Biden know. Okay, thank you. So we'll see you back here at 1:30.
All right, so the court agrees?
You are muted.
I think her future in medicine is providing a steady flow of patients, right?
No,
I think that's what it is. But I think calling First Amendment auditors maggots is doing a disservice to
All right, so
maggots.
as far as the redactions that you think should be there, Ms. Little, and you perhaps don't, Mr. Lally, I don't know if the testimony opened the door any on some of what may or may not have been there. I don't have it in front of me. I haven't seen it. So the two of you talk, and if you're not in agreement, I would like a copy of both by 1:15 so that I can decide it before it goes in, and then it will be the next exhibit, either with or without the additional redactions. Okay?
What open door are they talking about? Is that the BAC? Is that the blood draw open door? Or I'm curious now. I'm curious.
All right, thank you.
All right, let's cancel.
All right. And let's maybe
retrial
it's
watchers,
Jesse
this is-
Weber. Can we just take a minute to appreciate Jesse Weber's pause face right here? Savor the pause face. It's still not quite to delete laws level, but that is one quality pause face, if I say so myself. And that might have been it. I admittedly was distracted for a few minutes with real life stuff, so that could be it. But let's find the resumption of court and not linger too long on Jesse Weber, because I appreciate Jesse. He does good work. subscribe to Law and Crime, obviously, because they do good work, and I'm a leech that uses their cameras. Although this might be court TV cameras, I don't care. Either way, I do appreciate the media in the courtroom that does the media pool feed. Yeah. From Jesse Weber's O-Face to Yannetti. Ew.
All right, so your next witness, Mr. Lally?
Yes, Your Honor, the call will call Dr. Gary Fowler to the stand.
They haven't struck me, so I think in general they realize trials are, they are a pool feed. As far as, curated content, I think they still absolutely do privacy or copyright strikes. So I haven't watched the entire series of Bones, so I don't know.
Step right up. Raise your right hand, please. You solemnly swear the evidence of the court and jury of the case now answer the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Oh, he's going to be soft-spoken.
Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for us?
Gary Fowler, F as in Frank, A-L-L-E-R.
And sir, that microphone in front of you, you can move that any way you wish. So if you want to bring it up or down, just one.
I mean, I don't wish ill of Nick Rekieta by any means. I'm not a fan of Nick Rekieta by any means. I appreciate the trail he has blazed. I wish him the best. And that's all I'll say.
And what do you do for work, sir?
I'm a pathologist.
And
Hey!
where is it that you work?
I work at
The medical examiner. We've been looking forward to him. Wonderful.
Good Samaritan Medical Center
And how long have you been working as a pathologist at Good Samaritan?
since November of 2015.
Now, if I could ask you just a few questions about sort of your educational background, starting with your undergrad, where did you go to school and what, if anything?
And I will say, as far as Nick Rekieta, I'm open. I judge Karen Reed for her association with Turtle Boy. I frankly, when it was after the during the Depp Heard trial, but really after I watched a few of Rekieta's live streams, and then he did a live stream with the quartering, and I'm like, nope, nobody, nope, because I very much dislike the quartering, and so I judged Nick on the company he kept. Just like with Karen Reed.
Did you receive a degree in?
My undergraduate education, I went to Tufts University.
All right, so doctor, I'm going to ask you to put the microphone perhaps underneath your mouth and speak
Oh,
into
okay.
it, because in order to keep this room cool, we need to have these fans going. If they can't compete with you, we'll have to turn them off, and I think everybody would prefer to have them on.
And
So
you're
please speak loudly.
soft
How am I now?
spoken.
Okay. So Tufts University, undergraduate. I have a degree in biology. That was.
And after you received your degree in biology from Tufts, where did you go from there?
I went to Tufts Medical School in Boston.
And that's important point, Vince. He the live stream before his arrest, he looked awful. He looked like a skeleton. He was dazed and confused. Great song, not a great condition to be in. Hopefully he has hit rock bottom. Hopefully, he realizes he needs to do better. If he starts thinking straight, he's going to hire an attorney, not represent himself, not represent his wife and mistress, because frankly, that's probably an unwaivable conflict. That's begging for disbarment. But if he starts thinking clearly, he hires an attorney and checks into rehab as soon as he is released on bond. And that way, at the next appearance, his lawyer, not him, but his lawyer goes in and says, Your Honor, my client is taking this seriously. He is in rehab. He's trying to get better. He's working on himself. He's, that would be the absolute best thing he could do for himself. So, but now we're moving on from Ricada.
For 4 years there.
And after you graduated from medical school, where did you go from?
I went to a residency in pathology, anatomic and clinical pathology at Tufts Medical Center. So I stayed within the Tufts system. Okay.
And Tufts is there in Boston.
That residency?
That residency was, at the time, pathology residency was 5 years. It's now 4 years, I believe, but it's a 5-year program. I finished the residency with the chief of resident in pathology in my 5th year.
And then following the residency, where did you go for work?
In 1996, I finished residency, and my first job was at Kearney Hospital, beginning the end of June of 1996.
And how long did you work at the Kearney?
I'm still on medical staff at Kearney, so ever since. I was transferred.
Conspiracy. He's at Kearney. Aiden Kearney is Turtle Boy. Conspiracy. I've got you, doctor. Conspiracy.
To help Good Samaritan Medical Center in 2015. My full-time job is at Good Samaritan now since 2015, but I still cover Kearney Hospital every now and then.
And are you board certified?
I am board certified in both anatomic and clinical pathology.
You've used that term, and just if you could explain to the jury what your understanding of that term is as far as pathology and sort of the difference between anatomic pathology and clinical pathology.
Sure. Pathology, there's two subspecialties, I guess, in pathology. One is anatomic pathology, which is basically if you, as a patient, go to a hospital or have a biopsy, or a tissue biopsy, or an excision, or anything like that, it comes to the pathology department, and an anatomic pathologist is responsible for making the diagnosis for that patient. So we abbreviate that as an AP, anatomic pathologist. So in residency, you can also train to become a clinical pathologist, and clinical pathologist is a pathologist who basically deals with, to put it simply, if you have a blood test that goes to that gets sent to the lab, we are essentially responsible for the quality and the safety of that blood test to help ensure the lab tests that are done on the specimens are accurate.
Now, with regard to your position at Good Samaritan, what is it that you do at Good Samaritan? What are your sort of duties and responsibilities in relation to that hospital?
I am the chief of pathologist at Good Samaritan Medical Center. I'm also the laboratory medical director. So my job at Good Samaritan is to ensure, quality of both the anatomic pathology side of things, as well as the clinical pathology side of things. Ultimately, my job is to help ensure that any laboratory report coming from Good Samaritan is accurate.
Now, the lab at Good Samaritan where the testing is done, is that accredited?
Yes, it is.
And can you explain to the jury sort of what that accreditation means, who it's by, and sort of what goes into that accreditation process?
We are accredited by the...
And actually, I'm glad you commented about that, Vince. So, as I've mentioned, my aunt has MS, and I saw her yesterday on Memorial Day. Imagine that. She was at the family barbecue. And I specifically asked her because, as I've said, I know the heat affects her. She can't have extreme heat. Her health insurance paid for an upgrade to her house air conditioning. But I asked her, what about cold? And she's like, well, extreme cold, I can't do that. I'm like, what about, 20, 30 degrees? And she's like, no, arthritis maybe, but not MS symptoms. Once again, though, that's her, not Karen Reed. MS doesn't manifest the same in everyone, which is why it's so difficult to diagnose. But, my aunt basically said, extreme temperatures, bad. Otherwise, fine.
College of American Pathologists. We abbreviate that as CAP, if I mention that later, just so you know. And the accreditation process, the CAP has been in business for 75 years or so. They, according to their website, are the preeminent accrediting body for medical laboratories. So what that means is every 2 years, we have an in-depth laboratory survey. That's every 2 years. And there are over...
No, because she wasn't drinking. She did go to Boston, I think, in 2022, but it was September. And she doesn't drink. She's Mormon.
Maybe 3,000 elements or checklist requirements that the CAP will look at in our lab, which ranges from anywhere, for quality, mainly quality control, making sure that we have enough staff members, just about anything that...
If I were to tell you my aunt's name, you wouldn't believe me, and it would be a conspiracy. But I'm not going to dox my aunt, so there is that. I have doxed her daughter, but...
can affect a laboratory result. There is essentially a checklist requirement that we need to fulfill and pass. So that's every 2 years.
And is that accreditation, is that up to date as of now?
Yes, it is. We will be having another inspection. Our window opens in July, so it's coming up. We have a 3-month window where the CIP can come anytime unannounced. So.
And was that
You never know, CJ5. He might let loose at parties. I bet he has stories to tell.
Accreditation up to date prior to January 29th, 2022. Now, as far as the clinical portion of the lab, what are some of the things that get tested as far as, what are some of the things that are tested for in the lab as far as blood work is concerned?
Many different things. As probably all of you know, when you go to a hospital, you have your blood tested, and the physician is looking for
Yeah, it's like on The Simpsons when with the mob war and basically the Yakuza, the Japanese mob. There's the quiet guy, and Homer's waiting for him to go off, and then he misses it. But it must have been epic off screen.
different tests such as like a sodium, a potassium, a chloride, some basic tests that if they show abnormality, that could help them, help the clinician make a diagnosis on you. So the most common things would be like a glucose, sodium, potassium, chloride, stuff like that.
Now, is there's some sort of like standard algorithm for things that are tested, or does it sort of dependent on the patient's presentation?
I think it's depends on the patient's presentation. There's no standard ordering test that one can order. So it depends mainly on what the doctor is thinking and his differential diagnosis. He will order, a variety of different tests. Some tests are pretty standard. When you go to a hospital, they might order,
Of course, by that logic, you'd think, you know, Brian Albert and Brian Higgins and, you know, all the law enforcement that was at the Albert house, if the Free Karen Reed conspiracy is right, you'd think they'd also know how to make it look like it's not them. You know, you'd think cops would know better than to leave their murdered bodies on their own front lawn. So, you know, if he's as bad as at making it look like an accident as the McAlberts, you know, conspiracy.
Test that I just talked about, a CBC, they want to look at your complete blood count.
Just a little louder, please.
Okay, sure. Things like that. Want to look at your hemoglobin, hematocrit, maybe sodium, potassium. Those are some of the really common tests that would get ordered in a hospital.
Now, as far as drugs of abuse, including alcohol, is that something that's dependent upon the presentation of a patient to your facility?
I think an alcohol test or a drug of abuse test is not a routine type of order or test. It all depends on if the clinician or the primary care physician is suspecting could be, you know, drugs of abuse or alcohol on board, and they need to know if so to help treat the patient.
And would that also include sort of a patient that presents in regard to a mental health status or Section 12 drugs of abuse? Would that be somewhat standard in relation to testing or blood work that's done in relation to that kind of patient?
Section 12. So he might actually not be the medical examiner testifying about Johnny. He could be the pathology lab talking about testing the blood draw. So we might have got ahead of ourselves. We might have got ahead of ourselves. This might be about Karen's blood draw, not Johnny's autopsy. Whoops.
As far as Section 12, I do not know if there is a standing order for a routine ordering process for a patient that is admitted to Good Samaritan under Section 12. So I'm not sure. So,
would that be abnormal, though, as far as doing a blood draw and testing for alcohol and someone presenting on Section 12?
I don't think so, no.
Now, with regard to a blood draw in Good Samaritan Hospital with reference to testing for alcohol specifically, what, if any, sort of policies or protocols are in place in reference to that type of blood draw?
I think a test for blood alcohol.
And that's it. That's it. As I've said, I'm going in as a juror. Everything I want to be new to me so that I experience it like a juror. I hear medical examiner, I hear pathologist, I should say, and I think medical examiner, I think autopsies. But as he explained, well, there's can't remember how he divided it, but there's, you run these tests or you run these tests. You run blood tests or you run, tests on biopsies. That should have been my clue. I was just expecting, and then there's the autopsies. But that's why I keep reiterating when people come in and call me out that I'm a juror who happens to be a lawyer. But experiencing it as, oh, she's a zombie now, is she? Very interesting. Very interesting.
What is the phlebotomist pretty much has to run through the same protocol that he or she needs to follow for any type of blood test, except for the fact that we do not want to use an alcohol swab to clean the area before the blood draw. In theory, if you use an alcohol swab and you're testing for alcohol, then you can, in theory, contaminate the blood sample with some of the residual fluid of the alcohol. Some people say if you let the alcohol swab dry for 30 seconds, it's not going to contaminate it, but we don't go by that process. We have it specifically in our policy never to use an alcohol swab when an alcohol test is ordered.
So in that case, do you use like iodine, that yellow swab that they do before surgery. I don't know what, I think it's iodine, whatever that antiseptic is. Of course, I don't know that that yellow antiseptic might have alcohol in it, but
Now, in that vein, doctor, with reference to Good Samaritan emergency departments, what if any precautions have you or your facility taken in regard to those types of blood draws in testing for alcohol with regard to alcohol wipes being used?
this is a pathologist lens, and good to see you. Thanks for coming. So he's a pathologist. We jumped to the wrong conclusion thinking autopsy, because we just heard from the ER physician who treated both John and Karen, or at least whose name is on the documentation for both, since he was the attending. We believe now that we jumped to presumably the right conclusion that he's here to testify about testing Karen's blood draw for alcohol. But we're not there yet. We're just about how do you draw a blood sample for alcohol and what swabs you use to sterilize it. Not alcohol.
My phlebotomy supervisor has removed essentially all, not 100%, but all of the alcohol swabs down in the emergency room. So a phlebotomist who perhaps could forget, which they shouldn't, because we have competency policies for them. So we have that in place where she's removed almost all of them so somebody can't mistakenly use a swab down in the emergency room.
Okay, so keep your voice up again, please, doctor, especially at the end of your sentences. Thank you.
And so, doctor, the removal of those alcohol wipes from the emergency department of Good Samaritan, does that predate January 29th, 2022?
It's been in place for a long time. Before that, there was a policy they would use betadine for swabbing, but that policy has been in place for a long time, and before that day of 2022.
You've spoken a little bit about as far as phlebotomists working within Good Samaritan. If you could just explain to the jury sort of what is a phlebotomist and what is it that they do?
A phlebotomist is any person who is trained to draw your blood when you come to a hospital.
Medical vampire.
We train people to draw the blood.
A vampire.
And as far as with regard to phlebotomists at Good Samaritan, you mentioned that there's some proficiency testing or some protocols that they have to adhere to. Can you explain that a little bit more to the jury as far as what's involved in those?
So with anybody who works in the laboratory, per CAP checklist requirements and the government's requirements, there has to be competency policies and assessments on anybody who works in our laboratory, including phlebotomists. So any new phlebotomist, they get an initial training, and they'll get a training, and then they have to be assessed to make sure that they know what their job.
I've lost a lot of good phlebotomists that way, Grey Duck. Damn blood drinking vampires.
What they need to do for their job, including knowledge of all policies. Then after that, after initial training, our competency policy states that we need to assess them again at 6 months. We do the same thing, make sure they know what they're doing. And then 6 months from that, so that's a year from when they started working for us, and then annually thereafter. So the CAP is, we have all these competency policies for everyone to make sure the lab technicians know what they're doing. We also have competency policies for pathologists as well. So it's all about making sure the final result is that comes from our lab is a good quality.
May I approach the witness?
Yes.
I guess luckily they just take urine tests for my medication. Still degrading, but
I'm showing you 2 sets of documents. You can just look at those and
Okay.
And just in general, do you recognize what those are?
Yes.
And what do you recognize those?
There are two of our policies that we have for Good Samaritan Medical Center, one for the phlebotomist, one for our laboratory technicians. The first one is a patient preparation for specimen collection policy, which defines our policy for drawing the blood for the phlebotomist. The second is an alcohol policy, which is one of, I don't know, thousands of policies that we have in the lab to describe how our policy for alcohol testing. Every laboratory test in our
Grey Duck, are you Brandon in disguise? Are you Brandon Zalt?
in our hospital has a separate policy.
Well, everything from hematocrit to sodium to potassium chloride has its own policy, is that correct?
Correct.
And the policy you have before you, that's for alcohol testing?
Correct.
And those two policies that you have before you, were those policies, what was in place on January 29th, 2022?
Correct. Yes.
May I approach January?
Okay.
Almost seek to introduce in a minute the next exhibit.
Any objection?
Okay.
All right. So, Madam Court Reporter, I don't think we marked SS into evidence. Do we have that ready to go into evidence?
I don't believe so.
All right. So these instead, Madam Court Reporter, will be the next two exhibits.
They're massive cup-shaped needles, CJ5. Just huge. They'd really hurt to get stuck with. They're blunt too. And it's funny, Vince, when your brain is expecting something. So phantom pain, I've talked about a little before, how it's awful. Like, absolutely awful. Terrible. Wouldn't wish it on Karen Reed. Probably wouldn't even wish it on Turtle Boy. But one of the weird things about phantom pain is that certain bodily functions can cause certain sensations in my non-existent foot. And like, let's say walking to the toilet to do those bodily functions, my non-existent foot will start feeling those sensations in anticipation. And it's weird, and I don't like it.
Thank you. And what is 107, Madam Court Reporter?
I believe 107 is in reference to excuse me. I believe 107 is in reference to the alcohol testing, and 108 would be in reference to the sample collection.
All right, thank you.
May I approach the witness?
Yes.
I'm just showing you a document as far as some medical records. Are you familiar with those records?
Yes.
Those records are in relation to a patient named Karen Reed that visited the Good Samaritan on January 29th, 2022. Is that correct?
Correct.
Now, with reference to, may I approach again, Your Honor? Just
Yes.
Sure.
your attention to a previously tapped portion of those records. Do you see a result for alcohol within those records?
Mr. Lally, you have to keep your voice up when you're hearing something.
Let me say it again, sir. Doctor, with reference to those records and the page that I've opened up to, do you see a record in regard to a lab results for alcohol testing with regard to Ms. Reed?
Yes.
And what is it reported as, sir?
It is reported at 93 milligrams per deciliter.
And is that, as far as milligrams per deciliter, is that a relatively standard way of reporting an alcohol result?
Yes, it is in our hospital systems.
Could you explain to the jury sort of milligram per deciliter what that reading means as far as the metric that's used there?
Well, it means 93 milligrams of alcohol per deciliter of the blood.
And as far as, if you could explain to the jury sort of the testing process or the protocols that are in place of the Good Samaritan? So the blood is drawn by the phlebotomist, and then what happens from there as far as the testing?
Okay, so
Before you do that, Doctor, so we might have to turn off the fans, which we don't want to do. I really need you to keep your voice up so that the court officer over there, so that folks down there can hear you.
okay, so at Good Samaritan, I can go through the process. The doctor will order the test in the emergency room. We have 2 phlebotomists down in the emergency room. That test will print out, the order will print out down in the emergency room. And it will.
So I'm not seeing a direct conversion, but 93 deciliters per milliliter or per deciliter, 93 milligrams per deciliter. Like what I'm looking at says 50 to 100 milligrams per deciliter. Clinical signs and symptoms would be euphoria, sedation, impaired coordination, decreased sensory responses to stimuli, decreased judgment. So it sounds like drunk.
Print out a label for the blood tube. It will print out on that label the color of the blood tube to be ordered, and we'll also print out what on the label what is to be tested in our lab. So that order will be seen by our phlebotomist in the emergency room. They will then locate the patient.
And you weren't here when we discussed it, Linz. HIPAA exists, but there are a lot of exceptions to it, and prosecution is one of them. So at least to a certain extent. So it's coming in. It's coming in.
And perform the veni puncture or the blood draw and use a correct tube. They'll go through the process of one of the most important processes in testing somebody's blood is accurate patient identification. So within our policy, we ask the patient to state his or her name, first and last name and date of birth. We have them say it out loud to make sure we have 2 forms of identification. Once that's confirmed, there's also a bracelet on the patient, so we'll match it up with a Good Samaritan ID number. So the first step is to make sure we have the correct patient. So then the phlebotomist has the order in front of her or him and uses the correct tube. Before drawing, they have to find the correct vein, a good vein for the patient, which is usually in the forearm antecubital fossa area. They will find that vein. They will
and just further looking it up, I wasn't sure exact, like 93 milligrams per 100 per deciliter or per 100 deciliter, whatever it is. I assumed that's 0.093. I just wasn't positive that was the conversion because, it is. So 93 is 0.093. So legal per se limit to drive. One of my pet peeves is when people say 0.08 is the legal limit. And it's like, no, it's not. No, it's not. It's the legal limit for what? It's the per se threshold where whether you're impaired by it or not, you're legally drunk. Too drunk to drive. But for stumbling home, 0.08, it's not, it's not illegal. At some point, it might be public intoxication. For being home, 0.08 certainly isn't illegal. But 0.08 is the per se threshold where you're legally too drunk to drive. Except in Utah, where it's 0.05. If you're one of those people that can't handle alcohol, if you're intoxicated at 0.04, you're intoxicated and you can still get a DUI, even though you're not over the per se limit, you're intoxicated. And that's the standard. So if you'd fail the field sobriety tests at 0.04, you can still get hooked up. the jury might not convict you, but you can still get hooked up. Legally, you still can be guilty of a DUI at 0.04 because you're intoxicated, you're impaired. Whereas you might be one of those alcoholics that in order to function, you have to be at like a 0.15. And you're not impaired until 0.2. I mean, how you're still breathing at that point, if that's your baseline, or how you still have a liver, is beyond me, but that doesn't matter. Because even if you're not physically impaired until 0.2, you're above 0.8. Therefore, the per se limit, you're guilty. But yeah, so she at 7 or 8 in the morning, 0.93 or 0.093, sorry. 0.93, she'd be dead. But 0.093 BAC. Once again, okay. Let's, building our Sublime Sun logo right there. Building that puzzle, that might be the nose or the eye piece in that puzzle piece. Or there's still the potential defense. I drank, 5 shots of whiskey when I returned home at 1 o'clock. I was, I didn't hit John, but even if I did, I wasn't drunk when I did. It was an accident. And even if I was drunk later. I became drunk between the period that I didn't strike John and the blood test. So there's still that defense. Whether the jury believes it or not is up to the jury. But we're building our puzzle. So this is an important piece. Not for the second degree murder, but for the DUI manslaughter.
Cleanse the area with a non-alcohol swab, which in this case was the order was for
All
alcohol.
right, so doctor, I'm sorry. I'm going to stop you. I think part of it is that you're saying so much and your voice is fine and then it drops and it's fine and then it
Okay.
drops. So Paul, can we turn the fans off, please? It's important that all the jurors hear everything you say, doctor.
Yeah, sorry.
Okay, so but speak into the
Okay, I'm
microphone.
going to bring it really close.
All right, this
So-
should be better with
And hopefully you can turn it back on when I get better at this.
Now he's clipping.
So, I'm sorry. It's hot. I'm hot too.
Take off your jacket.
One is we make sure that it's correct patient identification. We use the correct tube. We draw it. We don't use an alcohol swab. We use one that doesn't contain an alcohol in that. Then the phlebotomist will then put the labels on the tube or tubes in front of the patient, then bring it back to his or her area. Make sure they sign their name they initial their name on the tube as well as the time. Then it will be put into a bag, and in the emergency room it goes through a chute and it goes directly to our laboratory for testing. Once we get it, it's called receiving the blood work. A technician, a lab tech in our lab will scan, there's a barcode on the label, they'll scan it and that will document the time that we received it. They will also manually enter the name of the phlebotomist and the time of the blood draw, so we have accurate records of what we received and the time. Once that's done, it's entered into our system. And then the technician will decide what needs to go next. In this case of an alcohol test, we're using a green top tube, which has lithium heparin, has an anticoagulant in it. It's to prevent clotting. So we'll get that tube, and once it's entered, we will centrifuge it, and that is centrifuged for about 10 minutes or so, so that we can separate the layers of the blood. In the blood, when you first see blood, it's all red. There's no separation of the elements. But within blood, there are red blood cells, there are white cells or inflammatory cells, and there's the liquid portion of the blood. So for alcohol testing, we there's an anticoagulant in it, and so we will centrifuge it to separate the different layers of the blood. The different layers, the red cells will go to the bottom, and the aqueous portion or the plasma portion will go to the top. And when we test for blood alcohol in our lab, we're testing the aqueous portion of the plasma portion of the blood. So that's why it's important for us to centrifuge it and separate the components. Once that is done, that takes about 10 minutes or so, maybe a little bit longer. Then that tube will be brought over to our machine, which is a Roche Cobas machine, and it will be put onto the machine, and that machine will test for the alcohol or whatever else is ordered on the patient. I think I covered everything.
Now, with regard to, you used the term a couple times as far as centrifuge, can you describe to the jury sort of what that is and how that instrument works?
Sure. So when the tube that we take is a blood tube, and
It's a spinny tubey thingy, the centrifuge.
we want to test the aqueous plasma portion of the blood. And the only way to get that plasma portion or the watery solution of the blood is we put it in a centrifuge, which will spin the blood at a rapid rate, something like 3,300 RPMs or so, which is fast. And it will separate the blood into those three layers. Also in the tubes that we use is a gel that comes in the tube, and it nicely separates the red blood cell component from the water or aqueous plasma component. It keeps those two portions of the blood separate to make it easier for us to test on our machine.
Now, as far as the blood testing is concerned, is there a difference between sort of what's known as whole blood versus serum and plasma?
There is a difference. Whole blood is basically the whole blood. When somebody has a test drawn, and if we test something on the entire blood without separating it, that would be whole blood. If we say we're testing on plasma or serum, we're actually separating the components of the blood by the centrifuge process.
Which of the two, as far as serum plasma versus the whole blood, which would record as far as a higher percentage of alcohol in the testing?
Alcohol, the answer would be plasma or serum would have a little bit higher.
I mean, he'd be watching past episodes, so at least I'm not giving him contemporaneous advice. In which case, that would be go fuck yourself, Unetti. But yeah.
Blood alcohol content compared to whole blood.
As far as the separation that you're talking about, is there a specific area as far as the separation is concerned?
I mean, no change to her resting bitch face every time they're talking about Johnny being dead, finding Johnny in the snow, talking about her blood alcohol content. Yeah, she's not a happy camper. She's got a frowny face, not just a resting bitch face right now. So yeah.
Concerned where alcohol tends to concentrate within.
Yes, alcohol tends to go into the more into the watery or the aqueous component of the blood. So when we like serum or plasma has a 98%, reportedly 98% water component. Whole blood, if you look at the whole blood overall, it has a lesser percentage. If you look in the literature, it can be 86%, or there's a range. But so since alcohol tends to go to the watery components, if you measure alcohol like we do in hospitals on the serum or plasma, the value that we get will always be a little bit higher than total, than measuring on whole blood.
Aware of, through your training experience, sort of a conversion that can be done between sort of what's reported as a testing from serum plasma to a whole blood count?
In the hospital, we're pretty much in the business of,
So is BAC, is that off of the serum, off of the whole blood count, or is that measured off of just the aqueous portion?
Reporting alcohol, in serum or plasma, and we're not in the business of the legal aspects of alcohol testing, because alcohol, what I understand is the alcohol legal limit in Massachusetts is 0.08 grams per deciliter. We don't make any conversions in a hospital. We're not in that business to do that. We just report on the serum percentage or the plasma level, and we don't make any attempts to do any official conversion to a whole blood level. If we did, we'd have to validate, we'd have to do many studies, and we're just not in the business for that.
And I understand that's not how it's reported within your record or at your facility. What my question is, are you aware of a process by which you can sort of then mathematically convert from milligrams per deciliter to a gram?
I am aware of that. Recently, I had to read about it, but up until recently, I was not aware. Not in that we're not in the business for whole blood. But there is a formula. I do know about it, and it's there is a if one wants to convert a whole a serum or a plasma level to a whole blood, there are formulas that basically you need to. It's a simple formula, but there's a.
And that's my guess, Anne. That's my personal feeling. But once again, the defense is going to say, so what if she was drunk? She got back to Johnny's place and she drank, as is her legal right. She got in an argument, left him at a party, drove home, and then got drunk. That's going to be their argument. That's the argument I'd make. Whether they have evidence, whether they're able to show that, whether they're able to refute anything, I don't know. But that's the argument I'd make. That's the argument I'd make. So,
varying opinions on which formula can be used.
Now, as far as this specific patient, the defendant, Ms. Reed, do you have any sense from the chart in front of you as far as sort of the timeline of when the blood was drawn to when it was tested and reported and things of that nature?
I think it was the order was 9:03 in the morning. 5 minutes later, the phlebotomist. It happened pretty fast. 5 minutes later, the phlebotomist got the labels printed. Then 5 minutes after that, they went in and drew it. It was very quickly. I don't have the numbers in front of me, but ultimately, it was received in our lab, I think, 10 minutes after the order, the blood, very quickly. And then the final result, when the alcohol level was reported in the computer system, was, I think, 50 minutes from the time of.
Well, what they're going to do, I bet, is, let's say it's Trooper Proctor that is testifying about, yeah, we had them draw her blood because we thought she was drunk, or whoever, I don't know, whatever, just hypothetically. On cross-examination, I'd say, do you have evidence that she consumed all this alcohol at the waterfall? No. Do you have evidence she consumed it at CF McCarthy's? No. What evidence do you have as to the amount she drank while she was out on the town with John? I have receipts of 2 vodka sodas, whatever. So, do you have evidence that she didn't consume multiple drinks after returning to John's house? No. Do you have, any information whatsoever about when she consumed drinks? No. Do you have any evidence that, what evidence do you have that she was actually impaired at the time she was leaving 34 Fairview? Do you have evidence that she didn't become intoxicated after leaving 34 Fairview? So basically, I'd try to cross-examine someone about that. someone. I don't know who. I don't know who, but someone. So, and that's it. It's another brick in the wall. They're building the case. They're putting that puzzle together. And we don't have 9 drinks on video in evidence yet. It might come into evidence, but it's not in evidence yet. If they do get that into evidence, though, that's pretty good evidence, you know, based on her size, that she was smashed. And, you know, even if she didn't drink another drop after she returned to Johnny's place, you know, based on her size, 9 drinks, she very well could be 0.09 the next morning at, you know, 8 in the morning, 9 in the morning, whenever. So, but once again, we don't have that in evidence yet. And that's it. All we have so far in evidence is she was drinking something. We don't know what it is yet. And she brought one of the drinks from C.F. McCarthy's to the waterfall. But that's all we have so far. I assume they have receipts. I assume, you know, the bars do a good job of tracking, and, you know, receipts are business records kept in the ordinary course of business. So presumably they can get those in. But I don't know. I seriously don't know what to expect, because, as I've said, I do not know the evidence other than what's been presented in court, because I'm a juror who happens to be a lawyer.
The order.
May I approach?
Yes.
Okay.
That'll show her. And there is that. You know, there are people that bring the flask in. Here in Utah, that's pretty illegal. I assume it is most places, certainly against the rules of most bars. But here, licensed premises, you do not bring your own, because that's going to get you in trouble. That's going to get the premises in trouble. It's just bad all around.
And that lab results done pursuant to the testing and policies and protocols and everything in the lab was 93 milligrams per deciliter. Is that correct?
Correct.
Thank you, doctor. I have no further questions.
Cross-examination?
Good afternoon.
Good afternoon.
You testified that, hospitals are not in the legal business of calculating the BACs. Do you recall that testimony?
Yes.
And you'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are done in labs, correct?
Correct.
And the purpose of testing in sort of a clinical setting at a hospital is to assist in the quick diagnosis and treatment of a patient. Is that right?
Yes, correct.
And so your priorities may be different than those if you're at a forensic lab where the goal is to ensure accuracy and reliability at all costs, correct?
I don't agree. Not correct.
Well, hospitals use serum tests to screen for the presence of alcohol, correct?
Correct.
And you'd agree that serum testing does not measure alcohol directly, but it actually measures the presence of NADH.
Correct.
And NADH is the byproduct that's created when the body breaks down alcohol.
Correct.
And the reason hospitals use a serum test rather than a whole blood test is because it's quick and efficient and you can get test results within 20-ish minutes. Does that sound about right?
Correct.
And you'd agree that NADH, which is what's...
He didn't like that, but it was technically correct. He did not like it.
serum essentially tests for can also be elevated by factors other than alcohol in the blood.
I'm not aware of that.
Are you familiar? Are you familiar with any medical literature that has found that NADH is created when the body has elevated either lactate or LDH in the system?
Correct. There are some issues, in our policy. There are some factors that can lead to falsely elevated or falsely lowered serum alcohol. One is lactic acid or LDH. Another one is Waldenstrom's macroglobulinemia, which is a hematological problem, and other things that can interfere with not just any tests or lipids, high levels of lipids, or hemolysis, or high levels of bilirubin. But our machines are very sophisticated now. If there are any elevations of, let's say, hemolysis or lipids or bilirubin, the Roche machines will detect that and flag it as a possible interference, or it won't even let us resolve the test. So with any test, there can be interferences, and I'm sure there can be interferences with the forensic way of testing as well.
All right, so there are other causes of high levels of LDH and therefore NADH also include things like trauma, muscle weakness and loss of muscle tissue, or abnormal tissue formation. Is that correct? Have you read studies about that?
I haven't read those studies, no.
Would you agree that there may be other sort of medical stressors or things that can't necessarily be captured by the technology, but that could cause error in testing?
I don't understand that question.
You missed my fabulous pun. That's what you missed.
Well, you testified that there can be certain errors in testing. That's something that we see throughout all different types of sort of scientific literature, which includes.
And I accused Grey Duck of being you on using an alt because he made a terrible joke as well.
Yep.
And there are certain sort of factors that could cause a higher level of NADH that might not necessarily be picked up by the machines that you use in the hospital. Is that correct?
I am not familiar. I mean, if there is, it's not not a common phenomenon. Our methodology for doing many tests are based on this NADH enzyme methodology, and we've never had issues with it. I read a lot. I haven't read about major faults of our methodology for testing. Most hospitals, when we look at when we actually have to do proficiency testing with any test that we do in a hospital. So 3 times a year we get sent unknown levels of alcohol and 5 samples to be accurate 3 times a year, and we're able to look at not only our results, make sure they're correct, but we're able to look at how, what other hospitals are doing across the nation. So when I last looked.
So are you saying that Disney isn't going to take my Mikey Moose character as flattery? Back to the drawing board for me, Mickey. I mean, Mikey. And Jackson is in California today. He had to go home, hopefully forever.
And it's held true for over 10 years, maybe 20 years, is that of the, I think, 5,000 hospitals that are testing for alcohol, it's over 80% of them are using our methodology, which is the alcohol dehydrogenase and NADH. And I can't imagine why if there were any major issues with alcohol testing using that methodology, why would it wouldn't be that high of a.
As you testified, the goal in a clinical setting, obviously, is to test for the presence of alcohol, but you're
Don't interrupt him.
not in the business of trying to sort of calculate BAC, correct?
No, we don't. We don't.
So your goals are to make sure that you're screening for the presence of alcohol, but you're not quite as concerned with the precise amount that you might see in, for instance, a whole blood test in a forensic lab.
Well, we result in terms of in the serum. We know the Massachusetts laws and laws across the nation are based on whole blood, but there are in the literature formulas that you can use if it were a medical legal case that one can use to convert our level to blood alcohol. We don't do it in a hospital. We won't report a serum alcohol and then we don't do the conversion, but because it's a very rare event that that a level will end up in court. But
I agree, says Karen Reed. I agree. You don't do the conversion. This is what she reacts to. She sits stone-faced through everything else, but this is what she reacts to.
But there are forensic lab people that can provide that formula.
And when you get a test result from a serum test, that information does not establish when alcohol was consumed, correct?
Correct.
And so you're just
Hey, see, like, I want to ask the cop who, but doesn't say when it was consumed, just that it was. She could have consumed this at 4 a.m, couldn't she? Sure.
looking at a specific point in time to say this is what the serum test reflects at 9:08 a.m. on January 29th.
Correct.
Thank you. No further questions.
All right. Mr. Lally, any follow-up?
Just briefly. As far as the interferences or anything that would lead to elevated levels from your review of Ms. Reed's chart, was there anything like that present there?
I didn't see anything, no.
And the interferences would be accounted for in the sense of the machine would sort of vet them out and not result or not recorded in a chart if that were to occur. Is that correct?
Objection, Your Honor.
The form of the question, I'll sustain the objection. You can ask it differently.
Sure. Dr. Fowler, with regard to the interferences that you were talking about, what, if any, impact would that have on the results being reported?
If there were 3 major things that could interfere with the result, like high lipids, hemolysis, or high bilirubin, our machine would flag that, and we would have some information that
Okay, I thought this would be a shorter redirect, so I was waiting to get to Brandon's question, but yeah, I mean, the jury, like, if the evidence isn't there, but they just look at her like, oh, she's ugly, let's convict. That's inappropriate. That's inappropriate. But if her demeanor is something they can observe in court. If she gives a visible reaction to testimony, sure, the jurors can consider it. Sure, it's they'll be instructed basically, the testimony you heard is what's evidence. The attorney's questions isn't evidence. But you can make reasonable inferences based upon that evidence, and sort of those reasonable inferences are taking into account the jurors' common knowledge. Water's wet. Snow is cold. The sea is wet. They don't have to hear testimony. They can make reasonable inferences from that. But they can also make reasonable inferences like, boy, she jumped out of her skin at that response. Such a visceral reaction makes me think she did it. Something like that. And that's it. The defense is trying to, unbalance the witnesses with their cross-examinations. That's one of the reasons Jackson comes out breathing fire on this first question. He's trying to trip them up and, get them to stutter, get them to hesitate, and, you saw, you saw how uncredible the witnesses were. They couldn't answer my questions. They, an honest answer, you don't have to stop and think. They had to stop and think for every question because I put them on the defensive. So, but there is that. She's reacting to this. She sat stone-faced through all the testimony about finding John, about the rescue efforts, about the party, about their relationship. But this is what gets a reaction. It's very possible the jury has noticed this, that this is what melts her stone face. And that could be a problem for her. It might not be either. It might not be. The jurors, they might think, oh, she's been coached not to react. She's fighting really hard to mask her emotions. And with this witness, she wasn't expecting she'd have to, because they're not talking about Johnny. They're talking about her, so she wasn't masking. The jury can think that. I'm not saying they are, once again. I'm just playing devil's advocate. I'm still going to be accused of being biased and worst attorney ever and yada yada, but I'm trying to point out both sides. Which side I feel. If I'm sitting on the jury, I'm on the side of, oh, this is what gets you to react. But once again, other jurors, other people might see it differently. So, see, I'm a great poker player, Pat's Cats, because once again, I'm undiagnosed, but the ADD is absolutely there. I can sit there while my friends play poker and bullshit with them, but as soon as I have to sit down and play poker, I'm fidgeting and going crazy. And frankly, if the buy-in is little, I intentionally go bust pretty quick just because I get bored focusing on the poker. But because I'm not paying attention, I have a great poker face. Because Clueless is a great poker face. And the one where Dale sues the tobacco company, that is a great court case. All time great. God King of the Hill is brilliant.
Result may not be valid, and sometimes we will report a result with a disclaimer, or sometimes if those levels are so high, we won't report it at all. But in this case, there were no flags.
Nothing further on.
Anything, Ms. Little, or are you all set?
If I could have one moment, Your Honor.
Sure.
No, you may not. Surprised they don't have Larry Foreman sitting up there asking for immediate pro hoc.
Right, this one over here. No further questions.
All right, Dr. Fowler, thank you, and I'm sorry I gave you such a bad
Oh, okay, I'm so
voice.
sorry. Thank you.
Thank you.
Is he? I didn't notice him, but I haven't
Your
been
next
looking.
witness, Mr. Lally.
Yes, Your Honor, the Commonwealth will call Mr. Nicholas Roberts to the stand. Your Honor, may we approach this while the witness is coming in?
Yes.
If he's there, is he with the Reed family, or did he actually sign up for a media pass properly this time? And I mean, we need bench conferences. Come on. We can't have the judge call them out in front of the jury. Oh my God, Karen, is that a zit on your nose? How embarrassing for you. How embarrassing. And that's always possible.
Muted.
You so much for the evidence given to the court and jury in the case now hearing.
I mean, that is what a lot of the free Karen Reed crowd has basically argued. I have reasonable doubts right now, therefore she's factually innocent and the case must be dismissed. Even though reasonable doubt standard is after the prosecution has presented their case, not during. And frankly, I wouldn't know. I have no idea.
The truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can have a seat. I just need you to keep your voice up very loud. If you're too soft, we're going to have to turn off the air conditioning. Everyone's going to get mad.
No problem.
All right, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good
All
afternoon.
right, the logo is something scientific. Can't read the red, but the white is scientific. So, yeah.
Afternoon.
Would you please state your name and spell your last name for the jury, sir?
Sure, my name is Nicholas Roberts, Roberts.
And what is it that you do for work, sir?
I'm currently employed with a company called Thermo Fisher as a field service engineer
All right, Thermo
And how long
Fisher.
have you been doing that?
since November of last.
And once he said it, came into better focus. Thermo Fisher Scientific. Thermo Fisher. Fisher.
Year.
And so prior to that, or prior to November of last year, 2023, where did you work before that?
I was in the Massachusetts State Police Crime Lab in the toxicology unit.
And how long did you work in the toxicology unit at the Massachusetts State Police Crime?
Since October of 2014.
All
Now, if I
right.
could-
So, State Crime Lab. This is an important witness. Is he going to be the crime lab analyst that picked up the blood samples? Not Karen's, but the red Solo Cup blood samples and transferred them into proper storage containers in the Sally Port. It is, or is his role in the state crime lab something else? Did he do the analysis? There's a lot of stuff we can have, but either way, important witness.
Could turn your attention to prior to joining the lab for the Massachusetts State Police. Can you talk a little bit about your educational background? Where did you go to school and what did you go to school for?
Sure. I have a bachelor's degree in applied forensic science with concentration in chemistry and toxicology from Mercyhurst University. That's in Erie, Pennsylvania. And then I also have a master's degree in forensic toxicology from the University of Glasgow in Scotland.
Oh,
Now, after receiving your degree from the University of Glasgow in Scotland, where did you go from there?
too bad Neil Morrison isn't in here. He was in here at the beginning, but I mean, Glasgow's a bit farther north than I was, but just the same. Go study abroad. Master's degrees abroad. That's the way to do it.
I returned home to the British Virgin Islands, where I taught at a community college.
And what did you teach there?
Mainly chemistry and a term or two of physics.
And then following your teaching in the Virgin Islands, where did you go from there?
I was hired in at a Mass State Police Crime Lab.
Now, when you're initially hired at the Mass State Police Crime Lab, you're working initially as a forensic scientist 1, is that correct?
Correct.
And can you explain to the jury sort of what your duties and responsibilities are, what your work looks like as a forensic scientist 1?
So a forensic scientist 1, you're essentially going through all the trainings that they provide at the lab. We do a number of different testing, mainly on blood and urine, looking for the presence of drugs and alcohol. We also do serum conversions and retrogrades. So during your training period, I I started as a
At 1 1/4, the U.S. Virgin Island accent is muted a little bit, but you still catch it a little bit. You get that island accent a little bit.
first one. So that went up until I was fully signed off to actually write reports that would be issued to ADAs across the whole of Massachusetts, in which I became a forensic scientist too.
And so what are the difference, sir, between sort of your work as a forensic scientist 1 versus your work as a forensic scientist 2?
So essentially, as a 2, you're essentially fully trained and you're able to do all the testing that we do in-house. You also are able to go and give testimony based on the reports that you write, whereas in a forensic scientist 1, you're still in that training process.
And did you work essentially as a forensic scientist 2 from that point in time till the time that you left the lab in November of 23?
Yes.
Now, with reference to while you're working at the lab, was there sort of an ongoing continuing educational component?
Yeah, so we would habitually receive articles based on different discoveries within the forensic field. So different ways they would find certain types of drugs in different bodily fluids. It's always a revolving door when it comes to drugs being discovered as well as being manufactured, what's illicit on the street, et cetera, et cetera. We would often get different articles, just research papers based on what they're doing to discover these things within the matrices that we were looking at.
Now, in addition to that, while you work at the lab, what, if any, are you familiar with the term proficiency testing?
Yes.
Or what, if any, proficiency testing would you undergo while you were at the lab?
So we receive both in-house and external proficiency tests. Essentially, the process would be just the same. The only difference would be we'd have internal people sending us samples as if it came from an external source. And then the external proficiency testing that we receive is actually part of our accreditation. So it came in just like regular samples, and we would test it accordingly per our protocols.
And as far as the proficiency testing that you undertook over the course of your time at the lab, did you pass each of those tests?
Yes.
Now, you mentioned a little bit as far as accreditation with regard to the lab. What, if any, accreditation did the Safe Police Crime Lab have?
We had accreditation. It's a internationally accreditation board for forensic scientists, as well as any kind of lab in particular, and the branch that our lab would fall under.
Especially since he speaks loud enough that the fan can be on.
We have a certain set of rules that we have to adhere to. Mainly it's a standard known as an ISO 17025, but we have a different accreditation board, and they have narrower requirements because of the type of lab that we are.
It may be pretty well understood, but that as far as the accreditation is concerned, that's done through an external entity, is that correct?
Yes.
Now, with regard to the lab, as far as your assignment of work, at the time that you left the lab, about how many forensic scientists were working within the lab in your toxicology?
By the time that I left?
Yes.
Oh. So within the toxicology unit?
How many degrees does Karen have? I don't actually know. Like, I understand, you know, they've talked about her being a finance professor, but they don't call her Dr. Reed, so I doubt she has a PhD. Does she have a master's or a bachelor's? What? I don't actually know.
There was one more when at the time that I left.
And as far as you and sort of the other forensic scientists too, at the time that you worked at the lab, was there some sort of rotation, or how were you assigned work as it related to your work in the toxicology?
So throughout my time there, we had more forensic scientists, 1s and 2s, and we would delegate each type of assignments that we would look for to different types of testing. On a monthly basis, we would get a different group of tests that we would perform throughout that month, and it would rotate to the next person as the month at the end of the month. So that's how we did the testing.
Sir, if I could turn your attention to May of 2022, you're working with the lab at that time, is that correct?
Yes.
Were you assigned to serum conversions at that particular time?
I was, yes.
And at some point were you specifically assigned to a case involving a Ms. Karen Reed?
Yes.
Now, as far as a serum conversion is concerned, if you could explain to the jury sort of what goes into that process.
I guess that is a job, if you can get it.
And what is it that you're reviewing or you're looking at? How is a serum conversion? What is it and how is it performed?
Sure. So with serum conversions, usually what happens is that we get hospital results. So So that would be the police or the ADAs would get results from the hospitals that whoever was attended to. We get the results, and usually hospital alcohol results they use serum in order to test alcohol. Serum is essentially the liquid portion of blood. Let's say, for instance, you fall and you cut yourself, that red stuff that comes out, that has serum within it. What the hospital does, they centrifuge it or spin it very fast in order to get the red blood cells, the white blood cells, and all kinds of the heavier materials out of that blood. And what's left is the serum. So they use that to test their alcohol. What studies have,
As Dr. Mumbles said, Dr. Low Talker,
shown is that we actually tend to have a higher alcohol concentration in serum than in blood. So what that means is that due to the chemical nature of alcohol, it likes to stay in that liquid portion more than throughout the whole blood. So a serum conversion essentially is able to convert the
get the burn unit in now, because that was a burn, Jennifer Ray. Youch.
alcohol content from that serum that we get from the hospital into what it would be in whole blood.
And did you have occasion to perform a serum conversion in regard to Ms. Reed's medical records?
Yes.
Okay, approach the witness.
Yes.
And that's what I believe they're getting
I'm showing you
to,
the document,
Vince.
just ask you to review that if I'm finished.
And I'm sure the cross-examination will be by Ms. Little, and it'll be exactly the same as the previous one.
You recognize that, sir?
Yes.
And what do you recognize that?
So this is the serum conversion report that I made, where the calculations were made on May 3rd of 2022.
And as far as the result that you received, in addition, so what kind of materials did you receive in order to perform that analysis?
We got the medical records.
May I approach the witness again?
Yes.
My apologies, Your Honor. If I could, it's looking for these. So I'm going to show you what's been marked as Exhibit 106.
I mean, I would if I'd consulted. And yeah, that would be the case. But so basically, though, I have a bachelor's and master's in finance, both from better schools than Taunton University, or Bentley University, sorry. She's from Taunton, went to Bentley University. I went to real universities. And then I have a law degree on top of it.
And directing your attention to this last page contained in this document here. Is that a portion of the medical records that you reviewed in regard to Ms. Reed's serum alcohol level?
Yes.
And if you could, what was reported in the medical records that you reviewed and using in your serum conversion analysis as far as the level?
The level was at 93 milligrams per deciliter.
I mean, like, my undergrad, University of Utah, very good school, very good finance program, all that stuff. Durham is a little harder to quantify just because the rankings don't directly compare somehow, but very good school. Like, overall, one of the best in the UK. It's just when you get into the global rankings, the UK universities focus on different things, so their rankings are different. But then grad school, I came back, went to University of Utah. So yeah. And I mean, certainly worked hard for mine, but if Bentley University gives them out, I guess, I don't know. I don't actually know Bentley University. Of course, that was my concern applying to Durham was like, I had never heard of it before. I Googled, Masters of Finance UK, and Durham was the first result. And so, like, I really had this worry that, like, despite everything I had read, it's just the University of Phoenix in England. They paid for that top Google search result. And like, I had concerns even as I was traveling to Durham. Like, I was at JFK transferring to the plane to London, and I was talking to some English people there in the airport, and I conveyed my concerns. I'm like, yeah, I'm concerned that Durham will take anyone, that, it's University of Phoenix. And she was probably 60 years old. She's like, well, they rejected me. So, and I'm like, oh, sorry.
And so with regard to that 93 milligrams per deciliter, I'm sorry, was there also a time that specimen was collected as far as your review of those records?
Yes,
And what was that time, sir?
it was at 9 in the morning, 9:08.
Now, as far as just in terms of the general term, as far as forensic science, what you did at the lab, can you explain what that term means, or what you did in relation to that?
What do you mean specifically?
That was very poorly phrased. Let me try to restate that. What is your understanding of forensic science, and can you explain that?
Oh, forensic science is essentially a scientific study based on anything dealing with the law. So whether it comes to ballistics or DNA analysis or toxicology, like I did, anything focused or based on the law or for legal purposes, essentially that's what forensic science kind of encapsulates.
And forensic toxicology, would that sort of be a subset of forensic science?
Yes.
And can you explain to the jury sort of what your understanding based on your training and experience, what is forensic toxicology?
So toxicology in general is essentially just a study of poisons, plainly speaking. So anything that'd be harmful to the body, essentially that would be toxicology, because you also not only have forensic toxicology, but you also have like environmental. And the forensic toxicology is just, like I said, again, with the forensic science, just basing it on things for legal purposes.
Now, through your training experience, are you familiar with sort of the difference between a serum plasma level versus a whole blood level?
Yes.
And can you explain to the jury sort of what your understanding is of each, and what, if any, differences there are between the two?
I think everyone is friends with the McAlberts, aren't they? According to the Free Care and Read crowd.
So just plainly your serum plasma level, or the serum plasma is what it's called. It could be referred to as either or one or the other. So that is just the alcohol level in your serum, whereas your whole blood is your alcohol content, or regular BAC in the whole blood. This difference between the two is, like I said previously, in your serum or plasma, that alcohol content would be higher as it would have been in the whole blood.
Conspiracy.
Now, as far as the milligrams per deciliter, how that's reported in the Good Samaritan medical records referencing this read that you reviewed in this case, is that typical as far as how hospitals would report sort of the serum plasma levels?
Yeah, from my experience and all the times that I've seen serum conversions come to the lab, milligram per deciliters are the units that they use from the hospital, yeah.
Now, as far as that 93 milligrams per deciliter, what, if anything, with regard to serum conversion, what, if anything, are you then able to do to convert that to a BAC or a blood alcohol concentration?
So, based on some studies, they came up with a few different conversion factors, knowing that the blood alcohol content would be higher than the serum plasma content. They're able to apply different conversion factors to the numbers that we would get in serum. And we usually get, we usually give a low, an average, and a high, being that it's kind of hard to say what one particular person's conversion factor would be between the two of them, since it's dependent upon like age, sex, the water content, what you had to eat that day. So it's harder to pinpoint, therefore we give a good range as what it could possibly be pertaining just in case a person converts, or their conversion would be a lot lower or higher. So we give a good range.
As far as those different...
Yeah, they don't need hot tubs. They've got the Virgin Islands with firefighters.
Conversion factors, where do those come from?
It's based on some studies. I don't remember the actual names of the papers that were thing, but they were based on studies throughout the forensic world when it comes to looking at specifically testing blood and serum to find that conversion factor.
As far as those studies are concerned, they come from sort of different population bases. Is that correct?
Yeah, so that's how they're able to get the range of conversion factors that they use.
Now, as far as the water within the serum or sort of how that works with the centrifuge, what, if any, relationship does that have to the reading that you get or the conversion factors that you use?
So the water content, essentially, if the serum being the liquid portion of the blood, water is also liquid, it makes up some of that serum that you get from it. Therefore, your higher water content, more essentially, the lower the concentration could be of that, or lower or higher, depending upon whether or not your water content in that sample is lower or higher.
So as far as those different conversion factors that you're using, this is essentially a mathematical calculation, is that right?
Yes.
And so the different conversion factors that you're using for the low, the average, and the high, what are those conversion factors?
So the low is a 1.18, with the average being a 1.14, and then the high being a 1.12.
So based on your analysis, as far as the medical records, what was reported to you, using those three conversion factors, what, if anything, did you come up with as far as the low and average and high for the 93 milligrams per deciliter?
So our values that were calculated for the low was a 0.078 gram percent. The high was a 0.083 gram percent, with the average being a 0.081.
Now, sir,
So basically, the conversion puts her right at the per se legal limit to drive. But her presuming her blood alcohol content has been dropping, that puts her considerably above 7 hours before, because the draw was at 8 o'clock, I believe they said. She presumably arrived back at Johnny's place about 1. So, you know, I don't know what the metabolism rate is over a 7-hour period, but she was drunk, presumably, unless she drank when she got home.
Reference to the alcohol that's reported in the records, are you familiar with, are there different types of alcohol?
Yes.
And can you explain sort of what those types are and what the differences are or where they come from?
Sure. So there are multiple different types of alcohol, mainly based on the number of carbons that are within that molecule. You start off with methanol, which is 1 carbon. Methanol you can find in like some rubbing alcohols. You can find them in many different labs. We have big, large vials of them. Ethanol, which has 2 carbons. That one is the common one that is in our alcoholic beverages. And it goes all the way up isopropanol, octanol, et cetera. It all depends on the number of carbons in the chain of it.
I wonder how many carbons octanol has.
And the type that's reported within Ms. Reed's medical records, that was ethanol, correct?
Correct.
And so,
So drinking alcohol was in her system.
with regard to your training experience as a forensic toxicologist, are you familiar with the term known as a central nervous system depressant?
Yes.
And can you explain to the jury what that term means and how it relates to alcohol?
Sure. So alcohol is what is classified as a central nervous system depressant, and essentially the name kind of gives it away as to what it does. Your central nervous system is responsible for essentially all your movements, both involuntary and voluntary. So the way you move your head, the way you blink, the way you breathe, the central nervous system is responsible for all of that. With a depressant introduced into the body, it affects that central nervous system, causing things to slow down. So that's essentially what depressant means. It's going to slow down certain processes that the central nervous system would be in charge of. So you can have delayed reaction times. It can cause drowsiness.
Ask another question.
How would that manifest as far as the central nervous depressant affecting the body?
Objection.
I'm going to allow it.
Go ahead.
There are many different effects that you could see, or side effects from having a central nervous system depressant in the body. Lethargy, sleepiness, drowsiness, unable to walk properly, any kind of any one of those tests that you see on TV from the police when they try to get your horizontal gaze and they try to make sure you're coordinated, it can affect all those things.
Now, sir, are you also familiar through your training experience of working in forensic toxicology with a term known as retrograde extrapolation?
Yep.
And can you explain to the jury what you understand that term?
So a retrograde extrapolation is essentially another calculation, but it allows you to be able to calculate what the possible blood alcohol content would have been at a time prior to when the blood was drawn. Say, for instance, blood was drawn at 2, you could essentially figure out what the blood alcohol content would have been at 10 in the morning prior to it.
And that's done with the calculation as well, is that correct?
Yes.
Now, what are some of the types of information that you would need to know or that you would want to know in order to perform a retrograde extrapolation?
We need to know, one, for sure, what the alcohol content would have been. We also need to know the time that the blood was drawn, as well as the time of the last alcohol consumption.
Now, in regard to timing, as far as what, if any, limitations are there in regard to performing retrograde extrapolation as it pertains to timing is concerned?
So when we do these,
So retrograde extrapolation, basically, what was her BAC when she stopped drinking, or what was her BAC at this time? So
calculations, anything that's shorter than 2 hours, we usually don't do that conversion.
And why is that?
Because we're built in within our calculations, we allow for 2 hours. That has to do with the way that alcohol leaves the body. If the alcohol is still being absorbed by the body, we want to give it enough time to get to a point where it's coming out of the body as opposed to increasing in the body. So that 2 hours puts the person at a point in which that alcohol will be coming out as opposed to it being absorbed.
they want you peeing, not drinking.
So there are essentially 3 different sort of phases as far as intake of the alcohol into the body through dissipation. Is that correct?
Yeah, we usually there's a well-known kind of metabolism route to which alcohol metabolizes out of the body. Yes.
And so can you describe to the jury sort of that metabolism process as far as how it starts to its end?
Sure. So with having, let's say, 1 drink, what the body begins to do at that point is absorb the alcohol. Usually you get like a steady line that increases with time. So if you think of a regular chart where you have the level of alcohol in the body versus time, which would be on the y-axis or the x-axis at the bottom, as time goes along, after your first drink, the body starts to absorb the alcohol. If that was your only drink and that was it, the body then at a certain point, it stops absorbing it because there's no more to absorb, and it plateaus. So essentially the line goes straight. After that point, the body starts to eliminate it at this point. And then your level or your concentration of alcohol within the body decreases with time as it's getting rid of it.
And so there's sort of the absorption phase, the plateau, and then the elimination phase. Is that correct?
Yes.
Now, you mentioned that in the course of your analysis for retrograde extrapolation, it's important to know sort of when the last drink was. Is that right?
Yes.
And why is
it? That way we can get a good time in and figure out the amount of time that has passed between the last drink as well as the time that the blood was taken.
Now, did you perform a retrograde extrapolation analysis with regard to Ms. Reed's BAC or the converted BAC from the serum conversion?
I did.
And so with reference to Ms. Reed, as far as...
And you'll notice, defense lawyer brain clicking on. One of the inputs into his retrograde extrapolation is the time of the last drink. When I get up to cross, I'm asking, how did you estimate the time of her last drink? That's one of your inputs. How did you estimate the time of her last drink? Well, the prosecution told me. Conspiracy.
You looked at obviously the hospital records.
And that's exact. I mean, I wouldn't conspiracy jazz hands, but I literally would ask, who provided you with that input? Are you sure she didn't drink when she got home? Are you sure she didn't stop at 3 a.m.? She must be lonely. How do you know?
You looked at the serum conversion report. What, if anything else, did you review or look at in coming to that retrograde extrapolation analysis?
We usually get a police incident report, and that usually identifies the time in which, per their narrative, what time in which they had the last drink.
May I approach the witness room?
Yes.
And you
So again, presenting you with
do have that, but once again, who's to say she didn't drink when she got home? Is the point I'd be trying to make. They can show she left the waterfall at 12:13 a.m. And that's going to be the input he puts. Something like that, 12:13, 12:08, whatever. But how does he know that's the last drink? There's a big time period where she's alone. She might have been drinking then. So this is going to be the input. The time she left the waterfall. That timestamp. But Ms. Little is going to ask, I would ask, like I said, I would ask, where did you get this input? How did you determine this input? It's one of the factors in your calculation. I absolutely did Kova, and I'm not a Matchbox 20 fan. I got their CD for Christmas back when that CD was relatively new, and I exchanged it for an MXPX album because I didn't care for Matchbox 20. Little did I know that was about the high point for the next 25 years of music, unfortunately.
Document, if you could just look that one up. Do you recognize that document, sir?
I do.
And what do you recognize it?
This is the retrograde extrapolation report that I did for the subject of Karen Reed.
Now, with respect to the time that you utilized in that report, as far as when was the time that you utilized as far as the last drink or time of operation?
And that's the thing, Anne. That's the thing. You concede. Yeah, she had one or two drinks. Big deal. One or two drinks, she's fine. Can you show me individual glasses? And once again, I haven't seen all the evidence. We've only seen snippets from C.F. McCarthy's and from Waterfall. I haven't seen 9 drinks. I'm not saying they can't prove 9 drinks. I'm just saying I haven't seen 9 drinks. But if you can't show the jury 9 drinks before driving, I'm going to argue, well, yeah, she drank after driving. So your input is flawed as to the calculation of her BAC at 12:30. So, but once again, you say I'm firing on all cylinders from the defense perspective. Don't tell the free Karen Reed crowd that. They won't be able to call me biased.
The time that was utilized as the last drink. It was at 12:45.
That'd be 12:45 a.m. Is that correct?
Correct.
Oh, I said 12:13, leaving the waterfall. They even gave her a little leeway because putting 12:45 actually is going to result in a lower imputed BAC, I believe, than if they had used 12:13. So, and that's it. I don't remember her giving an exact number is the problem, CJ5. And the barmaid was only from one of the bars, and I can't remember if she was Waterfall or McCarthy's. And if you can't remember how many drinks, once again, I want to see the receipts. If you can't remember how many receipts and you only hear from the bartender from one bar, you argue, well, yeah, she had 2 drinks. She was served a couple times, 2 drinks at one bar. In fact, she was drinking so slow that she brought her nursed drink from McCarthy's to the waterfall. See how slow she was? So.
And so you're using that to sort of extrapolate from 9:08 a.m. when the
manager of the Information Systems Division
Damn it, Vince.
of the Finance Department.
I think that was YouTube not liking my ad blocker. Because I certainly didn't click anything that would do that. I'm still blaming Vince. But
And essentially what your value was for your BAC.
And the time of the last drink, you'd want to know.
I'm still blaming Vince.
So with the minimum calculation, we incorporate the 2-hour period. So we assume that maybe at 12:45 wasn't, the body wasn't at that point finished with the elimination. It wasn't in the elimination phase, so we allow for 2 hours ahead of it. We also have a conversion factor. Once again, this is a study that was done to see the elimination rate of different people within a population, what rate they would get alcohol out of their system per hour. So we imply the lower limit, which was a 0.1 gram percent per hour. With that,
All right, I went a little.
That alcohol be coming out as
Estimated a little too far, so we're going back a little bit more because I want to hear this testimony, Vince.
Using for the low, the average, and the high, what are those conversions?
So the low is a 1.18, with the average being a 1.14, and then the high being a 1.12.
So based on your analysis, as far as the medical records, what was reported to you, using those three conversion factors, what, if anything, did you come up with as far as the low and average and high for the 93 milligrams per deciliter?
So our values that were calculated for the low was a 0.078 gram percent. The high was a 0.083 gram percent, with the average being a 0.081.
Now, sir, with reference to the alcohol that's reported in the records, are you familiar with, are there different types of alcohol?
Yes.
All
Can you
right.
explain
Nope.
sort of what those types are and what?
This we still need to go a few minutes ahead. We'll go right there.
To know, or that you would want to know in order to perform a retrograde extrapolation?
We need to know, one, for sure, what the
right.
alcohol content would have been.
This is good.
We also need to know the time that the blood was drawn, as well as the time of the last alcohol consumption.
Now, in regard to timing, as far as what, if any, limitations are there in regard to performing retrograde extrapolation as it pertains to timing is concerned?
So when we do these calculations, anything that's shorter than 2 hours, we usually don't do that conversion.
And why is that?
Because we're built in within our calculations, we allow for 2 hours. That has to do with the way that alcohol leaves the body. If the alcohol is still being absorbed by the body, we want to give it enough time to get to a point where it's coming out of the body as opposed to increasing in the body. So that 2 hours puts the person at a point in which that alcohol be coming out as opposed to it being absorbed.
So there are essentially three different sort of phases as far as intake of the alcohol into the body through dissipation. Is that correct?
Yeah, we usually there's a well-known kind of metabolism route to which they alcohol metabolizes out of the body. Yes.
And so, can you describe to the jury sort of that metabolism process?
We're on the right subject now, Vince, so I'm counting that as a win.
As far as how it starts to its end.
Sure. So with having, let's say, one drink, what the body begins to do at that point is absorb the alcohol. Usually you get like a steady line that increases with time. So if you think of a regular chart where you have the level of alcohol in the body versus time, which would be on the y-axis or the x-axis at the bottom, as time goes along, after your first drink, the body starts to absorb the alcohol. If that was your only drink and that was it, the body then at a certain point, it stops absorbing it because there's no more to absorb, and it plateaus. So essentially the line goes straight. After that point, the body starts to eliminate it at this point. And then your level or your concentration of alcohol within the body decreases with time as it's getting rid of it.
And so there's sort of the absorption phase, the plateau, and then the elimination phase. Is that correct?
Yes.
Now, you mentioned that in the course of your analysis for retrograde extrapolation, it's important to know sort of when the last drink was. Is that right?
Yes.
And why is it?
That way we can get a good time in and figure out the amount of time that has passed between the last drink as well as the time that the blood was taken.
Now, did you perform a retrograde extrapolation analysis with regard to Ms. Reed's BAC or the converted BAC from the serum conversion?
I did.
And so with reference to Ms. Reed, as far as you looked at obviously the hospital records, you looked serum conversion report? What, if anything, else did you review or look at in coming to that retrograde extrapolation analysis?
We usually get a police incident report, and that usually identifies the time in which, per their narrative, what time in which they had the last drink.
All right, and
And
I missed that part the first time. Probably Brandon's fault, not Vince's. But from the police incident report. So, like I said, I think 12:13-ish, because that's about when the video shows them leaving the waterfall. So, to me, that's the time I would have selected as the investigator, as opposed to 12:45.
Yes.
So again, presenting you with the document, if you could just look that one up.
That's it. That's why it was Brandon.
Do you recognize that document, sir?
I do.
What do you recognize it?
This is the retrograde extrapolation report that I did for the subject of Karen Reed.
Now, with respect to the time that you utilized in that report, as far as when was the time that you utilized as far as the last drink or time of operation?
The time that was utilized as the last drink, it was at 12:45.
That'd be 12:45 a.m. Is that correct?
Correct.
This
So
is
you're
where we
using that to sort of
were
extrapolate from
sabotaged.
9:08 a.m. when the 93 milligram per deciliter is reported from Good Samaritan to 12:45 a.m. Correct?
Correct.
Now, with regard to that 12:45 a.m., what if any difference would it make if it were a little bit off of that? Say it was 12:30 a.m. or it was 1 or 1:10 a.m. What if any impact would that have on your conversion?
So we tend to go by hours. So we kind of round to the nearest, I think, 15-minute interval. So a couple minutes or 10 to 20 minutes forward or behind of that 12:45, it wouldn't change the results by a lot, if any.
Ooh, where?
And similar to the serum conversion, is this done with different conversion factors as far as a low, an average, and a high?
So we usually just calculate a minimum and a maximum for the retrograde, and that incorporates some conversions as well.
Now, as far as the minimum versus the maximum, what do each of those sort of signify, or how do you come to those mathematical calculations?
So with the minimum calculation, we incorporate the 2-hour period. So we assume that maybe that 12:45 wasn't, the body wasn't at that point finished with the elimination. It wasn't in the elimination phase. So we allow it for 2 hours ahead of it. We also have a conversion factor. Once again, this is a study that was done to see the elimination rate of different people within a population, what rate they would get alcohol out of their system.
I would assume that includes height, weight, age, to try and average out the metabolism rate
per hour. So we applied the lower limit, which was a 0.1 gram percent per hour, with that 2-hour allotted time.
So 0.1 gram per hour minimum rate. That's best for Karen Reed because a slower rate of decline gives you a lower baseline starting point. They go with a higher decay rate, and it's a higher BAC at the retrograde estimate time. So, yeah.
Interval, and then we use the lower serum conversion number, the one that was converted on the lower end. We use all of that in the calculation in order to come up with the minimum. The maximum one uses the opposite. So it uses the higher converted serum conversion number with the higher elimination rate, using the full amount of time.
And these calculations or these conversion factors are all based on sort of medical studies that you reviewed in literature that goes into your training?
Yeah, all of it was part of the training, and they came up with those numbers prior to even when I was hired there. But it is based on multiple different studies in that, looking at that elimination rate.
And so from your calculations, when it came to the minimum with regard to the retrograde extrapolation, what, if any, calculation, what, if any, result did you come from with your calculations as it pertains to the minimum?
So the minimum amount that was calculated would have been a 0.135 gram percent.
And that's essentially reporting in a blood alcohol concentration, is that correct?
Correct.
And
That's
then with
drunk.
regard to the maximum, what, if any, result did you get from your mathematical calculations in regard to that?
The result was a 0.292 gram per cent.
Oh.
So that range-
Wow. Now that is quite a range. 0.13 to 0.29. That's drunk too. Look what I can do. Drunk. Assuming her metabolism is somewhere in the middle, she's let's make some bad choices drunk.
That you receive is a bit of a wide range, is that fair to say?
Yes.
And why is that?
So we base those calculations. They're based on that conversion that I did from the hospital results from serum, giving us a good range of values in the first place. But then we incorporate the retrograde extrapolation one, which uses a time factor, and that 2 hour difference using two different elimination rates that causes a wider span of values. And it's just so that it can encompass essentially anybody within the general population, that they would be somewhere in between that lower limit and that upper limit.
So
So
somewhere
essentially,
between.
from those mathematical calculations, anyone within sort of the general population with that result would be somewhere between the 0.13 and the 0.29, correct?
Correct.
Any approach just to retrieve your?
Yes.
Once again, that's assuming she stopped drinking at the waterfall and wasn't drinking at Johnny's place. Of course, knowing Johnny, he probably took Sharpies to his liquor bottles just to know exactly where they were.
Can I have one moment, John?
Yes.
Thank you, sir. I have no further questions.
Okay. Ms. Little?
Good afternoon.
Good afternoon.
You used a method called retrograde extrapolation to reach your sort of opinions and conclusions in this case, correct?
Yeah, it was a calculation.
And that means that you rely on an assumption that a trend will continue beyond sort of observable data.
So the metabolism is actually pretty well studied. So we know that that elimination rate, unless you introduce more alcohol into the system, it declines at that rate, and it's pretty linear.
Exactly. So in other words,
And how do you know more alcohol hasn't been introduced into the system? Boom.
certain assumptions are incredibly important for you to reach your analysis.
Sure.
And that includes sort of the timing of the very last drink that the individual had. Is that right?
Yes.
If your drinking pattern is sort of different than what you assume for purposes of your calculation, then you'd agree that your entire extrapolation would be incorrect. Is that right?
Yes, it could be.
And again, those assumptions sort of included the time of the incident, right?
Yes.
And importantly, the time of the last drink.
So those two will be what we use. It's the time of the blood draw as well as the time of the incident or last drink.
And your report acknowledges the testing that was used to obtain ethanol results in this case was not performed by the Massachusetts State Police Crime Lab.
Correct.
And for that reason, the report and those results do not fall under your forensic lab accreditation standards.
Correct.
The Massachusetts State Police, as you testified, is an accredited forensic lab.
Yes.
And so you're required to meet certain minimum standards in order to uphold that.
Yes.
And you'd agree that those accreditation standards are different from accreditation standards that, say, a hospital lab might have.
They can be.
And do you ever work on testing within the Massachusetts State Police Lab for serum tests or whole blood tests?
So we did test the blood and serum for alcohol content in it.
I mean, he could be taking notes, and it could be he's a loud typer, and so he takes notes on his phone during court. I don't know. I'm just you know, in his defense, that could be what he's doing.
At the Massachusetts State Police Crime Lab, yes.
And their typical protocols are to use whole blood tests.
We use whole blood or serum.
In terms of the machinery that's used with the Massachusetts State Police Crime Lab, you'd agree that the gold standard is gas chromatography and mass spectrometry machines.
Usually with a headspace detector.
I'll let him, go ahead, you can
Sorry.
answer that.
Usually with a headspace detector, yes.
And that would detect whole blood rather than serum.
No, it just detects any volatile substance.
But you'd agree that a serum test usually, as you testified, has a much higher level than whole blood.
Yeah, due to the nature of the substance itself.
And so you kind of have to go through this extra step of trying to extrapolate, okay, how do I convert this to get to whole blood?
So what we incorporated anytime we had a serum sample submitted to the lab for alcohol testing, we actually did the same serum conversion in order to figure out what the blood alcohol concentration would have been.
And that's an extra step that you have to take using conversion factors, correct?
Yep, that's a calculation.
You're not actually testing for ethanol in the blood, you're testing for an ADH, and then you have to do a conversion to get it to what a whole blood test would just automatically show you.
Yeah, so we get the serum level and then we convert it via calculation.
And typically in the Massachusetts State Police Crime Lab, you would do what's called confirmatory testing.
Yeah, so we have a screening method as well as a confirmatory test, correct?
And confirmatory testing means that you take two separate samples and you test both of those.
Essentially, well, our protocol involved testing in duplicate, but that's not always the case for the other drugs that we tested. We essentially have a screening test, which is one type of test, and then the confirmatory test would be a separate test, or sometimes even the same test, just rerun the sample again.
And the reason you typically would do two tests is to ensure that there's no error in the testing.
Correct.
And that acts as a fail-safe against false positives. You
Yes.
agree with that? And it also ensures that you're testing the correct sample.
Correct.
And in this case, obviously, you didn't conduct any of the testing.
Correct.
You're just assuming the accuracy of a single test that was performed by a hospital.
Gotcha.
Oh, no.
Yeah.
And so if the clinical results are invalid, then your extrapolation is going to be invalid.
Yes.
Do you have evidence that the
Now, we
clinical
discussed a lot
test was
about sort of serum
invalid?
testing and conversion rates. Do you recall that testimony?
Yeah.
And you'd agree that the precise conversion rate between serum ethanol levels and whole blood ethanol levels is almost impossible to accurately predict.
For each individual person, it would be difficult, yes.
And that's because the amount of water in our blood is scientifically impossible to predict with accuracy.
I mean, depending on how dehydrated you are, depending on if you're anemic, depending on, your white blood cell count. There's so many factors. So yeah, in one person, it can change minute by minute.
I'm not aware of any kind of test that would do that. So yeah.
Because individuals are different, right?
Yes.
And so the conversions that you use are based on averages from scientific studies.
Yes.
But you'd agree that in certain instances, people can fall outside of that average range.
Yeah.
In fact, a comparison of hospital serum alcohol levels, they range quite wildly. You agree with that?
Yeah.
In fact, you're aware that some studies show that a conversion rate from serum alcohol to blood alcohol can be as high as 1.59%.
I wasn't aware of those numbers, but yeah, it could range. That's why we give a wide range, and you could lie on the outskirts of either side.
And so that would mean that the actual blood alcohol content, once it goes through the conversion rate, would be much, much lower than sort of the average conversion rate that you relied on.
Yeah, it could be both higher and lower.
And that includes that range.
So she could have been at 0.06. Checkmate.
Range that you gave, right?
Yeah, it could fall outside the range.
You'd agree that the more imprecise an extrapolation is, the less reliable it is.
Yeah, you do have to base it on good. Your starting blocks have to be good. So you have to know the times in which the blood was drawn, the time of the incident, and essentially what your value was for your BAC.
And the time of the last drink.
I think irrelevant is what they're going for, or garbage in, garbage out, basically.
You'd want to know that?
So we would put that around the time Yeah, either the time of the last drink or the incident date.
And so the more sort of unknowns you're trying to account for, you'd agree the less reliable your end result is going to be.
It could be, yes.
And you'd agree that sort of the range you gave in this case, which was 0.135 to 0.292, that's a very, very large disparity.
Yeah.
Almost a sort of 120% swing.
Yeah.
That would be the equivalent of, for example, predicting a child is going to grow somewhere from 6 feet to 14 feet.
Objection.
Sustained.
Argumentative.
It's a very large number. You'd agree with that.
Yeah, there's a
Argumentative.
large range, like I said, due to the factors involved in the calculation. That's how it gets so large.
And that's because you're acting with a lot of unknowns in this case.
Yes.
But that's also why they give a minimum expected rate and a maximum expected rate and say, we would expect her to fall somewhere between these ranges. That's kind of the point of having a minimum expected and maximum expected. You absolutely can fall outside, but the probability of that being the case is small. I don't know what the probability is, but it's assuming it's a normal bell curve. You know, how many standard deviations off from the median, and, you know, assuming it is a bell curve and not, you know, skewed or whatever. I can't remember all of the, you know, skinny tailed, fat tails, you know, skinny bell, fat bell, all the technical names for them. My econometrics class was 15 years ago, so I don't remember.
Now, you testified that your retrograde extrapolation assumes that Ms. Reed reached the elimination phase of processing alcohol at or before sort of 12:45 a.m.
Yeah, we allow for, we start for the maximum at the 12:45, and then it would have been 2:45 for the minimum.
And so for purposes of your calculation, if Ms. Reed drank alcohol after 12:45 a.m. and before her blood was drawn at 9:08 a.m., your entire calculation would be invalid.
Yeah.
No idea. No idea.
No further questions.
Okay, Mr. Lally?
Straight, please.
And that's exactly what my argument was, Vince. That's exactly the point I was trying to make. There's so many unknowns that, yeah, you can use this rate equation, but if you don't even know the starting point for it, the starting time, how are you going to get a good result? She might have been drinking right up until 4 a.m. when she realized, oh, I haven't seen Johnny yet. Go search the house for an hour and then call Jen and Carrie. And remember, don't let the free Karen Reed crowd hear me, you know, hear about me making defense arguments here. Make sure they don't, because I wouldn't want them to think that I'm unbiased. You know, I wouldn't want them to think I'm pro Karen Reed. Just, you know, as I've said from the start, what I want out of this is justice. What justice looks like, I don't know yet.
So in this instance, Mr. Roberts, you're dealing with a time of incident that was known, correct?
Yes, it was given to me that it was at 12:45.
And as far as the BAC or the serum conversion that was coming from a medical record, so that was known as well at 9:08 in the morning.
The time that the blood was drawn, yeah, that was known as well.
Now, as far as the question you were just asked, if the defendant drank alcohol after 12:45, does that include sort of?
Once again, that was a hypothetical made up by Joe saying she started at 4 a.m. when she stopped drinking. That was my hypothetical, just to be clear.
Shortly after 12:45, or how long after 12:45 would it take in order to affect your calculations or your retrograde extrapolation?
It's hard to say where that would have skewed it. It would have definitely caused a different time frame, depending on how long after the incident or the reported last drink. If there was another drink in between there, it just shortened up the amount of time that would have been prior to the blood draw for sure.
What I'm asking is, would it have any significant impact, or would there be any difference if the last drink was, say, at 1 a.m. versus 5 a.m.?
So that'd be a 4-hour difference. So essentially that
So,
could,
yeah,
that could, given the
duh.
conversion rates, that would put the numbers very different. Yeah.
But what I'm saying is, so the 5 a.m. would significantly impact your calculation.
I'm sure it will be their all-time bestseller, though, Edwin, because I'm fucking gorgeous.
Correct?
Yes.
1 a.m., would that significantly impact your calculation?
No.
Okay.
You all set, Ms. Little?
If I could just ask one question. You said that you were given 12:45 as the time that you sort of based your analysis on. And to be
Yes.
clear, that was not something that was provided to you by my client, right?
No.
That was something that was provided to you from a police report.
Correct.
One question. You said one question.
All right.
That
Mr.
was
Adams, you are all set,
three.
sir. Thank you very much.
No problem.
Okay, your next
That
witness,
was
Mr.
three
Lally?
questions.
Yes, Your Honor, I'm about to call Mr. Michael Trotter to the stand.
Michael Trotta. So much for half days on Tuesdays. Ugh.
May stand in your face of court.
Raise your right hand. You solemnly swear the evidence of the court and jury in the case now against the truth, the whole truth, and nothing but the truth, so help you God. Yes. Thank you.
All right, Mr. Lally, whenever you're ready.
Good afternoon, sir. Could you please state your name and spell your last name for the jury?
Michael Trotta, Trotta.
And,
So the quick summary, JT Davis, that was the state crime lab estimating Karen's BAC. Basically, he converted what the pathologist took, estimated she was between, well, she was roughly 0.08 something BAC at 8 a.m. Doing retrograde analysis, it put her at between 0.13 and 0.29 at 1 o'clock when she stopped drinking. So, of course, there's, the defense was, well, how reliable were your inputs and your, blah, blah, blah. So that is the summary. So hopefully that chapter was good. He's, Mike is pretty good.
where do you live, sir?
Sharon, Mass.
How long have you lived in Sharon?
Long Sharon since 82.
And what do you do for work, sir?
I am the superintendent of public works for the town of Canton.
And how long have you held that position?
Superintendent of Public Works, Mr. Trotta. So this is going to be about snowplows, I do believe. At least that's my guess going in.
Superintendent of public works.
Since 2003.
And did you work for the town of Canton prior to 2003?
No.
Now, with regard to being the superintendent of public works, can you describe to the jury sort of what are your duties and responsibilities when it comes to that work?
Typical management duties of staffing, controlling, directing, working on the budget, working on scheduling, long-term scheduling, 5 to 10 years, capital planning, overall operations, the day-to-day operations, what it takes to maintain a water system, a sewer system, the road system.
Now, with reference to, I'd like to turn your attention back to late January, early February of 2022. At some point in early February, were you contacted by a trooper in regard to a blizzard that had happened the week before?
Yes.
And do you recall who that trooper was or how they contacted you?
I believe it was Michael Porter, and I believe the contact was by phone.
Michael Porter, but his name's Proctor. Unless there's a different one named Porter.
Now, with reference to that trooper, is that someone that you knew or you had spoken to before in any way?
No.
And prior to that date, did you know a John O'Keefe or Karen Reed or anybody?
No.
Conspiracy.
And as far as As far as anybody within an Albert family within the town of Canton, were you familiar with them? Did you know them at the time?
No.
Now,
Conspiracy.
when you were contacted in that early February of 2022, with regard to the blizzard the week before, what if anything, was the trooper asking you? What kind of information were they looking?
He wanted to know what the procedure was when we prepare and staff a snowstorm.
And if you could explain to the jury sort of what is the procedure, or what at that time, what was the procedure, and what was sort of the makeup of what Canton DPW would do with regard to a snowstorm?
Well, we have the town is divided up into, I believe, 29 plow routes, several main routes, and side routes. The routes are generally somewhere between 3 miles and 3.5 miles long. And we have 30, I think back then we had 39 pieces of our own and probably 30 something private plow trucks. We try very.
Oh, he's nervous. He is so nervous. This poor man. This poor man, he is terrified.
Hard to have 2 trucks on a route, but we generally don't get enough. So if we try to have a town truck on a route with a private plow on a route. The private plow is procured through a bid process. They have to have a contract. They have to have insurance, liability insurance, and they have to show that they pay their taxes to the state and that they have workers' comp. And they have a contract with the town. Then the operations manager is in charge of the on-site, boots on the ground, if you want to call it that. He'll assign the specific truck and the private contractor to a route. Generally, the day before, maybe 12, 18 hours before, the two of us talk. We try to schedule the overtime so that you're not going home at 3 o'clock and then you're getting woken up at 1 or 2 o'clock in the morning to come back. We like to schedule it so when the guys go home, they know when they're going to come back. To the best of our ability, that's what we'll do. We'll tell the contractors when they are expected. And generally, if we're plowing, it starts with a sanding operation. So we would have a sanding fleet, which is maybe a dozen trucks. They'll come in early, and then the rest of the public works people come in at a scheduled time.
And so there'd be about, and correct me if I'm wrong, there'd be about 30 some odd trucks that were sort of DPW trucks?
A few more. I'm not sure the exact number. It's probably 37 or 38 because that counts sidewalk plows too. So there may be, I think there's 3 sidewalk plows. So there's probably 34 or 35, we'll say, between medium-sized trucks and the big construction trucks.
That was sort of my next question. As far as the DPW trucks are concerned, do they vary in size, or what is sort of the range in size of the town?
They'll go from a pickup, 2-ton pickup, F-150 or F-250 Ford, if you're familiar with that, to a medium-duty 20,000 to 22,000 pound truck up to a large construction truck, which is generally 26, 28,000 pounds.
Now,
the large truck is a 6-wheel truck.
And as far as the other trucks, the private ones, those would sort of be subcontracted out through the bidding process. Is that correct?
Yes.
With the range, as far as the size of those trucks, would that be similar or something different?
If they are pickup trucks, or usually lighter pickup trucks, there may be a couple of front end loaders. There's probably, I don't think there's any big heavy duty trucks.
I think he's shaking from nerves. Some of his body language leaning way back, like putting his chin directly over his sternum, basically. He's trying to create distance. He's terrified.
But they're probably pickups, might be couple of Jeeps, pickups. Again, a medium duty like an F-350 or F-450 pickup. Those are Fords and loaders.
He's also old.
Now, with respect to questions or what you were asked about by the trooper, was there a specific sort of street or plow route that the trooper was inquiring about?
I believe he asked who was down, that's Fairview, or down in the Cedar Crest area, that's what we call it. I believe that's what he asked.
That's it. None of them did, other than, the pathologist, the cops, the, crime scene technician. But none of the Alberts signed up for this. The McCabe's, Higgins, none of the friends signed up for this. He didn't either, but he at least applied to work for the city.
Madam Mayor Pro.
Yes.
Judge looks tired.
I'm showing you a document, just look at that, look up when you finish.
Uh-oh.
Do you recognize that, sir?
Yes, sir.
And what do you recognize it to be?
This would be a plow plan for that day. It's a plow plan for the season, but it is particularly a plow plan for that storm of January 28th through January 29 of 2022.
Thank you, Mayor Pro Tem.
Yes.
I'm about to introduce in a minute the next exhibit.
Okay.
I have no objection.
Thank you.
I guess now that I see his name, it literally is Michael Prada, not Protter or something, Potter with a Boston accent. It's Prada. So, yeah. And yeah, I'm still hoping that, Grant's tweet from last week is true and that this is the only day of court this week. I'm hoping. We'll wait and see, because I don't believe things until I hear it straight from the horse's mouth. In this case, the judge is the horse. But I'm tired.
Charlie, when it comes to that form for you that's now been marked as Exhibit 109, just have a couple questions for you in regard to what's listed there. So with regard to the top of the page, there's a listing as far as 1/28/2022 Boulevard, 11 p.m. You see that?
Yes, sir.
And what does that mean, sir?
That means that the first group of workforce, which would be the Sanders, were scheduled to come in at 11 o'clock that night.
Now, as far as the next entry going across the top of the page has 1/29/2022, is that correct?
Yes,
And as far as what's listed as W&S/BM/REC at 2 a.m., what does that mean?
W and S would be what?
He said BM.
So BM would be building maintenance.
Oh,
REC would be the rec, and they are scheduled. That would be the balance of the Canton's workforce. They were scheduled to come in at 2 o'clock in the morning.
And at 2 a.m., would that be at the same sort of central location?
Yes, they
yeah,
would all-
here in Utah, especially those old Mustangs. Oh, the classic cars, they just got, the salted roads chewed them to pieces. Of course, the coastal salt will do that too. So really what you want is a car from Phoenix. That way it's just sun rot.
I'll report to the Bolivar Street garage. I think that address is 150 Bolivar Street.
Now, as far as the next listing, it states contractors at 3 a.m., is that correct?
Yes, sir.
And who's that referring to?
That would refer to all the private contractors that would be plowing that day. So again, it's staged.
It's sort of the last.
Private plowing contractors. Insert Law Talk with Mike's. Ma'am, are you a whore?
Sort of notation on the top of that, it indicates out at 5 a.m., 1/30/2022. Is that correct?
That would be when we completed and everybody went home.
Now, with reference to the Cedar Crest neighborhood or the area that would include Fairview Road, there's different route numbers that are assigned, is that correct?
Yes, sir.
And which route number would include that Fairview?
That would be Lower Cedar Crest number 11.
And from that, that would include Lower Cedar Crest, Kings, Fairview, and Spring, correct?
Yes.
And as far as the vehicle,
But see, Arizona's the best of it all, like I said, because it's dry, it's warm, no snow, no humidity. So the interiors rot, the paint fades, but it doesn't rust. The South, you still get the humidity, so you can get rust, just not the salted roads rust that we get. So
vehicles and the vehicle types that were assigned to that route pursuant to this list, what types were they and who was assigned to?
Truck 30, which would be a town of Canton truck. That's a 43 International. Brian Lochran would be the driver. The 43 International is a medium duty truck. The next up would be 7400 International.
I'd say Arizona is hell's asshole or Satan's asshole, except it's not humid enough. So
That would be the large construction truck. And there is an absolute, a by the yard 4x6, which is I believe that's a small 1-ton dump. That would have been the private contractor that was on the route with the city truck.
And so that truck 30, the 4300 International, is that a bigger truck or a smaller truck than the 1-ton?
Then the 1-ton, It's a larger truck. It's a like a 3 to 5 cubic yard truck, and the large truck is like an 8 to 10 cubic yard dump. It's a dump truck.
And as far as the height on that International, would that be, how much, would it be taller or shorter than say a 1-ton dump?
If you want, I would estimate that if you're sitting in the driver's seat of a car, you're probably 2.5 feet. When you're sitting in the driver's seat of a 1-ton, you're somewhere around 3 feet. When you're sitting in the driver's seat of this 4300, you're probably somewhere around 4 to 4.5 feet. And when you're sitting in the big construction truck, you're another 8 to 10 inches, 5 feet plus.
And when you're driving,
and this is important because the higher you are, the bigger your range of vision, the larger your perspective. So if you can see.
And the plow drivers are plowing the roads, excuse me. What, if any, sort of instructions are they given as far as how to first start plowing the roads when they first come upon sort of dropping the plows and going?
If we're in a plowable situation, which is kind of hard to define, it's generally when we feel that traffic is impeded or may not be able to safely get up and down the street. So that's probably anywhere around 2 inches. They're instructed, and we're expecting a heavy snow. They're instructed to plow the middle of the road, keep the middle of the road open. And as they make their way through the route, they're supposed to push back a little bit.
And, here in Salt Lake, since we're on a grid, basically the plow drivers have instructions. You do State Street, 7th East, 13th East, Foothill Drive, whatever their equivalents on the west side, you do those. You keep them clear. And, 21st South and 9th South and 5th South and sort of the big streets. Those are your priorities. And this is city plow drivers, not UDOT plows, which are doing the interstate. Then you have the second priorities. You've got, your 5th East, 9th East, 11th East, 15th, 20th, 21st, 23rd, up to the mountain. Those are your secondary. And then it's like Go to Harvard Ave, like when you can get to it next week. Although Harvard's enough of a steep hill that they might do that sooner just because it's really fucking steep. But side streets, it might take them 3 or 4 days to get to it in a big storm. You know, like I said, I live on a moderately busy street. We get multiple plow passes during the storm on our street. 7th East, which is 3 lanes all the way through the city, they get a fleet of plows, 3, maybe even 4 plows, you know, staggered, clearing the entire road every 5 minutes. So
If they try to clean a whole lane and then come back and do the lane again, generally they end up being in trouble and they can't keep up if it's a heavy snow. So they're instructed to plow the middle of the road to keep the roads open as much as they can before they do their finished cleanup.
and even on my street, like I said, we'll get multiple passes during the storm. They're doing the travel lanes, the bike lane and parking area. It might be another day before they get that cleared, just because, you know, priorities.
I may have one moment, Sean.
Yes.
Thank you, sir. No further questions.
All right, Mr. Yannetti?
Thank you, Your Honor. Good afternoon, Mr. Carter.
What's crazy is, you know, the Union Pacific Railroad, and they had their big boy locomotive, largest steam locomotive, and that was to climb basically between Ogden, Utah and Evanston, Wyoming, because that was the longest continued steep grade of railroad, and they needed the biggest, most powerful locomotive for that section. And that's going up Weber Canyon. That's where I-84 is, going out of Ogden. Whereas Parley's Canyon is like, whoa, way steeper. That's what I drive going to Park City. I-80, if you know.
Michael Proctor called you on February 3rd of 2022. Does that sound right?
It may be, I'm not sure of the date.
It was within days of the big snowstorm, correct?
Yes.
You knew that he was investigating the death of John O'Keefe, which had occurred on January 29th, correct?
I did not know that.
Have you heard that there was a police officer who was found dead on the lawn of another police officer in Canton?
Well, I knew, yes, I knew.
It's fairly big news at the
Yes.
And that's it, Jennifer Ray. Like, even I know, like, even though they're almost the same elevations, like Parley Summit and Donner Pass, like, I've got I've got family in the Bay Area. When they come to visit, it's like going to Park City, you're going to have a window most days. You plan your trip around Donner Pass. You plan your trip around those storms, period. Like, you might alter it by a week just to miss a storm.
Correct? And were you aware that that was why Michael Proctor was calling you related to that investigation?
After he called and identified himself, he said that is why he was calling.
Of course. Now, you spoke with him over the phone only, correct?
Yes.
He never came down to the DPW to meet you in person, correct?
Not me, no.
And he never asked to interview any of your employees.
And once again, this is all completely standard police investigation. Completely standard. So they never came to meet you? How suspicious. How very suspicious. Even though it's standard. Frame it as suspicious.
correct?
We may have discussed who was on that route and who plowed, but I'm not sure at that time if he had told me he was going to go talk to anybody else.
Oh, so it's your testimony
Oh,
that you may have told him the identity of the plow driver when you spoke with him on February 3rd over the phone.
I may have, but I am not positive.
You don't have a memory of him asking you who the plow driver was?
He asked, no, I don't have a memory of his exact questions.
But leaving aside the exact wording of his questions,
once again, did you hear the inflection in Yanetti's voice? Oh, there was absolutely nothing suspicious there. Absolutely nothing suspicious. But, oh, how suspicious.
it's fair to say you don't have a memory of him asking you who plowed Fairview Road on January 29th. Is that fair to say?
He asked me about, I believe he asked me about this plow list,
About the what? The plow list?
this plow list.
Right, but on the plow list, there's the name by the yard, correct?
Yes,
All right. There's also, to the left of that, an indication of the name of the plow driver, and it's just a first name and a last initial,
Yes.
correct?
yes,
It doesn't spell out the whole last name, does it?
no,
But you know the full last name, correct?
yes,
You have a limited number of employees, right? It's not a 1,000-person company, right?
yes,
All right. And you're well familiar that Brian L. is Brian Laughlin, right?
yes.
As you sit here today, do you have any memory of whether the name Brian Laughlin was brought up during that phone call with Michael Proctor?
I may have said to him, that's who BL was, but I believe I referred him to the operations manager to double check who was on plowing that day.
Okay. You say you may have mentioned the name Brian L. or Brian Laughlin, but again, I'm just trying to drill down on what your memory is. Do you have a memory one way or the other as to whether the name Brian Laughlin came up in that conversation?
If you are asking me, do I remember 100%? No.
Okay. In any case, Trooper Proctor, Michael Proctor, never asked to speak with Brian Laughlin when he talked to you over the phone,
He
correct?
did not ask me, no.
I'm going to allow the question and answer.
And how short was that phone?
That was hearsay. It was hearsay, but he had already answered. So rather than instructing the jury to disregard, it's who cares. But Brian Laughlin, a contractor, once again, Trooper Proctor never asked you at the city to talk to Brian Laughlin that day. How suspicious. I mean, presumably he went out and contacted Brian Laughlin independently because Brian Laughlin, contractor during snowstorms, not a city employee. He doesn't have a desk at the Public Works. He wouldn't be there like, oh yeah, let me transfer you to line 2. But how suspicious that Trooper Proctor didn't ask to immediately speak to Brian Laughlin when he was on the phone with you. So very suspicious. Can I reiterate for the jury how suspicious that is? Don't you, Mr. Prada, think that was suspicious? I mean, how suspicious? Do you think I've made my point yet about how ridiculous this how suspicious cross-examination is?
Call with Michael Proctor.
If I tell you, you're going to ask me, how do I know for sure? I would
Okay.
say a few minutes, whatever a few minutes is.
I'm going to accept that answer. And you would agree with me that after, and you, by the way, you were trying to be helpful, correct?
Yes,
After that couple of 3-minute phone conversation, you'll agree with me that Michael Proctor never followed up again with you personally.
that's a good question. I am not sure.
Okay. Well, I'd like to direct your attention to about a week and a half later, specifically the date of February 14th of 2022, which maybe you don't remember the precise date, but around that time period, you came into work around that time period, and you learned that a defense investigator named Paul Mikowski had left his business card for you with somebody on the DPW staff, correct?
Objection.
Sustained. Ask it differently.
Yes.
I do not,
Sir, that means you,
Oh.
don't answer that question. I think he's gonna ask him that's the appropriate one.
Yep, he's not a witness, not a professional witness. Sustained. So the answer to your question,
Okay?
Do you recall when you came into work receiving a business card from Paul Mikowski?
no,
Do you recall calling Paul Mikowski back?
no,
Do you recall speaking to any investigator from the defense at any point within a couple of weeks after you spoke to Trooper Proctor?
no,
Do you deny telling Paul Mikowski to call Bill Walsh?
Objection.
Sustained.
hearsay.
Who is Bill Walsh?
Billy Walsh is the operations manager for
Is he the highway department supervisor?
yes,
Did
Let him finish his answer. Don't cut him off, you turnip.
the name Bill Walsh ever come up in your conversation with Michael Proctor back on February 3rd?
Objection.
Did that name come up when you first spoke with Trooper Proctor?
again, I believe I mentioned it, but, I am not positive.
And
She just drove it to church on Sunday. Easy miles.
is it fair to say that the Canton DPW has their own plowing and sanding trucks?
Yes,
Does one of them in particular have a nickname?
if they do, I don't know what they are.
Have you heard one of the trucks being called Frankenstein?
Objection.
Sustained.
You don't drive the trucks, correct?
No, I do not.
But Brian Laughlin does?
Yes, he does.
And Brian Laughlin was driving the truck that plowed Fairview on January 29th of
Yes.
2022?
Objection.
Let me have a moment.
Yes, it'll stand. The answer will stand, Mr. Long.
I'll make that moment.
Presumably, if there is a truck called Frankenstein, presumably that's because it's received donations from so many old trucks being parted out that it's a Frankenstein monster. Presumably.
Sure. Can I approach
The witness or the sidebar?
the witness?
Yes.
Sorry.
Huh.
Do you have the reading classes as well?
Well, I have, yes,
Are you able to read the exhibit that you have in front of you?
yes.
Sure.
She looks worried
Thank you for
again.
another document, sir. And I would ask if you would compare that document with the document you have in front of you and tell the jury if it's the same document or not.
It appears to be,
Does it appear to be identical?
yes.
I will take the one back that does not have the exhibit sticker on it. Thank you, sir. And I have no further questions. Thank you.
Any follow-up, Mr. Lally?
No, Your Honor, but may I just retrieve the exhibit?
Yes. All right, Mr. Trotto, you are all set, sir. Thank you very much.
All right.
So, presumably, not asking him questions about the exhibit, the defense just needed the exhibit verified as one he made, so that presumably the next witness is going to be the plow driver or the supervisor, whoever he just asked about. And that way they can show them the exhibit. It's already been verified by Trotta. So I think
Yeah,
one
we have a
more,
witness here, Mr. Lally.
Yes, Your Honor.
one
Okay,
more
next witness,
witness.
please.
Your Honor, the Commonwealth call Mr. Louis Jutras to the stand.
Oh, that's terrible. That's terrible. It should be Snowgrew or Snowgoo, Grogu, because it's not Baby Yoda, it's Grogu. Unless, of course, they named it before Grogu was revealed. But in that case, his name was the Child or Kid.
Raise your right hand. Tell the truth, the evidence given in the court during the case now here to the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Take a seat.
All right, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Louis Jutras, Jutras.
And where do you live, sir?
Stoughton, Massachusetts.
And how long have you lived in Stoughton?
About 23 years.
And what is it that you do for work, sir?
I work for the town of Canton. I'm the manager of the Information Systems Division of the Finance Department.
And how long have you been
I'm
doing
sorry,
that?
what was the last part?
Of the Finance Department.
Thank you.
And sir, how long have you held that position?
Almost 25 years.
Now,
Who wants a finance egghead on the stand? Ugh.
if you could explain to the jury, just as far as your job is concerned, what does that relate to, or what is it that you do as a director of professional service?
Sure. So my responsibilities are for the municipal departments and all the technology associated with that.
And does that include everything sort of from cell phones to GPS in town vehicles to security systems, things of that nature?
Yes.
Now, with reference to your department, how many people work in your department?
There's 3 of us in total, myself and 2 others.
You essentially supervise the other 2 people as well?
Yes.
Now, at some point,
So GPS on town vehicles, presumably then they can prove whether a plow had gone down Fairview Road or not at certain times. As long as it's not a contractor vehicle, as long as it's a city vehicle. So, yeah, exactly. This guy has 2 legs. He's an imposter. He can't be a finance person. And he's also not on trial for murder, because, you know, those are the 2 finance people here.
if I could turn your attention to around the time of January 29th, 2022, some point after that, did someone from law enforcement or from a police department reach out to you in regard to security cameras or camera systems within the town?
Yes, I received a notification from the Lieutenant Gallagher that there was a motor vehicle incident in town, that the state police would be looking for some video footage.
And so you received an initial notification from Lieutenant Gallagher telling you that the state police will be reaching out looking for video.
Correct.
And at some point shortly after that, did you receive any sort of, did anybody from the state police reach you?
Yes. Trooper Dunn reached out. We had a phone conversation. And we had email correspondence relative to dates and times. We had pulled some.
So is this video footage from the plows, from vehicles like dash cam? Is this surveillance at City Hall? Police station? There's multiple options. Once again, I haven't seen it. I don't know until I watch it here with you guys. So this is me in real time as a juror would, trying to suss it out. There is that. Cameras on street poles. There is that. I mean, hell, when in the winter when I drive up to Park City, I log on to the UDOT website and look at the traffic cams on I-80 to see. So the weather's fine at my house. What is it at Parley Summit? When I tried to make it up to watch Gwyneth Paltrow testify, when I looked, the road was clear. By the time I was on there, by the time I hit the road, it was a nightmare because it changes fast in the mountains.
Footage from one site in Pequiside Farm that was put together. And then after that, there was a request for anything facing Washington Street, either from Town Hall or from the library.
And so as far as what was relayed to you by Trooper Dunn, what was sort of the description or what was it that you, were they asking just specifically timeframes, or did you get any other information as far as what you were looking?
From what I recall, there were 2 different timeframes, between 12 and 1, and then between 5 and 6.
See, I think I've heard claims, prosecutor claims that, a plow hadn't been down until after Johnny was found, and others claiming, the plow had, or, when it had, or whatever. It's hard to know. But then, even then, it's like, well, if a plow went by at 3, would Johnny have even been visible? If it went at 5, was he visible? If it went at 1, was he visible? So the timing of the plow could be relevant.
That was in our discussion and correspondence relative to Town Hall.
And just to be clear, that's from 12 a.m. to 1 a.m. and then 5 a.m. to 6 a.m.?
Correct.
Now, as far as the Equiside Farm, describe to the jury sort of what kind of location that is, or what kind of town property it is, and where it is in relation to the town.
Yes, so the physical area is off of Pleasant Street, which intersects with Washington Street, closest to Dedham Street and the police department. That's a large area, big white house, and we have cameras that face the entrance, the street, and the surrounding building.
As far as the coverage from those cameras, you've had occasion on this occasion or prior occasions or subsequent occasions to look at sort of the view that the camera gets from Equiside Farm?
Yes, yeah, we have a straight shot down from the building, down the entrance driveway, right to the street. The other...
We'll all bolt the delete laws security cameras to our heads, the visors.
Cameras that are around there. There's a couple of doorbell type cameras that physically focus on specific sections. And then other ones cover the general grounds around the building and the backside.
All right. So can I interrupt for a minute, sir? Could you please spell the name of the farm?
Yep. Pequiside. Pequiside.
Thank you.
And sir, Mr. Jutras, is it fair to say that the Pequiside Farm cameras cover more of the property and less of the street out in front? Is that correct?
Yes.
Now, as far as that was the initial request was in regard to Pequiside, is that correct?
Correct.
And so the subsequent request, what was that in regards to?
That was for anything town hall or library that physically faced Washington Street.
And so the town hall and the library, sort of where are they situated in relation to each other and in relation to Washington?
Yep. So they physically abut on either side of Washington Street, right at the intersection of Sherman. They are diagonal to each other.
Now, as far as the recording devices or the cameras on town buildings within the town of Canton, are those, are they sort of uniform or does it vary from location to location or vary within the location?
The physical model of the recorder, as far as the manufacturer, that is the same that we have across 15 different sites. The types of cameras do change, interior, exterior, doorbell, things like that. But all the actual recording units are of the same manufacturer, just different sizes and models.
And as far as the town hall and the public library cameras, as far as the exterior cameras at least, they face in that area of Washington Street and actually capture portions of Washington Street?
Yes. Yep.
What was the cross street? Washington and Sherman, did he say? I'm getting pretty fast at pulling up Canton on Google Maps. Scroll right to it. And not only that, but did his daughter go hot tubbing with firefighters in Maine? We need to know. We need to know these things.
Now, as far as the cameras are concerned, particularly the exterior cameras that we're talking about as far as the library and the town hall, how are they sort of set up to record? Is it one continuous recording? Are they motion activated? How are they?
Yes, the cameras, based on size and so on, they are all set up for motion in pretty much all of our locations.
And as far as from your review of Those cameras, is there any sort of indication on?
And Sherman, for those of you who haven't pulled up the map on your phones, Sherman is the next street to the north along Washington Street from Maple Street. So basically, you go to Chris Albert's house, his new condo. Next, somewhat major street is Sherman. So that's where we are. So I could pull up the map, but I don't want to mess with it. But I looked it up for you. So, 5-6 minute walk from the waterfall along Washington Street. 1 minute probably from Chris Albert's condo.
On the footage as far as date and timestamp or anything like that?
No.
Yes, we usually have it in one of the corners or someplace along when we have the video saved off and exported.
And when you were able to pull the video that the troopers were requesting, the date and timestamp
True.
to those videos, was that accurate as to what the date and timestamp actually was at the time that it's recording?
Yes, I would believe so.
You would believe so? Interesting.
And so those date and timestamps, you know where they come from?
The system is linked to
From someone who knows how to program a VCR. Einstein himself.
a time server, which is remote and is used from the national standards.
Now, as far as the video is concerned from those, they're motion activated, but how far back
Never
do
for
they
me.
go as far as how many days pass before, does it get sort of overwritten at some point?
Yes, depending on the site, most of them, because of the motion activated, because of various request types and so on, and the number of the cameras, we usually try to get about 30 days. There are some that go longer because the site is or isn't used as much. And then there are other ones where, specifically with the library, they only requested to have a maximum of 30 days on that device.
Their power knows no bounds, Sinclair. Ooh.
And so when you received this request from the troopers, that was well within 30 days.
For the last request.
Now, as far as the video that you exported, well, let me ask you this. As far as when you were asked to retrieve that video, can you explain sort of mechanically the process, how you got that video and how you delivered that?
Yeah, so specifically for the town and the library one, that again, timeframe provided, using the manufacturer's software product, doing the search, picking the...
I'd assume if they have cameras on the plows, just like civilian dash cams as opposed to police dash cams, basically you turn on the vehicle, it records. You turn it off, it stops. And at some point, it cycles through the memory.
The cameras that are facing the Washington Street side, and then having the time frame and exporting that out. That becomes, depending on the size of it, either a full
Now he is.
executable that can just be opened and viewed, or a combination of files that has a player with it. And then based on the fact that we had already put videos together and that material was picked up, I had sent a file share link for that information.
You had sent that file share link to Trooper Dunn, is that correct?
Correct.
Now, as far as the video that you reviewed, were you sort of parsing, or were you looking for specific areas, or did you just sort of take the whole time period requested and send that off?
As far as I recall, it was the whole time frame, just because we only have 2 cameras or so that physically cover the area in question.
Exactly.
And he had 2 separate hours in question as well. So they were able to be exported and sent.
All right. Well, we're getting close to the end, but you may have noticed me doing the potty dance. So I'm going to take a brief break. I'll be right back and we'll finish up strong. So behave. Gray Duck, you're in charge. All right, I'm back. I'm back. Make sure you all behaved. All right, good job, Gray Duck. Good job. You are, yeah. But yeah, if having one leg teaches you anything, frankly, the number one lesson is how, the actual maximum bladder capacity. Because, if it's just a matter of hopping up and running to the bathroom, no big deal. But when your mind is like, do I really want to pick up my crutches or put on my leg or whatever? Do I really want to stand up and go? So you learn when it's urgent and when you're like, in my bipedal life, I would have got up now. I've got hours to go still. And, that's good training for when you do insanely long live streams. Because, apparently the limit is about 7 hours and 15 minutes. And by then, I'm like, nope. Time to get up and go. Literally. So, and yes, Pop-Tarts. God, it's been a long time since I've had a Pop-Tart. Strawberry is the only acceptable flavor, frankly. And yeah. A better question, and it's been even longer since I've had them. Like, do you prefer your Twinkies frozen or unfrozen? Because as a kid, we'd always have Twinkies in the house, and my mom would put them in the freezer. And so that was kind of the standard for me, was frozen Twinkies. Except, like I said, it's been 25 years. And I could, but I'm not that committed. And there are too many inappropriate jokes that I could make. Too many inappropriate jokes. And yeah. So let's get back to the video instead.
Now, as far as this particular video, this is video only, correct? There's no audio that's attached to these cameras?
Correct, no audio.
Now, as far as access to these cameras and the footage within the cameras, who, if anyone besides yourself?
And that's the problem, Grey Duck, is I was going to kink shame other people, but it would have broken a different rule of my channel, so couldn't do it.
So would have access to remove any sort of footage from the cameras?
No one.
It depends.
Now, sir, before we get to the camera footage specifically, I just want to ask you about another area. In relation to also within sort of the ambit of your duties and responsibilities would include GPS on town trucks, correct?
Yes, Public Works has a setup via their radios for GPS information.
And so with regard to that, specifically the DVW trucks, what, if any, information did you receive from anyone at the DVW in relation to those GPS devices within the trucks shortly after the snowstorm from the 28th and the 29th of January?
Yep. So on February 1st, I received notification from the operations manager that the GPS information was not working.
And so you received information after the snowstorm that it wasn't working during the snowstorm, is that correct?
Correct.
Conspiracy!
And as far as that, is that...
Who tampered with the GPS? Conspiracy, conspiracy, conspiracy! Ah!
As far as GPS sort of going down in the DVW trucks, is that abnormal, or how often would that occur?
Yes, it happens several times throughout the year for various reasons. They have a radio repeater. It's connected through a network. It runs software on a server that we have in-house. Server's rebooted, network goes down, things that, change for various reasons, and we need to reestablish connection to whatever recorder it is for that repeater, and then the information is then picked up.
Now, taking you back to the
Well, yeah, they waited until the snowstorm.
Canton Public Library video that you provided to the trooper, were you told anything about sort of any type of vehicle or anything to be looking for within that particular video timeframe that they were asking about?
Not that I recall.
Did you recall ever actually watching the video yourself as far as confirming sort of what it was?
Yes, I mean, I watched it from the time frame to see that we had information, watched it just to move forward to the end to make sure there was information, and when the recording, was physically available. But what was in it, no.
And so I'm assuming, once again, what they're doing is he's, as the custodian of records, he is laying the foundation to admit this video taken at the Pissaquah Farms or whatever, Pequasset Farm on the corner of Sherman and Washington. And presumably that video camera, once he gets it into evidence, it's going to be Trooper Proctor who testifies about it, presumably, and we're going to be looking for Karen Reed driving by at a certain time. We're going to be looking for a black Lexus SUV at 1 in the morning, 12:45, whatever. And the thing is, pull my little map back up. Let's see. What street did John live on? They headed to Pleasant Street. I can't remember John's exact address, but presumably to get from Fairview to John's house, you drive Washington, turn on Sherman Street, continue to John's house, because John's, Fairview's on the west side of town. John lived east, other side of Washington. So presumably they are laying the foundation for the static security camera showing what time Karen is headed there. So gonna push play and Google John's actual address and get back to you.
May I approach?
Yes.
So I'm showing you this, just ask you to, as far as that video from the Canton Public Library, you've seen that video subsequently, is that correct?
This disc with the wording on it?
Yes.
No, I have not seen this.
Not that specific disc, I'm sorry, sir, but the footage, have you been shown that particular video footage, or did you review that footage before you gave it to the troopers?
This is not mine to the trooper.
Whoopsie daisy. Whoopsie daisy. And that's the thing. You can make everything suspicious if you really want to. And you know what I find that? Suspicious. And that's it. You had one job. One job. Okay, 1 Meadows Ave. That's where he lived. Let's put that into the old Google. And 1 Meadows Ave is right off of Pleasant Street. Well, between Sherman and Pleasant Street. So yeah, literally, you get onto Washington Street as you're on your way from Fairview. Head north, right past Chris Albert's house, condo. Very next street, Sherman Street, you turn right. And right being east. You continue along.
All right, so you both agree that this will be the next.
You continue along Sherman Street, and then you turn right, meaning south, on Pleasant Street, past Canterbury Drive, and right there on the corner is Meadows Ave. So, presumably, it is Karen driving past at 1 in the morning. They're trying to show. So,
Next exhibit.
Yes. Yes, ma'am.
Hand that to Madam Clerk sidewalk.
maybe we should start, instead of the everything suspicious channel, we should start the conspiracy jazz hands channel. Conspiracy jazz hands. That's our channel. And what have you missed? I don't know. Either way, you may have missed me taking my potty break, but basically they're trying to lay the foundation for the CD of the video of John driving past a city-owned security camera, or Karen driving past on the way to John's house that night. But there was a little whoopsie daisy in identifying the CD, so that's where we are right now. Oh.
All right, so the parties agree that this is the next exhibit, correct?
Yeah. And presumably, let me back up too. Let me back up. So, I don't know where the McCabe's live, but this could also be Allie McCabe dropping Colin Albert off, since it's right by the condo. So it might not just be, because they gave a range, it might not just be Karen driving by. This could be Colin getting dropped off by Allie McCabe. And Allie McCabe not driving that way again at 360 miles an hour. You know, my quick mental math due to the Life 360 nonsense.
Yes, sir. Yes, sir.
Thanks.
Your Honor, with the court's permission, I would just ask to briefly, publish portions from those.
Hold on. Yeah, Ma.
Oh,
I'm sorry.
she's probably hot tubbed
Yes.
with a Canton
Yes.
police dog.
I was going, if I could have the first video portion from 12 a.m. to 1 a.m. Mr. Jutris, what's up on the screen? What's up on the screen?
Yes, I do.
And as far as the view from this camera, this is from the library, is that correct?
Correct.
And so as far as what we're looking at here, this is the view from the camera as you served it on the security camera and as you provided it, correct?
Yes, sir.
I'm sorry, sir, do you have is there a laser pointer up on the desk in front of you?
Yes, sir.
Are you familiar with this area as far as the area of Canton?
Yes, yes. Town hall is,
And yes, we are on 1 1/4 speed, so bear that in mind as you see things drive by.
right across the street.
I'm sorry, I stepped right over your words when you were saying that.
Yeah, so town hall is right across the street. And the intersection here is at Sherman, and this is Washington along the street that you see.
So Washington sort of runs parallel with the street, and then Sherman is the street that appears intersected with Washington
Correct.
in the area of the town.
Yes, sir.
Okay, so if you could take that down and just put up the other flags. Again, sir, what's up on the screen? Do you recognize that?
Yes.
Is this essentially the video that you provided to the troopers, or retrieved from the Canton Town Library from 5 a.m. to 6 a.m. later on that day, January 20th?
Yes, sir.
And the orientation as far as Washington Street, Sherman Street, that's all the same.
So he said this is Town Hall kitty corner, or did he say this was Town Hall? I think it was Town Hall is kitty corner. So Chris Albert lives basically, you go to this QR code and follow it to the bottom of your screen, off the bottom of your screen, bottom left. So just for reference, where Chris and Colin Albert live.
In reference to the earlier, the camera has moved.
Correct.
Was there one saliva source or two?
I may have one moment, Your Honor.
Yes.
Thank you very much, sir. I have no further questions, Your Honor.
Okay.
And once again, no further questions, because that was laying the foundation to get the exhibit admitted. Trooper Proctor or someone, digital forensic analyst or whatever, I don't care, is going to discuss what's on the video. And yeah, so whose car was that? No idea. Absolutely no idea. The timestamp was midnight, which I believe is the start time for the video clips requested. So I think it was just a random car at midnight. Because once again, the only purpose for this witness was to get that video admitted. They played that little clip to say, so this is the clip that you pulled, right? Yes, good, thank you, no further questions. When the actual investigator testifies, they'll play the clip at certain time periods, like 12:25 to show Colin Albert getting dropped off by Allie McCabe, or 12:45 to see Karen speeding by with a broken taillight, turning onto Sherman Street, going to John's house. Gray Duck, you were in Canton that night? Oh, was Chloe in your car with you?
Good afternoon, Mr. Hughes.
Good afternoon, Jay.
Exactly.
So confirming the state police, when they contacted you, asked for 2 hours of video footage, right? Between 12 and 1 a.m. on January 29th and between 5 and 6 a.m. on January 29th, correct?
Yes, sir.
You pulled that video footage, or at least arranged for it to be pulled for the state police, correct?
Yes.
And I believe your testimony was that you checked the beginning time and the ending time to make sure that you had the right time periods for those 2 hours, correct?
Yes.
But you did not sit down and watch 1 hour of snow falling and or cars driving by the public library, correct?
That is correct.
Did
I
you do
did
that
not.
for between 12 and 1 or between 5 and 6?
Correct. I did not.
Almost like his job was to pull the video, not watch the video and analyze the video. Once again, how suspicious. You didn't watch all 2 hours you pulled? What do we pay you for? How very suspicious of you. Only doing what you were asked and nothing more. You're in on the conspiracy too, aren't you? Otherwise, you would have watched the full video. Of course, if you had watched the whole video, the whole 2 hours, well, why did you watch all 2 hours? You were only asked to pull the video. Everything's suspicious. Everything has that suspicious inflection to his voice. Because, yeah, did he check if John had a broken foot? Did he check if there was a hickey? Did he check for dog saliva?
And at the time that you provided the video footage to the state police, did you know whether or not there was any missing footage within those 2 hours?
No. Because again, I did not play every single second of the video.
Understood. It's fair to say, and you're certain, that you did not cut out any of the video footage in those 2 time periods, correct?
Correct. It's motion activated. That's the only piece.
You provided the state police with the raw footage as it existed in your possession at that time, correct?
Yes.
And at that time, you knew that the raw footage was only saved for between 30 and 60 days?
That one is less than 30, yes.
Right. Now, as of early February, when you were dealing with the state police, you knew that Karen Reed had been arrested and charged in court, correct?
I do not recall if I had that information.
You knew that there had been a police officer found dead on the lawn of another police officer in Canton?
At that time in February, I believe so.
And that likely would have been discussed when the state police called you?
I do not recall the conversation other than asking for video footage for Washington Street.
And I'm sorry, sir, if you could just keep if I can't hear you, I guarantee you that these.
Funny enough, the police don't have to give them a reason. They call and say, hey, we need between this time and this time. When can you have it ready? They don't have to say, so there's been a death and we think you might have, it's no. They say, give us this to this. That's all they have to do. But once again, they didn't give you all the details and they didn't break down the case for you. How suspicious.
Last jurors can't hear you. Could you repeat that last question?
Yep. Again, when in the conversation with it, we had the dates and the timeframes, and anything else relative to it, I do not recall specific with conversation.
Okay. So you don't have a memory of why you were being asked for this?
Correct. I know it was for a motor vehicle accident. Who and what, I do not recall if that was ever mentioned specifically.
Okay. And you would agree with me that as the IT director, you had the ability, if you wanted to download the footage onto some hard drive to preserve it, if you wanted to do that?
Yes.
Did any state trooper ever ask you to
And
download?
why would I if there isn't a request to preserve it? There's a reason it's on a 30 to 60 day loop. Because you don't just preserve it for the hell of it.
And preserve that footage so that it would exist longer than that 30 to 60 day period?
No.
And so it's fair to say you did not do that, correct?
Correct.
You complied with what they asked you to do.
Yes.
Now, skipping ahead to April 6th of 2023.
And once again, so you complied with what they asked you to do. They, the conspirators. As opposed to, so you have this standard practice, you have it on this timed loop. Your standard practice isn't to say, well, I'm going to save this month just in case. I'm going to save this night just in case without a request to preserve. So I'm going to go outside of my standard practices just in case. How suspicious you didn't do that. He's driving me nuts. All this innuendo.
You're contacted by Michael Proctor, a state trooper investigating this matter, correct?
I do not recall.
Do you recall Michael Proctor asking you to provide to the defense in this case the same raw footage you had previously provided to the state police?
No.
And you don't recall telling him that you couldn't do that because after 30 to 60 days, footage is gone, correct?
I had a phone call with what I thought was Trooper Dunn asking for another copy of the data and telling him that I did not have it and I couldn't recreate it.
I see. Oh, so you assume
if it was Proctor, but no, I thought I was speaking with Trooper Dunn.
Trooper Dunn was the name that you remembered from February.
Correct. That was the first interaction I had.
And when they mentioned state police, you assumed it was the same state police trooper, correct?
Yes.
It's fair to say that once you shared the footage with the state police in February of 2022, you didn't control what they did with it after that, correct?
Correct.
And you have no personal knowledge about how they preserved it or didn't.
Oh, so you didn't keep a copy of it just to make sure those sneaky, conspiring police officers didn't do just a little cheeky delete there. How suspicious of you not to foresee their conspiracy, which makes you a co-conspirator.
Correct?
I'll allow it. Do you have any idea?
No.
And one last question. You cannot testify about whether any video was removed from the footage after you provided it, correct?
Objection.
Sustained.
Thank you.
No redirect, Your Honor.
All right, sir, you are all set. You had a witness.
Yeah.
I do not, Your Honor, no. May we approach this on?
Well, and yeah, aiding and abetting by doing his job. How dare he? How dare he aid and abet those obscene, disgusting, despicable pigs investigating a murder? How dare he aid them? Unbelievable. Absolutely unbelievable. How dare he not foresee the conspiracy? How dare he not make multiple copies to sell to Dateline, to sell to Turtle Boy? It's ugh. So, but that's the end of testimony today. Basically, once they finish this bench conference, we're waiting to see what the instructions are, what the rest of the week looks like. And, you know, yeah. Once again, if it is a conspiracy, it is the stupidest conspiracy. That's what makes it so hard to believe.
So
You are unmuted.
in fairness, I didn't tell the lawyers that I was hoping to go until 4:30 today. And I understand, as sometimes happens with law enforcement witnesses, they get called away. So that's it for today. Now, next week, I would like to go as much as we possibly can on the days that we're here for full days. So Monday is a full day. I would like to go until 4:30 if everybody can, with the shortened lunch hour. Tuesday, we're not in session. Wednesday is a full day again. We'll go right till 4:30 with a shortened lunch. Thursday is a half day, maybe even closer to 12. And Friday, we will not be in session. So those are dates that we gave you before. So we will get as much done as we possibly can during that period.
All right. So
Those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. You've got a few days off. Just disregard this case. Don't think about it. Leave everything here and have a great few days. We'll see you next month.
All rise for the court, please.
all right. So in spite of any faults, Grant was at least correct about his tweet last week saying today's the only day of court this week. Of course, he didn't say it would be a full day of court. Damn you, Grant. And for other reasons too, but yeah. Can't imagine how much longer we'd be if it hadn't been a child witness that we zoomed through. Let's see if she instructs the parties further, excuse me. Because once the jury's gone, there might be a little more. But apparently she didn't tell the parties either, so we can't fully blame Grant because, you know, if the attorneys weren't informed it was a full day, we weren't either. And I mean, that's how I get out of things. I show a little leg and, you know, it's like that long, really little. But yeah, so what was that? 4 days next week. So court Monday, no court Tuesday, and then court Wednesday, Thursday, Friday ish. Something like that. So either way, it certainly is convenient not having court on Friday since I, you know, was very kindly interrupted by my cousin in a stream last week to give a very late invitation to his wedding for Friday. So I'm not complaining, much as I love hanging out with you guys. And oh, and actually, you know, going to my cousin's wedding on Friday that's on my dad's side. On my mom's side, the ones we hung out with yesterday for Memorial Day, my cousin's son apparently is engaged, which makes me feel ancient, because how can my cousin have a 20 or 21-year-old son? That's not allowed. It's not allowed. And yeah, no Jackie Poo for her. So sad. Not even DUI guy. Maybe she was able to make kissy faces at Turtle Boy if he was, well, doesn't look like he's there. He might have left already. But no kissy faces at Turtle Boy. And yeah. And that's the thing, Luna Nights. It's like, I don't feel 40 most of the time. Of course, it's time for me to hack the beard away, mostly, just because when it gets long, it's like, oh, there's a lot of blonde in the beard. Not a lot in my hair, but a lot of blonde in the beard. And that's when I'm reminded that I'm 40. So, we're gonna get any.
All rise, court stands adjourned.
All right. So apparently we won't get any instructions. Everything was done in front of the jury, and that is perfectly fine. And I mean, if I'm getting paid $800 an hour, I can take a little scratch, behind the ears and, pat on my head, pat on my ass, I'll let you do a lot of things for $800 an hour. A lot of other things would take a whole hell of a lot more money, but, I don't kink shame. So that said, it's been a much longer day than I expected. But, the longer the stream, the snarkier I get. So maybe that's a good thing. But I also get hungry. So it being 9 o'clock means it's way past dinner time. So yeah, do all the YouTubey things, like, share, subscribe, bribe your friends and family, yada yada, you know the drill. Unless you haven't been here before, then you don't know to bribe your friends and family to do the same. But at the very least, I will see you on Monday for a very long day of court once again. If I don't see you earlier, to catch up on some other thing we've, shoved off to the side. So, yeah. Either way, thanks for joining me. Bye-bye.